My lords.
GM ಇಲ್ಲೆಲ್ಲಿ ಬರುತ್ತೆ? 8ನೇ ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ಸರ್.
My lord, may I make a mention, my lord?
Give it. It will come, give it. Fresh. Pending matter is it? It will come on Wednesday, give it. Give Wednesday it will come.
My lord, extension.
My lord,
ಏನದು? Withdrawal. Yes.
My lord, extension of parole.
Give it. Extension parole ಎಲ್ಲ
my
ಕೊಡಿ.
lord,
ಇವತ್ತ ಯಾವತ್ತು ಎಂಡ್ ಆಗ್ತಿರೋದು?
Tomorrow date of surrender.
ಸರಿ 2:30.
My lord, may I make a mention, my lord? It's a matter, GM-CPC matter, wherein I had filed a caveat. My caveat was not noted despite it being recorded.
ಏನಾಗಿದೆ ಮೇಡಮ್?
ಅದು interim order grant ಆಗಿದೆ.
ಯಾವಾಗ?
Just before vacation. I moved it just before vacation.
Vacating stay ಹಾಕಿದ್ದೀರಾ?
ಹೌದು ಸ್ವಾಮಿ. May I request for Wednesday, my lord?
It will come only on Wednesday.
Last time when I had moved the matter, despite everything, the pending branch had not noted the date.
Don't worry about it. Give it.
May I request for Wednesday?
All vacating stay applications and posting it on Wednesday.
Maintenance ಗೆ stay ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, amount ಕೊಡ್ತಿಲ್ಲ husband and wife.
GMCPC.
Lord, sir, for 2:30.
Pending, fresh.
Pending ಮೇಲೆ.
Wednesday or Friday.
My lord,
ಏನ್ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಿಲ್ಲ ಕೊಡಿ. ಇವತ್ತು 2:30 ಗೆ ಯಾವ GMCPC ತಗೊಳಲ್ಲ.
my lord,
ಕೊಟ್ಬಿಡಿ.
my lord, 2:30 GM-CPC, my lord.
ಅಯ್ಯೋ ಮತ್ತೆ ಈ ಅದೇ ರಾಗ ಆಡ್ತಾ ಇದಿರಲ್ಲ. GMCPC ಲೋ ಅದೇನಾ ಥರ್ಡ್ ಮೆಂಬರ್ ಕೊಡಿ. ಎಲ್ಲ ಒಂದು ಕೊಡಿ. ಟ್ಯೂಸ್ಡೇ or Thursday it will come. ಎಲ್ಲ ವಿಡಿಯೋ ಎಲ್ಲೇ ಬರ್ತಾ ಇದೆ ಎಲ್ಲ. Give all the memos.
Coordinate bench has stayed by TV proceedings. Truth or dare case.
ನೆನ್ನೆದಾಗ್ಲೇ ಇವತ್ತು ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ. Wait till pronouncement.
My lord,
All right. It won't come here, so wait till pronouncement.
GM-CPC for vacating stay, my lord.
Wednesday.
One submission, my lord. One day, sir. Last Monday I moved the matter.
ಪರವಾಗಿಲ್ಲ. Vacating stay ಕೊಡಿ.
10th ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೊಟ್ಟು ಇದು
ಏನ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಇಷ್ಟೇ ಆಗಿದೆಯಲ್ಲ ಈಗ.
What happened, my lord? They filed a false dispute petition against me. I filed a suit against them. Then the suit, my lord, the dispute proceedings are stayed. Because of that, they filed a dispute based on the created document.
ಏನಾಗಲ್ಲ, ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಆಗಲ್ಲ ಕೊಡಿ.
ಎವಿಡೆನ್ಸ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಗೆ ಸ್ಟೇ ಇದೆ ಅಂದ್ಬಿಟ್ಟು ಅಲ್ಲಿ ನಮಗೆ ಟೈಮ್ ಕೊಡ್ತಿಲ್ಲ. ಹೈಕೋರ್ಟ್ ಸ್ಟೇ ಇದೆ, ಎವಿಡೆನ್ಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ.
Yes, give it. ನಾಳೆಗೆ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
My lord, appearing for petitioner in this case, it's an emergent matter because
ಎಮರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್.
ಯಾಕೆ demolition ಆಗಕ್ಕೆ execution ಹಾಕಿದ್ದಾರೆ.
ಯಾವ್ದ್ರಲ್ಲಿ ಏನ್ ಬಿಡಿಯನ್ನ?
Not ಬಿಡಿಯರು, ಮಂಗಳೂರು ಬೆಂಚ್.
ಏನ್ GM ಆ ಕೋರ್ಟ್ ಹೋಗಿ ಸರ್.
ಹೌದು, much obliged.
GM ಕೋರ್ಟ್ ಹೋಗಿ.
My lords, for 2:30, my lords.
School management, they got an injunction against the petitioner who was interfering with the case. He filed a application for the vacation judgment.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ವೆಡ್ನೆಸ್ಡೇ.
What are the 9th the school is opening.
ಆಯ್ತು ಕೊಡಿ ಮೇಡಮ್. ಅದು ಸ್ಕೂಲ್ ದೇನ ತಗೊಳ್ಳಿ. ಎಸ್. ಹಾ ಅಯ್ಯೋ ಕೊಡಿ ಸರ್. GMCPC ಎಲ್ಲ ಕೊಡಿ. GMCPC ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. Give everything.
GM-CPC itself. I require this.
GMCPC ಮೆಮೊ ಎಲ್ಲ ಕೊಡಿ.
2:30 PM.
2:30 ಗೆ ಏನಿಲ್ಲ.
ಯಾಕೆ demolition ಮಾಡಿದ execution process. I
2:30.
already filed IA.
Monday.
That has been
ಮಂಡೇ ಸರ್.
not much of.
ನಿಮ್ದು ಮಂಡೇ ಅಲ್ಲ ಏನು ಬಿಲ್ಡಿಂಗ್ ಏನು? ಮಂಡೇ.
My lords, vacating stay, execution proceedings has been stranded since December. This vacating stay has not been posted. Next following week.
Wednesday or next Wednesday?
Next Wednesday.
ಆಯ್ತು.
My lords,
ಯಾಕೆ ಡೆಲ್ಲಿನ ಕರೆಸ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ.
my lord, WP GM-CPC case, the case was supposed to be listed today.
Supposed to be?
No, actually, the court had directed that it has to be listed today, but it is not listed, my lord.
ಬರುತ್ತೆ ಕೊಡಿ. ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಾ?
A memo on
You come according to seniority, don't.
My lords, for 2:30, because my lords, apartment owner association election is on Sunday. The lordships are directed the matter to be listed today, my lords. For I don't know for what reason it has not been listed. Election because trial court refused to grant interim order and moved for a writ petition. Considering this, your lordship are directed for the matter to be listed today. The election is on Sunday, my lords.
2:30.
2:30.
Delivery warrant is issued in execution.
Monday.
Please.
Civil division petition.
ಕೊಡಿ ಸರ್. Give all the memos.
It's for one
All
matter for
GMCPC
Tuesday, my
for
lord.
withdrawal, my lords.
Suit filed against a dead person. I have filed an application. There is a stay.
Fresh matter. Stay ಇದೆಯಾ?
stay ಇದೆ ಅದಕ್ಕೋಸ್ಕರ. That is why I am.
ಕೊಡಿ, not Tuesday.
No.
Either Monday, Wednesday or Friday.
Please, please, Monday. I'll give
Fresh
it.
matter, my lord. Tuesday.
Yeah, BDN.
BW, yes, my lord.
ಎಲ್ಲೇ?
BWS.
Tuesday. Yes.
Interim application pending.
You what do you give?
One CRP for withdrawal of the petition,
When 2:30?
2:30 or Monday, my lord.
Withdrawal 2:30.
2:30, please.
Civil?
2:30.
ಆಯ್ತು ಕೊಡಿ, CRP.
WP CPC madam, vacating interim application. Monday or Tuesday.
Give all them, no date, I will fix a date.
Similar, my lords.
Memo for being spoken to, my lords. There's
For what?
clerical errors in the final order that this court has passed.
Monday?
Monday. Last title ನನ್ನ ಹೆಸರೇ ಬಂದಿಲ್ಲ.
ನಿಮ್ಮ ಹೆಸರು ಬಂದಿಲ್ವಾ? ಓ. Terrible clerical error.
My lords, a similar matter, a lady being dispossessed from the property, trial court refused to grant inter. Even this matter was directed to be listed today. I do not know why it is 2:30, my lords.
ಬೇಡ ಬೇಡ ಅದೆಲ್ಲ.
Monday, my lords.
ಕೊಡಿ. ಮಂಡೇ ಅಲ್ಲ, ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ?
Fresh matter, my lords.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅದು ಬರುತ್ತೆ.
Monday, my lords. Great.
Call the case.
My lords, with the permission, my lords.
ಟೈಮ್ ಕೊಡಲ್ಲ ಅದರಲ್ಲಿ. 6 ತಿಂಗಳಿಂದ ಟೈಮ್ ಕೊಡ್ತಾನೆ ಇದ್ದೀರಾ. Nothing doing.
My lords,
Wait when the matter is called. Yes.
Please,
I last time observed that I will not permit you to file objections if you don't file. Don't,
Please, my
take the orders for granted. Yes, next.
My lord, one submission.
Let's-
106. I appear for the respondent number 2. We have filed.
Adjournment.
Please, my lord.
Adjournment.
I have
Direct
filed my
or indirect
statement of
illa.
objections today, ma'am.
Make a mention at 1:30.
Please.
Millards, Millards, with regards to Harvard bench matter, no separate list is given on V-console, Millards.
ಯಾವ್ದು ಇವತ್ತಿದೆಯಾ ಮೇಡಮ್?
Millards, Harvard list, there is no separate list given, Millards, on
All
V-console.
right, what do you want?
We won't be able to appear, Millards, where our matter is called out.
ಯಾವ್ದು
So
ಮೇಡಮ್?
separate list is given in V-console, only then we can appear.
ಇಲ್ಲ, ಮ್ಯಾಟರ್ಸ್ ಪಟ್ಟ ಇದೆ. I have it.
Millards, but there is no
We'll
list.
take it at 2:30.
Millards, but there is no list for us to appear, Millards. We cannot appear, Millards. There is no
Okay.
list on V-console, Millards. With the
List
court
is not
officer-
issued to you?
No, Millards. Court officer cannot call us up, Millards, when our matter is called out.
Why?
Because there is no list on V-console, Millards, to appear, which we
ಏನ್
can.
ಲಿಸ್ಟ್ ನೋಟಿಫೈ ಆಗಿಲ್ವಾ ಅಲ್ಲಿ?
Yes, Millards. There is no list on V-console, Millards, for the separate Harvard bench.
ಲಿಸ್ಟ್ ಆನ್ ವಿ ಕನ್ಸೋಲ್?
V-console, Millards, so that we can appear before.
Will console you later. Yes.
No, Millards, we cannot appear, Millards.
Wait, sir. Don't worry. Yes. No harm will be done. Don't worry. Yes.
Being spoken to still number 1.
Then Google has moved.
Only point is, I am search engine. No direction may be issued against me.
Why?
Not-
Google LLC ಗೆ issue ಮಾಡ್ಬೇಕಾ?
No, my only point is, if the main websites take it down, it won't come in the search result anyways.
Which is that main website?
Not main website is our Honorable High Court's website and Indian Kanun.
That we will do.
Those, and they are already parties, they have been directed to.
Google LLC also will direct.
Not, there are no URLs also.
No URLs with you?
No URLs with me, no URLs in the petition.
ಬರ್ಕೊಳ್ಳಿ. Please fill.
My lord, one submission, my lord. During the vacation, in fact, I was also about to move this matter, but learned counsel had moved it. During the vacation, my lord, the petitioner has written to me. This is a High Court Legal Services case. So she copied the honorable registrar and also written to me saying there are some more cases which she had inadvertently left out to tell me. The cases where I had
Give a
sought,
copy to them.
I will
And even to the High Court Legal
I
Service
will do that,
Authority
my lord. If
Council.
these cases can also be included in the
ಇದೆಲ್ಲ ಕ್ಲೋಸ್ ಆಗಿದೆಯಾ?
ಎಲ್ಲ close ಆಗಿದೆ, ma'am. I checked last night, my lord, in fact, and
Between
hence-
husband and wife, is it?
yes, my lord.
You
So in fact,
14 cases.
in fact, in addition to the cases I had produced in my annexure A, my lord, in fact, that's why I produced the email copy also, because she has said she has missed out telling me. So there was no, I didn't want to,
ಇದು ಸಾಕಾ ಮೇಡಮ್?
my lord, it's a legal services case, my lord. So I'm obligated to put this before your lordship because
No, you just serve a copy on the.
I have served
copy
mine.
on, I think TP Vivekanand idare. Just serve on
Will
TP
also serve.
Vivekanand and
I have
I'll
received.
take it on Monday.
Please,
on Monday.
Monday in the same stage. Yes.
please. Great.
Obliged.
Preliminary hearing. Number 2.
Ravi Shankar.
Appeal for petition. 1 week adjournment.
1 week adjournment.
Senior counsel.
ಅದೇನು ಒಂದೇ ವಾರ ಸಾಕು. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಇಲ್ಲೇ ಇದ್ದಾರೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ರೆಸ್ಟಿಡಿಕೇಟಾ ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಇಲ್ಲ ಅಲ್ಲ?
ಏನ್ ಎಂಟ್ರಿ?
At the request of the
ಕಿಕ್ ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ಲ.
we'll do it next week. ಒಂದೇ ವಾರ. Yes. At the request of the council appearing for the petitioner, list the matter on Friday the next 13th half day. We'll take it on 15th, 16th. List on 16th. Yes.
Sorry, your lordship.
ಏನ್ ದಾರಿಗೊಂಡ್?
ಧಾರವಾಡ ಬೆಂಚ್ ಪ್ಯಾಟರ್ನ್.
ಲಿಸ್ಟ್ ಬಂದಿಲ್ಲ, 2:15 ನೋಡೋಣ. ವೇಟ್. ಇಲ್ಲ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ತೀನಿ. ಚೆಕ್ ಮಾಡಿ.
ಇಂಟ್ರಿಯಂ ಮಾಡ್ರಿ.
ಎಲ್ಲ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಸರ್.
ಪ್ಲೀಸ್.
Number 3 minutes. The council is unwell.
ಕೌನ್ಸಿಲ್ ಇಸ್ ಅನ್ವೆಲ್. ಈ ಕೇಸು ಅಷ್ಟೇ ಅನ್ವೆಲ್, ಏನು ಇಲ್ಲ ಇದರಲ್ಲಿ.
Next week minutes.
ಫ್ರೈಡೆ ಯಾರು ಮಾಡಲ್ವ ಆರ್ಗ್ಯುಮೆಂಟ್? ಕೇವೇಟ್ರ್ ಇಲ್ಲಲ್ಲ. Two courts have held against you. ಇನ್ನೇನ್ ಬಂತು? 39(1) and 2. Next, list the matter at the request, same 3(2) ಹೇಳಿದ್ನಲ್ಲ ಅದೇ. Where is the joint memo?
Petitioner.
Joint memo page.
ಇದು compromise, Annex 20, Annex
Joint memo
27.
compromise ಎಲ್ಲ ಒಂದು.
27. Connected matters also, my lords, this honorable court
When?
granted. Annexure M ತಾವು ನೋಡಿ ಸ್ವಾಮಿ.
ಅಲ್ಲ, connected matter ಯಾವುದು?
Other site owners have filed similar writ petitions.
Number ಕೊಡಿ.
151, I have filed the order, my lords. Page 143. Annexure M. Notice has been issued and the parties have been directed to maintain status quo.
The counsel for the petitioner Kamala Charan submits that
There are two other matters.
in identical cases the coordinate bench has while issuing notice directed the parties to maintain status quo. In WP 15188 of 2024, the coordinate bench has observed as follows, page 144. In
Two
the
other
light,
matters also may be connected.
in the light of the interim order granted by the coordinate bench, there shall be an interim order in the case at hand as well. Tag this petition along with 15188 of 2024 and
Two other matters.
and other cases. List them all on your
List them.
emergent, ಅದ್ಲೇನ್ emergent notice same ಮಾಡ್ಬಿಡಿ ಅದರಲ್ಲಿ. Yes.
Great.
List them all on first week of July. Emergent notice returnable by the 4th of July.
Great.
Yes, next.
Petitioner, my lords. My lords, this is an IA for deposit of rents that is rejected, my lords. On the last occasion, I mentioned to my lordship that there is certain instances wherein the subtenant who I have do not have any agreement with steps into the shoes of the main tenant, my lords. My lord, may I be permitted to read the definition of the tenant under the Karnataka Rent Act, my lords?
Small submission. Due to senior counsel inconvenience, I seek accommodation.
Senior counsel inconvenience.
My lords, they've just been dragging on the proceedings here and also in the trial court, my lords.
No, no, man. He has
May
gone
pass
to,
it over, my lords, but my lords may hear it today, my lords.
he has gone to Mysore, my lord. So
ಮೈಸೂರಾ?
yes,
ಯಾಕೆ
on
sir?
some case.
ಕೇಸ್ಗ ಹಾಗಾದ್ರೆ ಒಳ್ಳೆ ತಗೊಂತೀನಿ.
Yes. My lords, the definition of a tenant means
Take
any
reading.
person whom or on whose account or on behalf the rent of any premises is, but for a special contract would be, includes 1, a subtenant, 2, any person continuing in possession after the termination of his tenancy. My lords, his tenancy is expired in November 2022, my lords, and he's continued to remain in my property. Even though I have no agreement with him, he's continued to stay in my property, my lords. He's also not paying the maintenance. And my lords, as per their own admission in the connected matter they had filed for injunction, my lords, they themselves admit that they are my tenant, my lords. I filed a memo for production of documents, my lords. In that it is clearly mentioned that they are a tenant under me, my lords. And also the document number 2 shows that I am the owner and he is my tenant, my lords. So these are the materials I also placed before the trial court. They said that the prima facie as materials have not been placed, my lords.
Yes, sir.
I seek accommodation.
My lords, they've been dragging on these proceedings for 3 years, my lords.
3 years.
My lords, the connected
2025 case, sir.
My lords, in the trial court, my lords.
ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಇಲ್ಲೇನ್ ಸ್ಟೇ ಏನಿಲ್ವಲ್ಲ?
Stay is not, I'm seeking for stay of the order, rejecting me IA and interim order directing him to deposit rents, my lords.
Well, see, yes. At the request of the council appearing for the respondent as a last chance, list the matter on Monday. It is made clear.
Monday there is
List the matter on Wednesday. It is made clear no further adjournment would be granted in the matter to the respondent. Yes. Next. In the event the council would not submit, the interim order as sought for would be granted.
Grateful, my lords.
For the respondent, request a passover of the matter, my lords.
Passover, senior here. Yes.
This writ petition, my lord, raises a important question, my lord, which requires to be decided by this court, because there are divergent views of different courts, high courts. But the question is as to whether a petition for execution of an award will lie before the commercial court. Because under the Commercial Courts Act, my lord, there is no provision providing for execution of an award specifically. Now, in the absence of a provision in the Commercial Courts Act,
it's a commercial execution petition.
My lord, exactly. Now, the question, my lord, is as to whether a commercial execution petition, not a commercial execution petition arising out of a decree passed by a commercial court. It is a commercial execution petition to execute an award, which, my lord, is the award, my lord, is pronounced in Delhi. And there is a section 34 proceeding pending in the Delhi High Court. And in the Delhi High Court,
the court, without getting into jurisdiction issue, directs deposit of rent.
No, my lord. No, there's not. Now, my lord, the question would be, there's a 34 petition pending before the Delhi High Court.
Correct.
Challenging the award.
Yes.
In that, my lord, the respondent here, who is the award decree holder, has filed an application before the Delhi High Court seeking that the money must be deposited there. Now I ask myself, and parallelly move for execution here.
Because they have not deposited there. There is
No,
stay.
just one.
So, all
execution.
Suppose, my lord, the Delhi High Court rejects their application.
No, rejects the application is different thing. Now the entire proceeding is 34 is pending there. If you are frustrating that by filing an execution petition here, notwithstanding the fact that you've already filed an execution petition there.
I have not filed any execution there.
No, they have filed an application in the 34 proceeding seeking for deposit. Seeking for deposit of the same amount.
Deposit of the
award amount. Yes.
There is no stay.
No, I'm not saying that. I'm not saying any of those things.
No, this requires to be decided. And
now, my lord, having regard to the judgment of the Supreme Court in Ambalal, which says, my lord, very strict construction must be given to the provisions of the Commercial Courts Act because we do not want commercial courts to be flooded with cases.
Correct.
Now, my lord, the question is, in the absence of a specific provision with respect to execution of an award, which is governed by Section 10, as opposed to Section 7.
How do you execute an award?
My lord, that has, my lord, before the regular court. No doubt.
Not before.
Not with the commercial court. That is all the point.
So you mean to say that the award passed by, the order passed by the commercial court,
yes,
determining certain benefit, would be executed in a regular court?
No. The benefits given by an award,
correct,
should be executed by the non-commercial court, not by the commercial court. Because commercial court's jurisdiction.
This issue has not come up at all.
No, not before this court. It has come up before, my lord, Gujarat High Court. It has come up before Rajasthan High Court. It has come up before Kerala High Court. They have taken divergent views. Yes. Where is the citation?
I was given to understand that we had spoken to the other side and the matter would be passed over.
Wait 1 minute, sir. I am
because
trying,
execution is
trying
also
to
listed
understand
today.
what it is. Wait.
There, my lord, I give you lordships, my lord, what is pro and what is against me. I'll give you lordships all that, my lord, and then, my lord, your lordships will have to take a view. And in fact, my lord, I think my respectful submission to your lordships would be to be persuaded to follow the Kerala High Court judgment, not because I say it is in my favor, but as a matter of law, my lord, I thought the Kerala High Court discusses the entire position in great detail, and then says that because there is no provision in the Commercial Courts Act relating to execution, the execution does not lie before the commercial court.
No, of course, the statutory provision illa.
That is the problem. If there is no statutory provision, in fact, one other question arises. Now, if this is a execution under Section 36, of the Arbitration and Conciliation Act, which says that an award shall be executed in the same manner as a decree, I would say, my lord, that the execution is under Order 21 CPC, not in a proceeding under the Arbitration Act, and therefore Section 10 of the Commercial Courts Act will not apply. Because Section 10, your lordship may kindly see the Commercial Courts Act for a minute, my lord. There is a specific provision, special provision made in relation to arbitration matters, as opposed to Section 6, which relates, my lord, to general suits.
Correct.
Now kindly see Section 10. Where the subject matter of an arbitration is a commercial dispute of a specified value, and we are not concerned with 1 and 2, my lord, your lordship may execute that. 3, if such arbitration is other than an international commercial arbitration, ours is other than an international commercial arbitration, all applications or appeals arising out of such arbitration under the provisions of the Arbitration and Conciliation Act that would ordinarily lie before any principal civil court of original jurisdiction in a district, not being a high court, shall be filed in and heard and disposed of by the commercial court exercising territorial jurisdiction over such arbitration where such commercial court has been constituted. The emphasis I would place, my lord, is that if it is an application or appeal arising out of arbitration, no doubt about it, under the Arbitration and Conciliation Act, an execution is not filed under the Arbitration and Conciliation Act. Kindly see Section 36. Section 36, my lord, of the Arbitration and Conciliation, according to me, is reference to Order 21. That's all. It is not incorporation.
Section 36.
My lord, respectfully.
Kodi, madam.
Of the arbitration. You have one more copy? May I first turn?
Take it.
Can you get it to me?
Yes.
Your lordship may kindly see Section 36.
Enforcement.
Yes, enforcement.
Yes.
One minute.
No, the book is here. You can take- Yes.
Where the time for making an application to set aside the arbitral award under Section 34 has expired, then subject to provisions of Section 2, such award shall be enforced in accordance with the provisions of the Code of Civil Procedure in the same manner as if it were a decree of court. The enforcement, therefore, of an award is under Order 21.
Yes.
It is not an application under the provisions of the Arbitration and Conciliation Act. Whereas Section 10 of the Commercial Courts Act specifically says if it is an application or appeal under the provisions of the Arbitration and Conciliation Act. But if you don't file an execution petition under Section 36, you file an execution petition under Order 21. And therefore, Section 10 will not vest jurisdiction with the commercial court to entertain an execution arising out of an award.
So this is preferred under 10.
Yes, but there's no doubt about it. This is only under 10 read with Order 21. The emphasis, therefore, my lord, I would place is that it should be under the provisions of the Arbitration and Conciliation Act. An execution is not under the Arbitration and Conciliation Act. Is a submission I'm making for your lordship's consideration.
Password. Password.
Now, Madhyana Baranwaila. You have a long
2:30.
2:30.
Before that, illa. Password 2:30. If you have any problem, I'll take it on Monday or Wednesday.
We have one submission subject to what my learned friend says. Well, last time when the matter had come up, the execution case had been posted before the court on the same day. And it was understood before the learned single judge when it came up at that time that they will simply ask for adjournment. Now the execution case is posted today.
That is why, password.
So, my lord, told I'll go.
I'll nimagain tondre illa.
Illa, but I'll come.
2:30.
7.
Unclaimed.
Lordship, this is arising out of an impugned order in my execution petition. I appear for the husband.
Husband, yes.
Please, Your Lordships. We had entered into a compromise. There was a compromise decree. The same has been produced before this honorable court from page 28 to 31. As per the compromise, Your Lordship, the wife had to come back to Bangalore along with the children. My obligations under the compromise decree were to pay the school fees of the children and provide for them. All this has been done. In fact, the school fee paid receipts are also produced with the present petition from page 32 to 39. Unfortunately, Your Lordship, she has left her home here and gone back to Coorg, and presently she is residing there. It's been a while.
Where are the children?
With her. I am not in custody of the children.
All right.
In fact, Your Lordship, so
now what is under challenge?
so I filed a execution petition.
For what?
From it is produced from page 40 to 41.
To execute what?
The compromise decree, Your Lordship. I wanted my wife and my children to come back and reside with me here in Bangalore.
Where is the compromise?
It's at page 40 and 41, Your Lordship. And in the said execution, apologies, Your Lordship, page 40 and 41 is the execution petition, which I filed because she has violated the compromise. Compromise is at page, compromise award is at page 28 and 31.
29?
28 to 31.
Oh, it
Should
says
be.
compromise is part and parcel. Where is the compromise petition?
The compromise, we have produced the compromise award in the
Without that, what are you doing then? You have filed execution to execute the compromise petition.
Please, Your
Petition
Lordship.
itself is not here. That is rejected and you are here.
No, that is not
What
the
has
one that is
happened now?
rejected. When I filed the execution petition, I also filed an application for interim custody until the disposal of the execution petition.
Which is the impugned order now?
Impugned order is at page IA number 4, Your Lordship, page 51 to
Page 51.
60 to 60. Sorry,
It's at page
my apologies.
18,
18 to 27, annexure.
It's page 18.
18 to 27.
It is dismissed.
Please, Your Lordships. That is my application seeking interim
Your
custody.
application is dismissed.
Please.
And you want the compromise petition to be executed.
Please, Your Lordships.
Where is the compromise petition?
My lords, that I understand, Your Lordship. My submission is limited to.
No, you are saying there is violation of the compromise petition. She has taken the children and gone and you want it to be executed. You want the wife and children to come back.
Please, Your
I
Lordship.
need to see the conditions in compromise.
It's in the compromise award. Those conditions are laid down.
Where is it? Tell me.
It's from page 28 to 31. All the conditions are laid down in the compromise award, 28 to 31.
Where is it?
Annexure
No,
B.
you come to
The petitioner and
come to
respondent
page
have.
31.
Please, Your
Further,
Lordship.
it is ordered and decreed that the compromise petition will be a part and parcel of the decree award.
What? Please, Your Lordship.
Where is it? Get it. Wednesday. On Wednesday in preliminary hearing.
My lords, can it be listed on Monday convenient
Monday,
to
there
the
are too
court?
many matters. Again, you will have to
The
go.
trial court is coming up on Monday. I can at least make a
For what
submission.
purpose?
For evidence. The trial court now, he is subjecting me to evidence. In the one of the findings in the impugned order is that this is a matter of trial, that evidence has to be led. My lords, in an execution proceeding, evidence.
All right, Monday. Yes.
Great.
Dependent writ petition.
For respondent number 2.
The suit is filed for declaration initially and injunction in respect of a particular property bearing survey number 294, part 3. The main contention raised by the plaintiffs is that they acquired this property under a release deed dated of the year 1979. Then we filed a written statement disputing the very valuation. And court said the valuation is not correct, you evaluate properly. When they had to pay the proper court fee, they delete the prayer of declaration and the suit is limited only for injunction. After the trial is over, the application for appointment of a commissioner has been filed.
That is rejected.
That is allowed. What I am it is allowed by the at the instance of the plaintiffs. This application is filed at the instance of the plaintiffs. But what has happened is this: in the course of the evidence of PW1, he has categorically admitted that survey number 294/3 is not part of this release deed.
Page.
Kindly go to page 67.
60?
67. Last third paragraph. ನನ್ನ your
ವಾದಪತ್ರದಲ್ಲಿ
ನನ್ನ ತಂದೆ ದಿನಾಂಕ 21/8/21ರಲ್ಲಿ ನನ್ನ ತಾತ್ಪರ್ಯವಾಗಿ ನಿಶಾನೆತ್ತಿ ನೋಂದಾಯಿತ ಹಕ್ಕು ಬಿಡುಗಡೆ ಪತ್ರ ಮಾಡಿಕೊಟ್ಟು ಕುಟುಂಬದಿಂದ ಹೊರಬರುತ್ತಿದ್ದಾರೆ ಸರಿ. ಸದರಿ ನೀತಿ ಒಂದಲ್ಲಿ ಈ ಪ್ರಕರಣದ ದಾವಾ ಸೊತ್ತು ಮತ್ತೆ OS 233/2009 ನಮೂದಿಸಿದ ಸೊತ್ತುಗಳು ಇರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. And this is the basis for his suit. Now what happened is he filed an application for the appointment of commissioner saying that the property, suit schedule property should be measured and buildings whatever are there has to be looked into. We filed detailed objection saying that the very evidence given by him is sufficient for the purpose of disposal of the suit.
Where is the order?
Kindly see Annexure P, Miller.
Annexure?
What the court has done is, after referring to the objections filed.
Page, sir.
Page, Miller, the order commences from page 103, Miller. The relevant portion is this, Miller. After referring to the objections filed by us. In the objections, we have clearly
referring to, where is the impugned order?
Impugned order itself is Annexure P, Miller.
Annexure?
PP. Last 103, Miller, page 103.
103, yeah.
103.
103 is evidence.
Annexure P, Miller.
Annexure B.
P. Annexure P.
P.
The page
115.
I'm sorry, Miller.
115. Yes.
Miller, Annexure P. Kindly go to relevant portion, Miller, is at internal page 108, Miller. After in the objections, we have detailedly brought to the notice of the court various admissions made by PW1 in respect of his case. What the court says is, no, notwithstanding those objections, I would like to appoint the commissioner because I have the power. And second reason is, what has happened is the court directs the appointment of a commissioner of a property mentioned in the release deed, not the suit schedule property.
Lord, what has happened is there is a serious dispute regarding the identification of the property. They themselves dispute that in their written statement. Your Lordship may kindly come to page 37, Lords. Annexure E. Annexure E, para 14, my Lords.
Page?
Page 37, my Lords. Annexure E, written statement. Para 14.
Page is ಸರಿ ಇಲ್ಲ.
In page number 37, my Lords.
ಅಲ್ಲ ಅದು ನಿಮಗೆ ಕೊಟ್ಟಿರೋದು ಇಲ್ಲಿ ಬೇರೆ ಇದೆ. Written statement. Different.
Para 14 of the written statement.
The suit schedule survey number.
Yes. The suit schedule survey number 292/3, 28 guntas belongs to the defendants and the plaintiff has not properly given the boundaries, and the survey number 292/3 bounded on East Road and then defendant's house, vacant site and primary health care center, school field, west AG Shivshankar KR Narsim Shastri's property, Kolar Bangarpet Road, north Raj Kaluve and Anjanappa's land, and south school field, in which there is only one stone roofed cattle shed which measures so and so feet, and there is no tile roofed house and only walls which measures so and so feet, but there is no any Mangalore tiled roof house.
2008 suit.
Yes, my Lord.
It's
a 17-year-old.
My only submission is this, Miller.
You are the plaintiff.
They themselves dispute the identification of the property.
The defendants. My only submission is this, Miller. Kindly see the order of the court. The court does not say that the suit schedule property should be measured. What the court directs is item number 3 of the release deed has to be measured.
Which is that? Where is the release deed?
Release deed, my Lord, they themselves admit in the course of their evidence that the survey number 294 is not part of the release deed.
Where is the release deed?
Release deed, right now I don't have the document.
If court has directed measurement of the release deed.
That is not the prayer in the application for the appointment of commissioner.
They admit the execution of release deed.
May submit.
I'm only telling you. If you are saying that there is the court pronounces upon a release deed, which is not the subject matter of the suit.
It is the subject matter of the suit, but what has happened is item number 3 is not the suit schedule property. Item
there is
number 3
clear
of the release.
identification.
Will kindly see the order, Millard. What the prayer is that Millard, the suit schedule property should be measured. Suit schedule property survey number 294/3. What the court says is, and in his evidence, he says there is no 294/3 in the release deed. Release deed is the basis for his right. And he categorically admits that survey number 284/3 is not part of this exhibit P1, which he has produced.
What is the time frame fixed now?
Millard, time frame, Millard, my only
Particularly of item number 3,
Item number 3
rice mill in the release deed.
Oh,
Which is that item number 3 in the release deed? What is the obfuscation with regard
that
to
is
that?
not the suit schedule property, Millard. That's what I'm submitting. If it is a suit schedule property, I can understand, Millard. I have no case.
Yes, sir.
Your lordship may kindly come to the schedule of the plaintiff's plaint.
Yes.
It is mentioned as 292/3.
294/3.
292/3. So there is a serious dispute regarding the identification of the property.
Release deed, suit schedule property allado. 292/3.
294/3.
What is the property described in the release deed? Nimatra is the release deed.
Release deed.
Because the court has directed measurement of release
Item number 3.
property found in the release deed.
And in his evidence, he has categorically admitted that neither in the suit filed by him, in fact, what has happened is, in the earlier suit
See,
filed by the sons
now,
against the father.
Para 16 news. Court acknowledges the admission by PW1 regarding survey number 292/3.
Yes, ma'am.
No problem. Because that is what he relies on. That is already that finds place. But that is not what is directed to be measured. You said serious dispute about the suit schedule property, taking me to the schedule there and what is described in the written statement. But where did this release date come in?
Lords, what has happened is I acquired the suit schedule property by virtue of a release date in the year 1979 from my father. They also admit the execution of
Suit
release
schedule
date.
property is acquired by way of release date. After the release date.
In the release date, it is mentioned as rice mill property. It's not mentioned, there is no survey number mentioned in the.
Where do you, in the plaint?
Mentioned as rice mill
Plaint
property.
ಅಲ್ಲಿ ಯಾವ ತರ ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ ಅದನ್ನು? 3A, paragraph 3A.
This is what it says. 292/3 measuring 28 guntas, which consists of a vacant site and the half portion of the stone
Yes, sir.
roofed, half right. My submission is 294/3 is a different property, is our case. He is claiming right in respect of 292/3. Your lordship may kindly see. He is claiming right in respect of 292/3.
Correct, no problem.
292/3, he admits that it is not part of release deed. He has categorically admitted
28
that.
guntas already converted,
No,
said
that's what
survey
I'm
number was
submitting.
not mentioned in the release date.
We have produced documents to indicate that 292/3 belongs to us. We have produced RTCs and everything.
There is confusion.
And my submission is, there is no confusion relating to 292/3 because in exhibit P1, he has admitted that this property is not there.
The court notices that, but nonetheless,
what I am submitting
release
is-
deed mentions to a rice mill.
Rice mill is not there here, Miller. Can
No.
you see where in the suit schedule, there is no rice mill.
No, suit schedule illa, pleading ಅಲ್ಲಿ ಇದೆ.
And what I am submitting is, what suit schedule property ne ಬೇರೆ. ಅವ್ರು ಕೇಳ್ತಾ ಇರೋ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದೇನೆ ಬೇರೆ.
That has to be ascertained.
So,
by-
My submission, how do they
Now,
identify the
it's all
property?
right. What is the prejudice cost to you?
But my submission is, it's a suit for injunction, their suit for injunction. And we have disputed this title. Suit itself is not maintainable because earlier he filed the suit for declaration injunction.
What happened to the declaration suit?
Declaration, what I am submitting.
Prayer for declaration
Let
was
me come,
withdrawn.
please. What has happened is this, Miller.
Right, sir.
He files the application suit initially for declaration injunction. Then we question the valuation. Court says valuation is not correct, you pay proper court fee. Then he deletes the prayer of
Declaration
declaration.
and reduces it to permanent
Injunction.
injunction.
Only injunction. Lawful question he has to establish, that's all. Where is the question of identifying the property? Your lordship may kindly see what are the things which are directed by, identified by the
No,
trial.
in certain circumstances, even in a suit for permanent injunction,
Yes, Miller.
the court can get into the issue of title.
No,
There is one
history of title, they can provide it, the law
ಈ ತರ
also is,
ಇದೆಯಾ?
the law is also to the effect that.
Type of suit is
Law is
immaterial.
also to the effect that when the title is seriously disputed, a bare suit for injunction is not
No,
made.
the ಪ್ರಾಪರ್ಟಿ ರೈಸ್ ಮಿಲ್ ಎಲ್ಲಿದೆ ಅಂತ ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ ರೈಸ್ ಮಿಲ್ ಇದೆ ಅಂತ ಅವ್ರು
ಇಂಜಂಕ್ಷನ್ ಕೇಳ್ತಿರೋದು ಅಗೇನ್ಸ್ಟ್ ದಿ 292/3
ಅದ್ರಲ್ಲಿ ಇಲ್ಲ ಅಂತ
ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ ರಿಲೀಸ್ ಡೀಡ್ ಅಂಡ್ ರೈಸ್ ಮಿಲ್ ಎಲ್ಲಿದೆ ಅಂತ ಗೊತ್ತಾಗಲ್ಲ.
ಅಲ್ಲ 292/3 ಅದ್ರಲ್ಲಿ ಇಲ್ವೇ ಇಲ್ಲ ಅಂತಾನು ಒಪ್ಕೊಳ್ತಾರೆ ಅವರು. And in fact, my lord, he has admitted in another suit filed by him. Evidence had to be considered. The only submission is this, my lord. The trial court ought to have looked into the evidence before deciding whether.
ಇದು ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ರೆ ನಾನು ಅಲೋ ಮಾಡ್ತಾ ಇದ್ದೆ.
ಯಾವುದು? ಅದು ಆಯ್ತು.
Order 26 rule 9 dismiss ಆಗಿದ್ರೆ I would have allowed it.
Normally, my lord, I do agree in a case where there is, application is filed after the trial is over. My lord, application has to be allowed. But here is a case where it's nothing but a clear case of correction of evidence, my lord.
Subject to correction, what I know is Order 26 Rule 9 is not for the purpose of fetching evidence for the plaintiff or the defendant. It is for the court to ward off the obfuscation it gets generated when the evidence.
It is only
that is what the court says.
It is going to complicate the issue.
No, why do you worry court will do it?
My submission is if item number 3 as described in the plaint, as described in the release deed, if it were to be the suit schedule property, my lord, I have no case. Item number 3 is not even the suit schedule property. How can the court direct the item number 3 to be identified and measured? Item number 3, I have no case at all. It is not their case that they are filing the suit in respect of item number 3 of the suit schedule property. If that were to be the property, I have no case.
So nothing is going to come out of it. It is only a report of the commission. Court will decide on the basis of the evidence. It will only strengthen your case or strengthen his case.
Already admissions are there in the evidence, which clearly
that court will
establish
consider.
that
It's not court will consider whether
Court
it's
ought to have
this or
admission.
Admission of PW1 is also noticed by the court.
No, that is only referred to. Court says, notwithstanding the objections, I want to appoint a commissioner.
Correct, because it has generated some confusion.
The court
evidence has generated confusion.
Court has not looked into the evidence at all. Only it has referred to the evidence.
In Order 26 Rule 9 generally, unless the court says yes out of the evidence.
There is a judgment of this honorable court which says that only when evidence is not sufficient, appointment of commissioner can be made.
Absolutely insufficient in the case.
It is a lot of evidence. Confusion is there creating.
There is one judgment of this honorable court. Under Order 26 Rule 9,
Justice
court has ample powers.
Anant Hegde avarda.
Justice Suraj Govindaraj. Your lordship may kindly see para 10, my lords. Para 10 of the judgment.
Yes.
A perusal of a reading of the said provision would indicate that in any suit where the court determines a local investigation to be requisite, then such local commissioner could be appointed by the court appointing a commissioner. The fact that words used are the court deems a local investigation to be requisite.
That is the judgment of the law is well settled. Only when the court comes to the conclusion that
court has come to the conclusion.
The court has not even looked into the evidence. We have filed detailed objections. Those objections are referred to. Referring to the objections is different from considering the objections in my respect. They have only referred to the objections.
No prejudice would be caused to you. If there is going to be delay, we will fix time limit, no problem. Because the 2008
suit, repeated amendments.
We'll fix the time frame. The petitioner, defendant, sole defendant.
There are more than one.
More than one. The petitioners are defendants in OS 194 of 2008. They are at the doors of this court calling in question an order passed by the concerned court allowing an application filed under Order 26 Rule 9 directing appointment of court commissioner to bring out the measurement and the exact location of the property. Heard so and so. Facts in brief germane are as follows. The respondent plaintiff institutes OS 194 of 2008 on 6/8/2008 seeking relief of declaration and permanent injunction against the defendants. Due to erroneous valuation, it transpires that the plaintiff deletes the prayer of declaration and retains the prayer of permanent injunction against the defendants in terms of the amended plaint so filed on 22/9/2017, after which the issues have been framed by the concerned court and the trial is on. What has driven the defendants hyphen the petitioners to this court is not the merit of the suit, but an application filed by the respondent in IA number 19, seeking under Order 26 Rule 9, seeking appointment of a commissioner to ward off the obfuscation that is in the evidence before the concerned court. The defendants filed their objection to the aforesaid application, and notwithstanding the same, the concerned court has allowed the application and directed appointment of a commissioner to measure the property which forms the part of a release deed. The learned counsel Madhusudan Rao, appearing for the petitioner, would vehemently contend that the suit is of the year 2008, and at the fag end, the application is filed under Order 26 Rule 9, and it has been allowed erroneously. According to the learned counsel, there is no confusion with regard to the property, as there is admission by PW1 that the subject property does not form a part of survey number 292/3.
It's not, the suit schedule property is not part of the
Suit
release
schedule
deed.
property is not a part of the release deed. As is averred in the plaint itself. He would take this court through the evidence of PW1 to demonstrate that to buttress his submission with regard to the fact that the suit schedule property does not form the part of the release deed. The learned counsel would thus submit that the order impugned allowing the application under Order 26 Rule 9 is erroneous and contrary to the evidence. Per contra, the learned counsel, what's your name?
Ganeshes.
Per contra, the learned counsel appearing for the respondent, Ganesh, would refute the submission, again taking this court through the evidence and the plaint averments to contend that there is serious dispute with regard to the location of the property, as the release deed mentions with regard to a rice mill, and to verify the boundaries, it was necessary for the court to appoint a court commissioner. The learned counsel would further contend that it is for the court to ward off the confusion that is generated in the evidence. Court commissioner is appointed, and there is no prejudice would be caused to the petitioners if the property would be identified and the suit taken to its logical conclusion on such identification. I have given my anxious so-and-so. The afore narrated facts are a matter of record. They would not require any reiteration. What has driven the petitioners defendants to this court is the order allowing the application under Order 26 Rule 9 of the CPC. I deem it appropriate to notice the plaint averment and the written statement for the purpose of considering the submissions made by the learned counsel for the petitioners. The plaint averment and the schedule in the plaint is as follows. 3A extract madi. Amale schedule at page 38, page 36 and 38. The written statement filed by the present petitioners, the defendants, is as follows. Para 14. It is inter-alia as follows. The learned counsel for the petitioner would place heavy reliance upon the evidence of PW1, who admits that the property in the release deed does not form a part of survey number 292/3 and 292/3. There can be no qualm about the said admission, as it is a matter of fact. The concerned court, the respondent, the plaintiff then files an application under Order 26 Rule 9 seeking appointment of a commissioner. The concerned court by its order allows the same. It is necessary to notice the reasons so rendered by the concerned court. Para 11 in the end, page 120 to 124. The submission of the counsel for the petitioner also bears consideration by the concerned court while allowing the application seeking appointment of a court commissioner. The concerned court notices that PW1 has acknowledged que survey number 292/3 that it does not form a part of the release deed. The concerned court has rightly held that it does not preclude the court from appointing a court commissioner to verify the property, even in a suit of permanent injunction. It is not that the court commissioner should be appointed only in cases where suit is filed for declaration, even in cases of permanent injunction. It is if the court entertains or comes across certain obfuscation with regard to the identification of the property, which can be deciphered only by a report from the hands of the commissioner. It would be well within its power to allow such application and appoint a commissioner. Finding no merit in the petition stands rejected.
And only request, I may be permitted to file additional memo of instructions if it is.
Where Ali?
Ali.
Yes, you can.
Because what has happened
What is
is, court has already appointed a commissioner now, because by the time the matter came up before your lordship.
Yes.
So additional memo of instructions, if needed be, we may be permitted to.
Yes. The learned counsel, the last learned counsel of the petition at this juncture would seek leave of this court to permit him to place on record additional memo of instructions
if needed.
If needed, the said submission would merit acceptance, and the petitioner is permitted to file additional memo of instructions on the receipt of the report of the commissioner if needed. Before that,
before the appointment of before the commissioner proceeds.
Now the order is already there. A commissioner is appointed.
But PO is appointed.
PDO is appointed.
We have to give the memo of instructions to the commissioner to do the job.
Oh, yes, all right. Next.
Lords, there may be a direction for this program.
2008.
Yeah,
well,
3 months or 4 months.
Since the suit is of the year 2008 and 17 years have passed by, I deem it appropriate to direct the concerned court to dispose the suit on its merit within an outer limit of 4 months from the date of receipt of the copy of this order.
9.
Appear for the petitioner in this case. In this case, the petitioner challenges the order IA allowing order 1 rule 8 filed by the plaintiff in the original suit after 20 years from the date of institution of the suit. Initially, the case was filed by 3 plaintiffs and seeking the relief for additional pension for those who have retired between 1997 to 2002. The case was heard and finally reserved for judgment in the year 2018. Then, because the presiding officer was transferred, then again the case was posted for arguments.
That's all right. Wait. When did you retire, sir? Huh? When did you, Mike? When did you retire?
Myself. We have retired in the year 2002.
Are you a pension optee?
Yes, pension optee.
When did you?
And all the.
When did you all opt for pension?
Before while in service.
While in service, second option for pension or the first option?
No. It is not second option.
When did you opt, sir?
I have opted for this when I was in service itself. In the beginning, in 1996.
29/10/1993 is the settlement.
Yes.
All right. 29/9/1995 is the regulation. 26/1/1996 was the last date to opt.
Yes.
When have you opted?
I have opted in 1996.
All right. Now what is the problem?
And all the problem here is all the employees have retired under voluntary retirement scheme formulated by the bank.
All right.
And we have all retired, and our pension, we are drawing the pension also.
All right.
But
now,
while making the payment to the, pension to me, there are certain, as per the VRS scheme, the management has agreed and offered to grant pension as per Pension Regulation Act.
Regulations.
Regulation, pension regulation. And
regulations 1995.
Yes. But while giving me this paying the actual pension, they did not include 29.5, that is 5 years of notional
5 years
service.
additional qualifying service. All right.
And then dearness relief as on the date of my retirement.
Mm.
And then 10 months average pay,
Mm.
that was not paid to me.
Mm.
And they made that, as far as the dearness allowance is concerned, they have brought some, they have paid on their circulars, which were amended subsequently in 2006 and 14.
What is your prayer before the
The prayer is all the 5 benefits as per 29.5.
now what is the why are you here?
Initially, the case was filed by the 3 plaintiffs individually.
All right.
Now, in the petitioner bank, there are 770 employees who have retired during the period 1997 to 2002.
Hmm.
We have been paying the pension. The only issue is that there was a settlement at the industry level at the IBA stating that those who have retired between 1997 to 2002, their salary is different from those who are serving. Based on that, he is challenging the additional pension. The difference for those who have retired, the basic pay, the wages are different. Those who have in service, the base, that was the settlement arrived by the IBA.
No. Where is your voluntary retirement scheme? Settlement is not arrived at by the IBA. IBA is a party to the settlement. That's all.
On behalf of all the banks?
The Indian Banks Association represents all the banks.
Yes, my
whether they are nationalized banks or
private
banks, whatever. Indian Banks Association represents it. Now, Indian Banks Association, you all drew up a scheme for pension. And again, later in 2001, a scheme for voluntary retirement.
That is our scheme.
That is your scheme, correct. That in terms of your scheme, these people have retired. If your regulation, pension regulation, which is common to all and you also.
We have drafted our own scheme, sorry.
Correct, sir.
It is not a statute.
That is not all right. That's not different from the other schemes.
Yes.
If you go to subclause 5 of section 29, which deals with voluntary retirement, it has 5 years addition to qualifying service. If you complete 30 years of service, subject to
years.
maximum of 33 years of service.
Correct.
Then if they are entitled to, they are entitled to.
No. Now they want after 20 years, all these, they want to save from the limitation point of view also. Those
What
are
limitation?
Because they have not filed the case earlier. They can join as co-plaintiffs, not in the representative capacity binding all.
Now, what is under challenge here?
No, that the permission to give.
What permission?
The court has permitted to sue the case in a representative capacity. There is no sameness of interest.
Comprehensive suit court.
A representative suit.
Representative.
It will be binding on all. Because they can join as a co-plaintiff. I have no objection for that one. That is, and after 20 years, the matter is reserved for the judgment. Then he amends the plaint.
Amends the plaint, that is permitted?
That is permitted. Now, in 2024, he files an application. I raised the objection in the initial stage itself. After 20 years, he can't come with the plea that it should be converted to representative capacity and should apply to all.
As far as we are concerned,
my submission is that these employees retired during the year 97 to 2002. Each individual will get different quantum of pension difference, and some employees will not have 5 years of service because
what 5 years of service?
Additional service, notional service.
That is up to cap is 33 years.
Yes,
cap is 33 years under regulation. Regulation 25 or 29.5 also
29.5
mandates that the 5 years qualifying service would be increased only if it does not cross 33 years. ಈಗ 31 years ಸರ್ವಿಸ್ ಆದ್ಮೇಲೆ 5 ವರ್ಷ ಕೊಡಕ್ಕಾಗಲ್ಲ, 2 ವರ್ಷ ಕೊಡಕ್ಕಾಗಲ್ಲ.
20 ವರ್ಷ ಅವರಿಗೆ ರೆಸ್ಟ್ ಸರ್ವಿಸ್ ಕೂಡ 5 ವರ್ಷ.
28 ವರ್ಷ ಸರ್ವಿಸ್ ಮಾಡಿ ರಿಟೈರ್ ಆದ್ರೆ 5 years 33 ಗೆ ಹೋಗುತ್ತೆ. Otherwise
30 ಇದ್ರೆ 2 ಕೊಡೋದು.
Cap is 33 ಅಷ್ಟೇ.
Then that's in
that's covered by Supreme Court judgments.
That is not, but representative capacity.
That we will answer, no problem.
At the fag end of this case,
statutory rights.
My submission is that there is no sameness of interest in the case.
But all of them are not retired persons.
Retired person, their cause of action date also may vary. Because those who are retired between 97 to, he has stated in the plaint, they have retired on such date. I will read that. Cause of action as arose. It is at page number 37.
Where is the impugned order?
Impugned order is annexure F.
Page
Number 60. It starts from 68. 68, my lord. Apart from this plaintiff association claims it is registered in Chennai and represents all retirees of all banks. Whether the territorial jurisdiction also, the Bangalore City Civil Court has a territorial.
There are some of them who have retired here.
But the plaintiff.
Where is the association? It's Bangalore or Chennai?
No, Chennai. This is not an.
That is the objection that you have taken?
I have taken in the written statement.
We'll see. We'll answer all of them. Next Friday, Haki. We'll dictate it on next Friday. Yes. List on 13th. 13th, beda. Half day 13th. List on 12th, antane maadi.
12.
Next.
I can argue additional points.
Huh?
Additional points argue madabodalla.
Oh, maadi. We'll see.
Dictation anta.
Dictation, no, I won't post it as for dictating orders. It will come. Yes. Next.
10.
Can they have it next week, Mala?
Huh?
Next week, Mala. Senior counsel is family.
At the request of the counsel appearing for the petitioner. List on 23rd. Notice issue agilwala. Bad one notice. Interim order beka.
11.
This case, I prefer petitioner, my lord. Defendant petition, my lord.
Challenging what, sir?
My lord, the respondent filed a suit in OS number 474/2024 for the relief of declaration and possession with respect to agriculture land bearing survey number 110/2, measuring 18 guntas and 2 guntas of Kharab. My lord, kindly annexure B filed by the respondent before the trial court in schedule in page number 30, my lord. A schedule property, that is.
What are you challenging now?
Annexure A, my lord. 29/4/2025. Initially, the trial court issued the suit summons and emergent notice on IA number 1 filed by the respondent. The petitioner have filed a writ petition before this honorable court and annexure C, my lord. This honorable court.
Police protection.
Initially, this honorable court passed an interim order with respect to the scheduled property.
Page 32.
My lord. Page annexure C 32. My lord, kindly see the order passed by this honorable court in page number 34. Learned counsel for the petitioner submit that petitioner has placed on record all the necessary information, including latest RTC of the year 2023-24, which show that petitioner is
not to put up any construction.
Not to put
all
up,
right.
my lord. And the petitioner the respondents have filed IA number 4 before serving the suit summons. Filed IA number 4 before the trial court. Trial court, after serving the suit summons and IA number suit summons and notice, this petitioner have contested the suit, filed a written statement.
What happened to this petition?
This petition is pending for adjudication.
No, this writ petition.
And pending for adjudication. This writ petition. My lord, only kindly, next my question is, kindly, after 29/4/2025, order passed by the trial court, annexure G, my lord, kindly see the annexure G, dated 6/5, page number 54. Why the petitioner and respond number 1 and 2, jurisdictional police and respond number 1, throw out the materials and direct lock the house. Kindly claimed the interim order against the respondent in agricultural property. These
Money yaak bandru?
Money, you kindly illegally enter the house and lock the house, Your Honor. He claimed the respondent in agricultural property, obtain order of temporary injunction, agricultural property. One kindly photographs clearly established not agricultural land. This is a village limit. I produced the photographs in 10 or 6 numbers. One kind of case of the petitioner before this honorable court, I am not constructed the residential house. The measuring 36 into 27 feet is the ancestral properties of the petitioner. Earlierly, the Mannina money and ACC seat roofed house is
We are challenging the order granting police protection.
police protection. One kind of totally different. The jurisdiction respondent number without having any right title. It's 6/5. One kind is photograph 6/5/2025. Date time 2/10. 2:15. Illegally come to the residential house and lock the house. Your Honor.
My lord, actually that was construction house earlier when the order was passed here.
What is the suit? What is the suit for?
Suit for order 39.
Declaration and possession. Where is the schedule? Where is schedule in the suit? Suit schedule ellide.
Schedule is
On submission, before I produced all the documents with respect to the return statement schedule property before the trial court certificate copies.
That is agricultural land?
No. My property is the Gram Tana Kanismari number. I constructed residential. The Panchayat issued NOC and earlierly ACC seat roofed house and Bescom is issued the electricity connection and also paid.
Now what is the status?
The matter is set down for a hearing on IA number 1. The matter already house is constructed over everyone. One kind of photographs clearly as annexer G.
Tag this petition along with.
my lord, I will file objections.
Madi, tag this petition along with WP 22729 of 2024. The said writ petition was preferred by the respondent plaintiff.
Defendant, sir.
Respondent defendant. The coordinate bench had passed the following order, page 34-35. The learned counsel for the petitioner plaintiff would contend that after the passage of the order, it transpires that the defendant files, defendant or plaintiff?
Plaintiff, my respondent.
The respondent files an application in IA4 seeking police protection to execute the orders passed
Forced injunctive order.
31-2 ಯಾವಾಗ ಆಯ್ತು? 39-1 and 2.
This honorable court passed an order 28/8
for grant of police protection
29
for enforcing the injunctive relief granted by the coordinate bench of this court in terms of its order dated 28/8/2024. The application comes to be allowed. The allowing of the application has led to serious dispute with regard to the plaintiff and the defendant. The house that is constructed by the present petitioner is the petitioner is said to have been driven out of the house that is constructed, and the house is said to be locked. And to buttress his submission, the photographs are produced. Photographs are appended to the petition. The learned counsel for the respondent now seeks 2 weeks' time.
Yes.
2 weeks' time to file statement of objections. Till the filing of the statement of objections, the proceedings before the concerned court shall remain stayed.
The order of annexer A, stay the annexer.
Annexer A.
Annexer. Yes, A.
The order at annexer A shall remain stayed. Yes.
Already filed a memo along with the connected matters.
Tag the petition ಹೇಳಿದ್ನಲ್ಲ madam. Yes. Next.
Fair.
Milords, I appear for the petitioner in this matter, Milords. Milords, the petitioner is a plaintiff before this honorable court, who is aggrieved by the fact that trial court has not passed an order, ex parte order in their favor. Milords, petitioner.
In whose favor?
In my favor, Milords. In my
their favor andre?
My apologies.
Yes.
In my favor. Milords, petitioner is a real estate company, Milords. I purchase lands, develop it, form sites, and sell it to prospective purchasers. Now, what has happened?
What is the suit for?
Suit for injunction because the respondents before this honorable court were prospective purchasers who approached me in the month of January. I give them all the documents, Milords. Before saying this, may I invite your lordship's attention, page number 60, Milords. 60 of my petition. 60. Yes, Milords.
Yes.
Milords, this is a second part of the page, Milords, is a email that is written to me as on 30th of January. They say these are the pending documents that are required for the legal due diligence. I provide them all the legal necessary documents, my lords. They're very much happy with how the title flow goes. They say I will pay the advance sale consideration, and on 17th of February they pay me advance sale consideration of about 14 lakhs, my lords. 14 lakhs towards the purchase of property. And thereafter we enter into a sale agreement. Subsequently, after entering into a sale agreement, what the respondents, who are the defendants, say is, I don't want to go ahead with registration of property, I want my money back. I say, as per the sale agreement, there should be 10% of reduction in my favor. Deducting 10%, I'll give you the remaining balance, is what I say. That is when what these defendants do is they go on Google and they start writing derogatory comments against me, as if I have absolutely no title in the matter. Because, my lords, this matter, this particular land which I have now developing is a land which was belonging to originally SC/ST person. Grant land in 1978. The original grantee passes away.
You have no title, is it?
No, I have a title, my lords. I'm just saying the facts, my lords. The original grantee passes away. His wife in the year 2016 obtains permission for selling of this land. Subsequent to purchase, subsequent to obtaining,
It's permitted by the
it's
Assistant
permitted. It's
Commissioner?
permitted, my lords. All those things are there. They want the refund. The legal way of retorting is this way, my lords.
Now, what is the restraint order you sought?
The restraint order is not directing the defendants not to publish these kind of derogatory statements. And third, the second prayer is to direct Google to take down 2 Google reviews that they have posted.
Heard the learned counsel. Google is a party here.
But defendants are the subsequent purchase. Google LLC.
Google is a party.
Google
here.
LLC is third defendant, the third respondent.
The petitioner is the plaintiff, is before the court on the score that the concerned court has not granted an ex parte injunction as was sought for under Order 39 Rule 1 of the CPC. The facts that has led the petitioner to this court is that the petitioner is a developer. The respondents 1 and 2 are home buyers. The petitioner, the respondents, by way of email communication, sought certain documents from the hands of the petitioners to verify whether the land was to verify the status of the land and its legal status of the land. All the documents that were in the custody of the petitioners is said to have been communicated to the defendants 1 and 2. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು
14 lakhs,
10%.
10%. Total
Pursuant to which it transpires rupees 14 lakhs is paid by separately, na? Husband and wife,
husband and wife,
paid by defendants 1 and 2. After such payment, it further transpires that they did not want the land on a plea that on a plea entertained by them that the land was the land did not have a perfect title. In that light, the perfect title, and after which the defendants 1 and 2 have gone on the social media or Google by making derogatory statements against the petitioners. It is at that juncture the plaintiff approaches the court approaches the concerned court in OS
3073 of 2025.
OS 3073 of 2025. The concerned court in the teeth of the and the prayer that was sought was to restrain defendants 1 and 2 from making any derogatory statement, and the third defendant to take down all the statements already made. The concerned court ought to have answered the same without only issuing notice. In that light, there shall be an interim order or the injunctory relief sought for by the petitioners till the next date of hearing. 1, 2, Google LLC appear actor Manu Kulkarni.
I'll serve minutes.
1 and 2, emergent notice returnable by 4th July. 3, learned counsel Manu Kulkarni is directed to accept notice, petitioner to serve set of papers upon the aforesaid counsel forthwith.
Much obliged.
Next.
13.
Three propositions.
3 propositions. Yes.
Respondent number 2 was given the benefit of an OTS. I have applied for the similar OTS. The application is neither allowed nor rejected. Respondent number 2, my lords, has suffered a brain hemorrhage, not in a position to give instructions. Order 32 Rule 5 application was filed. The judge refuses it on the ground that Previously, he had filed. Order 32 Rule 5 application was filed. The judge says that on 28/2 you have appeared, and subsequently I filed my written arguments. He says, no, therefore I hold that he is not required to be examined. The Supreme Court is very clear that when there is mental unsoundness application, the court has to conduct an inquiry.
Well, we'll take it on Monday. List on Monday. In preliminary hearing. Yes. Next.
Appear for respond number 4 in start.
Should appear for
Copy is not.
petitioner.
Is
Is arising
arising out of what?
LAC proceedings, Your Lordship. Your Lordship, the petitioner respondent number 2 and 3, they are the claimants. Lordship, petitioner had filed an application for recalling the order for seeking permission to cross-examine the further cross-examination of PW1, as his counsel's son's marriage was there and he
One
couldn't be
opportunity.
present.
Let it be a direction to complete.
Direction to complete on the same day.
Please, they filed original suit that was dismissed, against which they preferred appeal.
We'll direct him to.
And second appeal is also dismissed. And they are dragging the proceeding. This is the 7th application that they have filed
Don't
for
worry.
recalling.
That I will not do. Recalling one haki. One day ಕೊಡ್ತೀನಿ. ಅವತ್ತು ಮುಗಿಸ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವತ್ತು ಅಷ್ಟೇ.
Yes, sir.
Public.
One opportunity. That will be the order. Dispose. Yes, next.
What's it?
15.
Lordship, application under order 26/9 appointment of commissioner to measuring the property in respect of the suit.
Where is the impugned notice?
My Lordship, in this page number 34, my Lord, annexure D, my Lord.
What's wrong with the order?
In the suit schedule property, it is only in the from the forefathers in the year of 1859 to is a position as adverse position.
Okay, 136/2. Survey number 136 bar.
Yes. Yes. And out of my Lordship, in the respect of 3.5 guntas, he was in a constructed house and shed. In respect of the dependent without right over the scheduled property, in respect of 2 acre 29 guntas, only in the total land measuring in the 4 acre 14 guntas, my Lord. So trial court only, but is a matter is posted.
He's not even denying it. ನೀವು ಕಟ್ಟಿದ್ದೀರಾ ಶೆಡ್ 3.5 ಗುಂಟೆ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಅಂತ ಡಿಫೆಂಡೆಂಟ್ ಇಸ್ ನಾಟ್ ಇವನ್ ಡಿನೈಯಿಂಗ್ ಇಟ್.
ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, ಇಟ್ ಈಸ್ ಓನ್ಲಿ ಕಲ್ಲೂಡಿತ್ ದ ರೆವಿನ್ಯೂ ಆಫೀಸರ್, ದೇ ಆರ್ ಎಂಟರ್ಡ್ ಇನ್ ದಿ RTC.
ಅದಕ್ಕೆ ಯಾಕೆ ಬೇಕು ಕೋರ್ಟ್ ಕಮಿಷನರ್?
ಅಲ್ಲ, ಮೆಜರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅವ್ರದ್ದು ಪ್ರಾಪರ್ಟಿ ಆ ಕಡೆ ಇದೆ.
ನಥಿಂಗ್.
In the even my Lordship, in the ruling adjudicating in the matter, it is only in the respect to the scheduled property.
What is that?
My Lordship, in the order 26/9 is allowed the
judgment.
Yes.
Yes, sir.
3.5 guntas he was a constructed, my Lord, and old building demolish ಮಾಡಿ new building ಕಟ್ಟಿದ್ದಾರೆ. Since from 1858 in the is a position. So our 2 acres only in respect of the 2 acres is a position. But dependent is no right to do, my Lordship. In this.
What is the stage of the suit?
My Lordship, in the suit is now is first time is argument.
First time?
First time argument post argument. Is only in the trial court has only taken that view, my Lord. The matter is posted for the argument.
Nothing wrong with the order, sir. Yes. Anything else?
my lordship, in the dependent also is a, of course, my lordship, in the denied is in the
He is
encroachment.
not denied.
Not denied.
He is not denied that you have constructed the property, constructed the shed in 3.5 guntas. ನೀವಿದ್ದೀರಾ?
Next matter.
ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರಾ?
16.
ಈಗ ಆಗ್ತಾ ಇರೋದು 15 ಅಲ್ವಾ? ಯಾಕೆ ಅಡ್ವಾನ್ಸ್ ಆಗೈತೆ ನಿಂದ? ಎಸ್ ಎಸ್ ಸರ್.
Very necessary, my lordship, in the ADLR is, my lordship, in the measurement is required, my lord, is. Because of our property ekade baruttade, nam property ekade
ಅಲ್ಲೇ ಬರುತ್ತದೆ ಅಂತಂದ್ರೆ ಎಸ್.
For earlier, my lordship, in the father of the dependent is filed a suit 93/19 in my lordship, in the is admitted, my lordship, in the written statement.
ಎಸ್ ಸರ್. ನಥಿಂಗ್.
ಅದರಲ್ಲೂ ಡಿಕ್ರಿ ಆಗಿದೆ. ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
ಅದು ನೋಟಿಸ್ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲಿ.
ಅಲ್ಲ, my lordship,
that is also notice OS 93 of 1982.
Yes, my lord.
Relying on the commissioner's report.
Commissioner report ಮಾಡಿದ್ದಾರೆ.
A suit of third party cannot be allowed. Yes. ಆ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ರಿಲೈ ಆಗಿರೋದು ನೀವು ಕೇಳ್ತಿರೋದು ಟೋಟಲಿ ಡಿಫರೆಂಟ್. ಇಲ್ಲಿ ಏನು ಡಿಫೆಂಡೆಂಟ್ ಇಸ್ ನಾಟ್ ಡಿನೈಡ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಟ್ ಆಲ್. ದೇರ್ ಇಸ್ ನೋ ಕನ್ಫ್ಯೂಷನ್ ಅಬೌಟ್ ದಿ ಬೌಂಡರೀಸ್ ಆಗಲಿ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಆಗಲಿ ಏನೂ ಇಲ್ಲ. ಎಸ್, ದಿ ಪೆಟಿಷನರ್ ಈಸ್ ಬಿಫೋರ್ ದಿಸ್ ಪೆಟಿಷನರ್. 1 minute. The petitioner plaintiff is before this court calling in question an order dated 17th April 2025 by which the concerned court in OS 35 of 2021 rejects an application filed by the plaintiff petitioner under Order 26 Rule 9 of the CPC seeking appointment of a court commissioner to identify the suit schedule property. The petitioner is the plaintiff. The petitioner is the plaintiff who claims to be the absolute owner of the suit schedule property, which is and has perfected his title by way of adverse possession, since he has been in possession from 11/7/1977. A suit comes to be filed as aforesaid against the defendant with regard declaration suit
ಇಲ್ಲ, adverse position.
Against the, who is the defendant then? Suit for adverse possession against the defendant for seeking the following relief as found in the plaintiff. Page 22. In the proceedings, the petitioner plaintiff files an application seeking appointment of a court commissioner by an application under Order 26 Rule 9 of the CPC. The concerned court, in terms of its order as aforesaid, rejects the application of the plaintiff on the score that on two grounds. One, that the matter, the suit is at the stage of arguments, and there is no confusion with regard to the identification of the property. The concerned court also notices that the earlier suit with regard to the land in OS 93 of 1982 was disposed on the basis of a report of a commissioner. That was the suit of third parties, and that cannot be relied on in the subject suit again to demand that those the survey number 136/2, which measures about 4 acres and 14.8 kuntas, should again become the subject matter of a report by the commissioner. The concerned court answers the same as follows. Para 10 in the Endoriga. So, in the light of the court not entertaining any doubt about the possession of about the existence, boundaries, or possession of existence of the property in survey number 136/2 with regard to 3.5 guntas of land where the plaintiff is said to have constructed a shed, and that being not denied by the defendant, there was no warrant for the concerned court to appoint a commissioner as sought for by the petitioner.
The order does not suffer from any such perversity which would entail entertainment of the petition under Article 227 of the Constitution of India. In that light, the petition stands rejected. Next.
16.
ಇದು ಅದೇನಾ?
ಅದರಲ್ಲಿ ಸೇಮ್ ಸರ್ವೆ ನಂಬರ್ ಅದು ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ 10 ಗುಂಟಾಸ್ ಕನ್ಸಿಸ್ಟಿಂಗ್ ಟು ದಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಓಲ್ಡ್ ಆಫೀಸ್, ಪೋಸ್ಟ್ ಆಫೀಸ್ ಅಂಡ್ ಬಸ್ ಸ್ಟಾಪ್. ಅದರಲ್ಲೂ ಅವರು ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ದಾರೆ. ಓನ್ಲಿ ಇನ್ ದಿ ವಿಲೇಜಸ್
ಬೇಕಾದ್ರೆ ಆಮೇಲೆ ಮಾಡ್ತಾರೆ ಬಿಡಿ. ಯು ಕ್ಯಾನ್ ಆಲ್ವೇಸ್ ಸೇಮ್ ಮಾಡ್ ಸೇಮ್ ಪಾರ್ಟೀಸ್ ಎಕ್ಸೆಪ್ಟ್ ದಿ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಅಂತ ನೋಡ್ಕೊಂತಾರೆ, ಆಮೇಲೆ ಹೇಳ್ತೀವಿ. ನೆಕ್ಸ್ಟ್
17. Rejected.
The defendant has filed a writ petition that impugned order is at Annexure A. Impugned order at Annexure A, my lords, whereby an amendment application has been allowed. By way of an amendment, a new entity, my lord, is sought to be implemented.
What entity?
My lord, the petitioner number 2, Purvankara Limited.
What is the stage of the suit?
Stage of the suit is, my lord, for evidence of the plaintiff. And the written statement, the original suit, my lord.
So it's after the commencement of the trial.
Yes, my lord, it is after the commencement of trial, my lord, and in the original suit, the project name has been shown as different. So I took a contention that the legal entity is Purva Ruby Properties. My lord, I could understand if that entity is sought to be.
Come to page 64.
Yes.
This is the, now the amended plaint.
Amended.
Where is the original plaint?
Original plaint, Annexure B, my lord.
Page.
Page 29.
Purva Zentech
Business Park, that is a project name. Now, my lord, in my written statement at para 4, page 40, I took a contention that it is a project name.
Purva Zentech Business Park.
Yes. At page 40, my lords, para 4 of my written statement, I took a contention that it is that's a project name and it is being developed by Purva Ruby Properties Private Limited, a company incorporated, Companies Act. Now, this entity is not sought to be implemented or no amendment. A totally different entity is sought to be implemented, my lord.
ಎಲ್ಲ ಒಂದೇ.
ಅಲ್ಲ, my lord,
ಆಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರಾಬ್ಲಮ್ ಕೊಡಕ್ಕೆ ಇವೆಲ್ಲ ಹೇಳ್ತಿರೋದು.
ಅಲ್ಲ, ಈಗ ಪೂರ್ವ ರೂಪಿ ಹಾಕಿದ್ರೆ my lord, the execution ಅವರಿಗೆ ಪ್ರಾಬ್ಲಮ್ ಬರೋದಿಲ್ಲ. Now, my lord,
ಆಯ್ತು, ಅದನ್ನೇ ಪರ್ಮಿಷನ್ ಕೊಡೋಣ ಬಿಡಿ.
Till then, my lord, let the suit, let it not be continued, my lord.
You serve on the council.
I'll serve on the council.
Serve on the council, we'll take it on Wednesday.
Very well.
The petitioner shall serve on the council, so represent the respondent 1 and 2 in the trial proceedings and file an acknowledgement. So and so. List the matter on Wednesday in preliminary hearing.
Yes.
Yes. We'll permit him to implead that. Execution will ತೊಂದರೆ ಆಗುತ್ತೆ ಅವ್ರಿಗೆ ಆಮೇಲೆ. Yes. Next.
My lord, 9/6 is the next date. ಸೋಮವಾರ ಇದೆ.
ಸೋಮವಾರ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಅಂತ ತಗೊಳ್ಳಿ, 11th ಹಾಕಿದ್ದಾರೆ.
ಆಯ್ತಲ್ಲ, ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಗಂತಿದೆ, so I cannot ask for an adjournment.
The concerned court shall defer the proceedings till the next day.
Next.
Yes. 9th and preliminary hearing. ಸರ್ವ್ ಮಾಡಿ ಇವತ್ತು. ಸರ್ವ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಇಂಟರ್ ಮಾಡಿ ವೆಕೇಟ್ ಮಾಡ್ಬೇಕು.
18.
I'll appear for the petitioners. The petitioners, this proceeding is arising out of the final degree proceedings. It's the second round of litigation for the petitioners. Petitioners are the purchasers of the sites in item number 9 of the suit schedule properties from the predecessor in title of the defendants 10 to 18, respondents 10 to 18, who are the legal case of defendant number 2. And what happened is, we were not aware of the pendants, we were not aware of the pendency of the suit. And we came to know about the fact that there is a partition suit and all that only in the final degree proceedings. We filed applications to implead ourselves because being the aliens, we can seek equities in respect of the allotment of shares. As per the shares allotted in the RFP, our regular appeal.
Whom did you partition suit?
Partition suit.
Whom did you purchase the property
I
from?
purchased the property from the predecessor in title of defendants 10 to 18.
Defendants?
Respondents 10 to 18.
Respondents 3 to 18.
10 to 18.
What was their share?
They had 1/6 share in this particular property. In addition to that, as per the judgmental decree passed in the regular appeal, he has been given half share in other items 1, 2, 5, 7, and 8 and 8.
How many sale deeds are executed?
But there are several sale deeds. Sites have been formed and sold. Then what happened is, this impleading application was filed. When the impleading applications were pending, respondents 10 to 18 enter into a compromise with respondent number 1. A compromise petition was filed. That compromise petition was accepted without considering our impleading application. Then we filed writ petition before this honorable court. In the meanwhile, respondents 10 to 18 themselves had filed a writ petition before this honorable court, challenging the appointment of a commissioner in FDP proceedings. And in that proceeding, this honorable, they said the bills are executed by the mothers because this Chandrasekhar Raya, who is the predecessor in title of defendants, respondents 10 to 18, he is the son of one Govindappa. And Govindappa had married two sisters. The entire suit partition is in respect of the allotment of shares to 6 sisters because they did not have any brothers. And all these people are claiming under some of the sisters. My predecessor is claiming under 2 sisters. And what happened? They claimed that there are wills executed by the mothers, the mother and the stepmother, in favor of this Chandrasekhar Raya. So they filed an application before the court in the earlier writ petition, saying that those wills should be inquired into. Thereafter, this order came to be passed, under which a compromise was entered into between respondent number 1 and respondents 10 to 18. They also challenged that order. They brought that order to the notice of this honorable court. This is the order passed by this honorable court in the earlier proceeding. Kindly go to
Justice Shyamprasad.
Justice Shyamprasad's order. Other than Annexure T, your lordship may kindly see. Otherly, there is a category in para 10 of the order. Kindly, I just would like to draw your lordship's attention to at ink page 345 minute. 345, your lordship gets it. This court must, para 10, your lordship got it. This court must also observe that the civil court, as it may not have due assistance to the learned counsel, must decide the merits of the application for impleadment filed by the concerned purchasers, and the decree to be drawn without constraints of completing the inquiry for drawing up of a final decree. Subsequently, we had also challenged the same order in the other writ petition at Annexure T, 26475 of 2023. This is the early writ petition filed by us. This honorable court, while noticing the order passed by His Lordship Justice Shyam Sundar at Annexure T, Shyamprasad, has passed this order at 354 in page 350. Lordship gets it. In this petition, petitioners are aggrieved with the impugned order dated so and so, passed in FDP numbers. Learned counsel for the petitioner, learned counsel for second respondent have jointly submitted that the very same order has been set aside by the coordinate bench.
You purchased it from respondents 15 and 17.
10 to 18.
10 to 18.
The predecessor in title of respondents 10 to 18. Chandrasekhar Raya.
Predecessor in title of 15 to 17.
10 to 18.
Now the court holds
16 to 18 also are the executants of the sale. They are the sons of Chandrasekhar Raya. But what has happened is, when the impleading application is filed, the court below says, my impleading applications are dismissed by the court, saying that I can always pursue my remedy in elsewhere. It's a well settled law that
I am entitled to only that share.
That's correct. But my application cannot be dismissed by respectful submission.
Is in the FDP.
FDP proceedings. See, my rights can be adjudicated only in FDP.
Correct.
Equities can be adjudicated
not in the
only in
preliminary
FDP.
decree proceedings, because suit for partition
Suit is already over. I am only a necessary party in the final decree proceedings. I have filed the applications in the final decree proceedings.
Yes, sir. Varadajan, sir.
That he was not aware of the pendency of the suit.
Is not a ground.
But that will not take him away out of the status of a list pendants purchaser.
Correct.
Suit is filed in the year 1989. They are all locals. They cannot plead ignorance about the suit. Matter is pending for about 35 years.
When did you purchase?
These properties were all purchased in 2004,
2007,
2009, 1993. So what has happened is,
during the pendency of the
original suit,
we
were not aware of the suit, Miller. We are not.
FDP is 21.
FDP is 21.
I will explain. Now, Miller, the matter pertains to only one survey number 68. Its total extent is 1 acre 13 guntas. Now 6 shares are awarded. 2 shares in favor of 2 daughters of the propositors Chengaya. That is one Mangamma and one Yangamma. Now their children are this Chandrasekharaya and Jayamma. Now there was some will and all that hardly now matters.
Now it does
now
not.
Each daughter is awarded 1/6 share. I am entitled to 1/6 share. The commissioner is appointed. Commissioner has filed his report with a sketch. Now this Chandrasekharaya, through whom they claim an interest, he is granted one block measuring about 8.5 guntas. Jayama, through whom he is of course not claiming, she is also given another block 8.5 guntas. Two wives, two daughters of the propositors, these two, in the will they have compromised it. Now his predecessor in title gets block number 1, about 8.5 guntas. That's the no layout is far above approved layout and all that, and it is a revenue land. They purchased it with some imaginary boundaries. That is all right. Now, so their right is only in the share of their vendor.
Correct.
That's ಅಷ್ಟು ಆ 8 ಗುಂಟೆನಲ್ಲಿ ಎಷ್ಟು ಜನಕ್ಕೆ ಅಕಾಮಿಡೇಟ್ ಮಾಡಬಹುದು ಜಡ್ಜು ಅಷ್ಟಕ್ಕೆ ಮಾಡಬೇಕು ದಿ ರೆಸ್ಟ್ ಬಿಕಾಸ್ ದೇ ಹ್ಯಾವ್ ಸೋಲ್ಡ್ ಎಕ್ಸಸ್ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ ಲ್ಯಾಂಡ್ ದೆನ್ ದೇರ್ ಶೇರ್ ಅವರು ದೇ ಮೇ ಹ್ಯಾವ್ ಟು ಪ್ರೊಸೀಡ್ ಅಗೇನ್ಸ್ಟ್ ದೇರ್ ವೆಂಡರ್ ಬೈ ವೇ ಆಫ್ ಡ್ಯಾಮೇಜಸ್ or recovery of the purchase.
If it is excess, if the vendor has sold in excess of 8.5 guntas, it is for them to work out their remedy elsewhere.
That's right.
Now within those 8.5 guntas, if there is a claim for them, they would be necessary parties.
I wouldn't dispute that.
Yes.
But what I am want this court to make it clear is, let's let this 35 years litigation, and Justice Shamp,
correct.
two of his orders,
Yes,
has said it should be over by another 6 months.
correct.
That is also, I have also made and filed an affidavit complaining that the order is not possible. I'm not on that, all that I want is, this court may say that these purchasers have to work out their remedy against their predecessor, Chandrasekhara, in relation to that particular block which is allotted to him. They cannot claim anything more. And if there are some other purchasers who cannot be accommodated,
what's the
so
next
they
date-
cannot
next
proceed
date
against
then?
the other shares.
16/6.
16/6. We'll take it on 11th. We'll pass orders on 11th.
Only one submission I wanted to make. What has happened is, this Chandrasekharaya is not only allotted 1/6 share in this particular property, he has been given half share as per the final preliminary decree.
There can be no doubt. They are entitled to proceed against Chandrasekharaya's share.
Let me come. Just want to make one submission. He has been allotted half share in items 1, 2, 4, 5, 7, 8, and 10 properties. So question would be, at the time, to what extent we will be entitled for adjudication of rights and all that, and equities are to be worked out, will have to be taken into account the shares which are allotted to Chandrasekharaya in all the properties, not only item number 9.
That's
so my equities can be worked out taking into account that shares.
Wednesday, yes, 11th.
There are other respondents, to whom notices.
Let me see. Yes, 11th.
Because what happens is, if your lordship wants to dispose it of, there may be difficulty because there are other respondents.
Now that the court would be saying,
That
he can
we'll
work
see.
it out remedy against his vendor. Why should he
11th.
want that other- This is how this is matter is being dragged in the.
Based on 11th.
Nobody is dragging. My
ಈಗ-
applications have been
ಈಗ-
unnecessarily
ಈಗ ನೋಟಿಸ್
delayed.
ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಅವ್ರ ಸರ್ವೆ ಆಗಲ್ಲ, another 5 ವರ್ಷ
ಅಲ್ಲ,
ಆಗುತ್ತೆ.
I can do one thing.
The court is saying,
No, I can
allowing
do
the
one thing.
litigation, why should he insist?
Don't, we'll see.
Hands on
11th. ಏನ್ ನೋಟಿಸೇ ಬೇಡ ಈಗ 11th.
My only difficulty was.
He is on KV8.
I've already served the copy.
Yes, so no problem.
Much okay. 12th minute.
11th.
Admission 19.
My lords, I appeal for the respondent, my lords. My lords, I pray for short accommodation.
Accused number, the accused number 4 and 5 are one of the lead manufacturer of Indian cylinder, my lord.
Yes.
For the government of India. And allegation that, my lord, accused number 1, who is a public servant, who has demanded of illegal gratification of 50,000 rupees for forwarding the inspection report of the inspection report.
What have the public servants have challenged?
Been quashed by this honorable court.
Kodi.
That is, I have produced the judgment, my lord. One more judgment.
Madam, this is not correct.
Lords, I pray for short accommodation. Which,
In fact,
my
in
lords, the
that-
connected matter, my lords, we have filed an SLP.
ಅದೇ ಲಾಸ್ಟ್ 6 months ಇಂದ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಕೊಡಿ.
And there's an interim order which is existing, my lords. Hence, my lords.
ಮಂಡನ್ಸ್ ಕೇಸ್ ಇದು ಸ್ಟೇ ಆಗಿದೆಯಾ?
Wire tap.
Stay
ಆಗಿದೆಯಾ?
No, my lord.
ಮತ್ತೆ
It's not.
My lords,
ವೈರ್ ಟ್ಯಾಪಿಂಗ್. Yes.
short accommodation, my lords.
Oh.
There's an interim order, my lords, which is.
ವೇರ್ ಇದ್ರಲ್ಲಿ ಇದೆಯಾ?
ಇದರಲ್ಲಿದೆ. My lord, in the
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನಾಗಿದೆ?
I'll have to.
ಇನ್ನು
ಒಂದು ವರ್ಷ ಆಗಿದೆ.
admission ಗೆ ಬಂದಿಲ್ಲ.
Yes.
My lord,
It
case
will
number
repeat Monday, Tuesday, all days. Yes.
Please.
Till you finish your argument, it will get repeated. List the matter on Tuesday.
interim order.
Interim order would continue till the disposal of the petition. Okay. Next. Madam, ಮತ್ತೆ time ಇಲ್ಲ. Tuesday you have to finish. Yes, next.
Petitioner Benny. The accused number 3 and 13 are before this honorable court. My lord, the offence is 420 and 119 of Karnataka Education Act. Already accused.
ಬೇರೆ ಕ್ವಾಶ್ ಮಾಡಿದೀವಲ್ಲ.
ಹೌದು, please.
Yes, madam. ನೋಡಿಲ್ವಾ?
This page number 91 and.
Sorry, Jagdish is not there?
So he's,
Jagdish is not there.
he's there
Where
in
is-
some other court.
Ask him to come, I'll pass it over. Yes, pass over. Yes, next.
21.
7A na?
Yes.
7A or 13?
No, serial 21, my lord.
Oh, 21, sorry, yes. 498A?
Yes, my lord. 498A and 376 POCSO, my lord. My lord, in this case, my lord, victim has turned hostile.
Cancellation of bail bond, I had stayed.
Yes, my lord. My lord, all co-accused are acquitted, my lord. I have produced memo.
All
And she
co-accused, your accused number?
accused number 1 and 2, my lord. All co-accused are acquitted, my lord. The victim has turned hostile and she has refused her complaint and her 164 statement is also.
No, I have not stayed the proceedings.
No, my lord.
What happened to the proceedings after that?
My lord, it's still going on against.
Let it go on.
My lord.
Oh, this is that the victim had an affair with someone else.
Yes, my lord. And she is married and she has a kid also. And that birth certificate is also produced, my lord.
ಆಯ್ತು ಇರ್ಲಿ ಬಿಡು ನಡೀತಾ ಇದೆಯಲ್ಲ ಅಲ್ಲಿ ವಿಲ್ ಗೆಟ್ ಅಕ್ವಿಟೆಡ್ ಡೋಂಟ್ ವರಿ all accused have got acquitted based on Friday, next Friday. Yes.
20th.
20th, yes.
22.
Appear for the respondent, my lord, in this case. Objection is ready, my lord. I'll file it in the counter, my lord.
Petitioner is second division assistant. He was
Interim-
arraigned A3.
Interim order ಕೊಟ್ಟಿದೆ.
ಕೊಟ್ಟಿದ್ದೆ. A1 ಗೆ ಕ್ವಾಶ್ ಆಗಿದೆ.
ಆಯ್ತು.
A2 ರಿಟೈರ್ ಆಗಿದ್ದಾರೆ.
Objection
Objection
ಬಂದ್ಬಿಟ್ಟು.
ready ಇದೆ. We'll file it in the counter, my lord.
The learned counsel Sri B.B. Patil seeks a week's time to file statement of objections.
Date may be fixed, my lord.
Objections if any.
Date may be fixed, my lord.
Objections if any by the next date. List on 12th. Yes, next is.
23.
This offense for the punishable under section 294, 504, 506. Short point is that, my lords, there is a dispute between the petitioner and the respondent.
295.
294.
Four.
Kindly see page number 43, my lords. That's column number 17. None of the ingredients of the offense that is mentioned in
Page number?
43.
I appear in 23.1, madam.
ನೀವು ಯಾರಿಗೆ ಮೇಡಮ್ 70 sorry
23.1.
connected cases accused number yes tell me
ದೋಷಾರೋಪಣೆ ಪಟ್ಟಿ ಕಾಲಮ್ 12 ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಆರೋಪಿತರು ದಿನಾಂಕ ಸ್ವಯಂಸೋ ರಂದು ಮಧ್ಯಾಹ್ನ ಸುಮಾರು.
you are A1 is it?
Yes, my lords.
A1 and A3 what happened to A2?
He is abroad, my lords. He has not received a summons yet.
All right.
JC Nagar Police Thana ಸರಪದಿನ ನಂದಿದುರ್ಗ ರಸ್ತೆ ಎಂಬಸಿ ಅಪಾರ್ಟ್ಮೆಂಟ್ ನ ಮುಂಭಾಗದಲ್ಲಿ ಮಳೆ ನೀರು ಕೊಯ್ಲು ಮಾಡಲು ಹೊಂಡವನ್ನು ತೋಡಿದ್ದಾರೆ. ಈ ಬಗ್ಗೆ ಸಾಕ್ಷಿರವರು ದಿನಾಂಕ ರಂದು ಕೂಲಿ ಕಾರ್ಮಿಕ ಗುರುಪರೊಂದಿಗೆ A1 and A2 ಹಾಗೂ A3 ಆರೋಪಿತರು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಮುಂಭಾಗದ ಜಾಗದಲ್ಲಿ ಗುಂಡಿ ತೊಡುವುದನ್ನು ಕಂಡು ಮಳೆ ನೀರು ಸಂಗ್ರಹಿಸಲು ಹೊಂಡ ಈಗಾಗಲೇ ಇದೆಂದು ಪ್ರಶ್ನಿಸಿದ್ದಕ್ಕೆ ಆರೋಪಿತರು ಸಾರ್ವಜನಿಕ ಸ್ಥಳದಲ್ಲೇ ಅಶ್ಲೀಲವಾಗಿ
Yes, don't read that. Yes.
Yes, my lords. These are the only allegations that are there against the petitioners, my lords, and they have invoked section 294, my lords. Now 294 deals completely with a different
That's
topic.
the only offense alleged?
That is the only 294, 504 and 506.
Not for 506.
That's the only offense that's alleged against the petitioner.
What is 294 read?
Obscene 294 obscene acts and songs whoever to the annoyance of others does any obscene act in any public place or sings, recites or utters any obscene song, ballad or words in or near any public place shall be punished with imprisonment of either description for a term which may extend to 3 months or with fine or both. None of the offenses are made out, my lord.
Really?
In this case, my lord, kindly peruse the order sheet dated 7/3/2025, my lord.
Order sheet.
In the order sheet, the learned counsel, 7/3/2025, my lord.
7/3/25.
The learned counsel for the petitioner submit
Ah.
that the private
Babu
complaint
Venkatesh.
did not accompany with the affidavit as was necessary in law in the light of the judgment of the apex court in case of Babu Venkatesh, the court has observed, my lord. So we have filed the affidavit, sworn statement by affidavit, my lord.
Really, private complaint jotega?
Yes.
Ellide?
Along with the affidavit, we have filed the affidavit.
Where?
Yeah.
On record, my lord.
They are not
It's
produced
not,
the-
it's not on record. We have applied for it. It's not there.
No.
Even
No,
in the record.
where is the
Private complaint is.
certified copy apply ಮಾಡಿದ್ರಾ?
No.
Yes.
Order sheet ಇದೆಯಾ?
Order sheet is there.
All right, that's all right.
Affidavit
Yes.
already filed, my lord.
Where is it, sir?
Certified copy I have taken from the trial court.
ಕೊಡಿ ಅದು.
Madam. In my affidavit, I have clearly mentioned, my lord, on 1/3/2023, what happened. I am residing in the ground floor of the same apartment, my lord. They are residing in the third floor of the same apartment. So they are harassing me, my lord, by insulting me, my lord, in the para 7 stated that intent to harm and hurt, which is causing headache, lots of tears, praying to God to make it go away and isolation.
This is
It is a
sworn
mental-
this is sworn statement. Sir.
Along with the.
This is sworn statement. Where is the affidavit with accompanying the private complaint? Where is the private complaint?
It's there, my lord. I have
ಇದು ಆಮೇಲೆ
annexed it.
ಆಗಿರೋದು. Private complaint.
No.
Three
Private
things
compla-
you should satisfy. One is you have approached the jurisdictional police under 154(1). They have not registered. You have approached the superintendent of police under 154(3). They have not registered. So you are going before the magistrate under 200, and all those averments should be made in the affidavit accompanying that private complaint. Where is that?
Along with the PCR only, we have filed the affidavit.
Where is it? It is sworn statement, sir.
No, the sworn statement is recorded by the court.
That is later. That is later.
That this is not a
Where
sworn
is the
statement.
certified copy apply ಮಾಡಿದ್ರೆ in procedure? Yes, order sheet.
This I have applied, my lord.
Yes, where?
It's not there, my lord. Whatever copy we have got is the one which is there from 26 to 31, my lord.
Page number?
Page number 26.
Where is the 156(3) order?
156(3) order is in page number 70, my lord.
17.
70.
1 minute.
The 70, my lord. The
1
complaint.
minute. 1 minute. The registry is directed to secure the records pertaining to PCR ಏನದು?
PCR number in page 26. PCR number.
PCR 12196 of 2023, along with the entire file by telephonic instruction. List on 12th.
Great.
Interim order subsisting will continue till the next date of hearing.
Great.
Both A1 and A3 ಅಲ್ಲ?
Madam,
12th. ಅದು ಕೊಡಿ ಅವ್ರಿಗೆ ವಾಪಸ್. Huh?
The only urgency is that it's been going on for some time, my lord, and.
Interim order ಇದೆಯಲ್ಲ?
Please, my lord. But,
Then what going on? How can the proceedings go on if there is an interim order?
No, my lord, in the sense that it's causing a lot of hindrance to the.
That's what, till 12th, wait.
Please.
List on 12th.
My lord, apologies, my lord. Previous matter, my lord, I may pray for 16th. 12th, I have a little inconvenience. There's a family function.
Right.
16th, obliged.
16th, 17th. 17th.
Right.
Yes. Yes, next.
24.
Going for the petitioner's matters, my lord. Very short questions is there, my lord, and the application filed by the second response under section 451 and 427 allowed. And directed to him to release the amount of 6.5 crores.
6.5 crores.
Please, my lord.
You are not heard in the matter?
No, my lord.
It's already released?
Already released, he had to enjoy the amount.
4 point something is released, my lords.
Again, he claimed one more complaint has been
What
filed.
is that amount for?
The amount for is, my lord, they have demanded, according to the complaint, my lord, that you have demanded 10 lakhs rupees.
Defrauded 10 lakhs.
Demanded.
Demanded 10 lakhs.
10 lakhs rupees to release the
It's a
second
kidnap
respondent
case,
for
my lord.
kidnapping.
I'll get back. Yes.
According to the complaint, my lord, what he says, the total demand of is 10 crores. Kidnapping him and release him. Out of that, my lord, he has paid 6.5 crores. Through the petitioner.
6.5 crores is seized.
Seized, my lord. Out of 6.5 crores, my lord, 8
Yes,
crores.
Jagdish, without hearing, how can it be done?
Trial court, Your Worship, is
Ah,
in
it's-
Axis Bank case, many times. Though
Without hearing them, it could not have been done at all. Agle 4.5 crores aitega.
Released, my lords.
Huh?
It was heard and released, and they have
No, no,
approached
no,
after
only the
lapse
prosecutor.
of 4
Where is the
years.
order?
Your
Where is-
Lordship's annexure, kindly see page
Where is
number,
the orders?
page number 14, my lord.
1-4.
Operative portion is page number 15.
to heard the accused, not the.
I have filed
that's what
his report.
heard the
APP
senior
only.
APP.
APP only.
This can't be done at all. Every case, this is being done.
Your lordship, my senior will argue on short.
No, no, senior, yes. I'll pass it over if you want.
All
Let
three
him-
matters, my
In
lord.
family function, your lordship, Monday or Tuesday, your lordship.
Heard the learned counsel appearing for the petitioner. The issue in the list revolves around an order passed by the concerned court answering an application under section 451 and 457, by which the concerned court transmits rupees 4.5 crores without hearing the petitioner.
4.82, sir.
4.82 crores without hearing the petitioner on without hearing the petitioner answering the aforesaid application and hearing the complainant and the state. Therefore, prima facie, there is blatant violation of principles of natural justice in taking away the money belonging to the petitioner and handing it over to the complainant.
Your lordship.
The learned counsel for the complainant seeks 2 days' time. List on Tuesday. Yes.
Good.
All three. Ella same, huh?
Different PS numbers.
25.
I prepare for the petitioners, your lordship. The
I took the second respondent, my lord.
7 and 9, 7 and 8, your lordship, that.
Quashed.
Yeah.
I have quashed.
No.
No stay granted, my lord.
Not yet.
Good.
The offense under section 109, your lordship, that our charge sheet was filed 109, 351 class 3, 352, 61, 55, 329 class 3, 3.
109 is 306. Abetment
307. 307. These petitioners are not present at the spot, your lordship. They are alleged that they are abated this one here, that's a civil dispute
Why
regarding.
has it come before me?
Earlier, I filed a petition, your lordship, that thereafter I withdraw the petition because the charge sheet was filed, your lordship.
Oh.
Meanwhile, it is not posted, your lordship.
No problems. Tell me.
Yes. The complaint, your lordship, in page number 18, your lordship, that.
18.
18, your lordship, that. ಈ ತಿಂಗಳು ಸುಂದರರಾಜ್ ಅವರಿಗೆ ಸೇರಿದ 700 ಸಮೀಪದ ಸರ್ವೆ ನಂಬರ್ 67 ಕಂಟ್ರಿ ಕ್ಲಬ್ ಮುಂಬೈ ಸತ್ತಿನಲ್ಲಿ ಸೆಕ್ಯೂರಿಟಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿರ್ತೇನೆ. ಸುಂದರರಾಜ್ ಅವರು ಈ ಸತ್ತಿನಲ್ಲಿ ಹೀಗೆ ಸುಮಾರು 3-4 ತಿಂಗಳಿಂದ ಹಾಜಿರಾ ಸೆಂದಿಲ್, ಮೋಹಸ್ ರವಿವನ್ನಂ, ಚೆಲ್ಲೂರಿ ವೆಂಕಟೇಶ್ವರು, ಶಕೀಲ್ ಜಗತಮ್ಮ ಜಾಫರ್ ಆಗಿ ಬಂದು ಗಲಾಟೆ ಮಾಡಿ ಸ್ವತ್ತನ್ನು ಖಾಲಿ ಮಾಡುವಂತೆ ಬೆದರಿಕೆ ಹಾಕಿದ್ದು ಈ ವಿಚಾರವನ್ನು ಸ್ವತ್ತಿನ ಮಾಲೀಕರ ಸುಂದರರಾಜ್ ಅವರ ಗಮನಕ್ಕೆ ತಂದಿದ್ದೇನೆ. ಹೀಗಿರುವಲ್ಲಿ ದಿನಾಂಕ 1/7/24 ರಾತ್ರಿ 11 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಸ್ವತ್ತಿನ ಮುಖ್ಯ ಗೇಟಿನ ಬಳಿ ಸೆಕ್ಯೂರಿಟಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಬೇಕಾದರೆ ಶಕೀಲ್ ಮತ್ತು ಜಾಫರ್ ಅವರು ಬಂದು ಈ ಸ್ವತ್ತು ಹಾಜಿರಾ ಮತ್ತು ಕಡೆಯವರಿಗೆ ಸೇರಿದಾಗಿರ್ತದೆ, ಜಮೀನಾಗಿರ್ತದೆ, ಖಾಲಿ ಮಾಡುವಂತೆ ಅಮ್ಮನಾಕನ ಬೈದಿರ್ತಾರೆ. ಶಕೀಲ್ ಲಾಂಗ್ನಿಂದ
ಓದಕ್ ಹೋಗ್ಬೇಡಿ. ಆತರ ಇದ್ರೆ ಓದ್ಬೇಡಿ. ಬೇರೆ ಎಲ್ಲ ಓದ್ಕೊಂಡ್ರಿ.
ನನ್ನ ತಲೆಗೆ ಸಾಯಿಸುವ ಉದ್ದೇಶದಿಂದ ಹೊಡೆಯಲು ಬಂದನು. ಆಗ ನಾನು ತಪ್ಪಿಸಿಕೊಂಡಿದ್ದು ಆ ಲಾಂಗ್ ಏಟು ನನ್ನ ಎಡ ಮೊಣಕೈಗೆ ಬಿದ್ದು ಮೂಳೆ ಕಟ್ಟಾಗಿದೆ. ಸಮೀಪದ ಸೆಕ್ಯೂರಿಟಿ ರೂಮ್ ಬಳಿ ಇದ್ದ ನಮ್ಮ ಸೂಪರ್ವೈಸರ್ ನಂದಕುಮಾರ್ ಮತ್ತೊಬ್ಬ ಸೆಕ್ಯೂರಿಟಿ ಸುರೇಂದ್ರ ಅವರು ಜಗಳ ಬಿಡಿಸಲು ಬಂದು ಅವರಿಗೆ ಸಹ ಶಕೀಲ ಮತ್ತು ಇತರರು ಸೇರಿಕೊಂಡು ಲಾಂಗ್ ಮತ್ತು ಚಾಕುವಿಂದ ಹೊಡೆದು ಗಂಭೀರ ಗಾಯಗೊಳಿಸಿ ನಮ್ಮ 3 ಜನ ಸಾಯಿಸಲು ಪ್ರಯತ್ನಿಸಿದ್ದಾರೆ. ನಂತರ ನಮ್ಮ 3 ಸೆಕ್ಯೂರಿಟಿ ಕೆಲಸ ಮಾಡುವ ಕುಟ್ಟಿ ಮತ್ತು ಮೂರ್ತಿ ಸರಳಾಗಿ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದೊಯ್ದು ಚಿಕಿತ್ಸೆ ಕೊಡಿಸಿ ನಂತರ ಹೆಚ್ಚಿನ ಚಿಕಿತ್ಸೆಗೆ ಪ್ರೊಲೈಫ್ ಆಸ್ಪತ್ರೆಗೆ ದಾಖಲಾಗಿ ಚಿಕಿತ್ಸೆಗೆ ನನ್ನ ದಾಖಲು ಮಾಡಿ ಹಾಜಿರಾ ಸೆಂದಿಲ್, ದಟ್ಸ್ ಒನ್ ಆಫ್ ದಿ ಪಿಟಿಷನ್. ಸೆಂದಿಲ್, ಮೋಸಂ, ರವಿಮನ್ನು, ಚಿಲ್ಲೂರಿ ವೆಂಕಟೇಶ್ ಅವರುಗಳು ಇನ್ನೊಂದು ಪಿಟಿಷನ್ ಹೆಸರೇ ಇಲ್ಲ. ಕುಮ್ಮಕ್ಕಿನಿಂದ ಶಕೀಲ್, ಕುಮ್ಮಕ್ಕು ಮಾತ್ರ.
This I had considered in sitting in LB.
Or my lords?
In 2020, I think I had passed some order sitting in LB.
My lords, I'll have to verify that.
Oh, please don't verify. Yes. Continue, sir.
Your lordship, that these petitions are not present. There's only allegations that they are abated. Your lordship, that the
Plea
petition,
of LEB only matter of evidence.
your lordship, petition number 1, his name is not mentioned. Either he is not abated.
You are A3 and A7, correct?
No. A7 and 8. 8 ಅದು.
A8
8 so.
ಮತ್ತೆ 3 ಅಂತ ಬರ್ಕೊಂಡಿದ್ದೀರಿ.
3 ಅದು ಟೈಪೋಗ್ರಫಿ.
A7 and 8.
8. Your lordship, that in the charge sheet also it mentioned that only abated. The accused number 7.
Advocate. Who is advocate?
Abated ante. Abated. In the charge sheet also is only mentioned the abated because there is a civil dispute, right? Because they are the owners, they are the implicated as a falsely, your lordship. That these petitions are not all present at this spot, your lordship. That that's allegation. Even accused number 7 is not mentioned in the FIR, your lordship. That
Wait. Yes.
FIR is not visited the spot also either prior to the 3 months or the after that 3 months, your lordship. That there is no mention in the accused number 7 petition number 1 name. This is only civil dispute, your lordship. After the, your lordship, that in page number, your lordship, that the writ petition was, order was passed 168. The order was passed by the clubbing of the another case, your lordship. That they are filed this case against these petitioners because they are the landowners, your lordship. That
168.
168 ಅಲ್ಲಿ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಇನ್ನೊಂದು ಇದನ್ನ ಕೇಸನ್ನ this petition, one of the accused was approached this on court, your lordship.
LR, sir. Yes.
One of the petition, the accused was approached this on court. They are clubbing of the another case, your lordship. They are pending before the another court. Thereafter this,
you are on offense of 307.
307 other accused, your lordship. This petition number 1 is not at present and there is no mention of FIR, your lordship. That
FIR ಇಲ್ಲ ಅಂತ ಚಾರ್ಜ್ ಶೀಟ್ ಇರಬಾರ್ದು ಅಂತಿದ್ಯಾ?
Because it's a civil dispute, your lordship, that they are not present at this spot.
Civil dispute is not a license for attempt to murder.
If they are present at this spot, your lordship, that if they are present at this spot, but if they are not present, you are
There are plethora of
between the
witnesses as well,
security
my
officers.
Wait. Yes.
Between the two security officers, your lordship, that there is a quarrel. That's not the owners.
67. Second paragraph.
Eyewitness.
Yes. Senthil.
ಆಗ ನಮ್ಮೊಂದಿಗೆ ಸೆಕ್ಯೂರಿಟಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ಕುಟ್ಟಿ ಮೂರ್ತಿ
Superaju, Senthil, both came and threatened them.
ಥ್ರೆಟೆಂಡ್.
Next day.
ಚೆಕ್ ಶರ್ಟ್ ಅನ್ನು ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಖಾಲಿ ಮಾಡದಿದ್ದರೆ ನಿಮ್ಮನ್ನು ಮತ್ತು ನಿಮ್ಮ ಮಾಲೀಕರಿಗೆ ಒಂದು ಗತಿ ಕಾಣಿಸ್ತದೆ. Who is this eyewitness?
Next witness also speaks the same.
Huh?
Next page also, 69.
Correct. Who is this eyewitness?
He is the security supervisor. Next witness is security.
11 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಾವು ಸುಂದರರಾಜ ಜಮೀನಿಗೆ ಸೆಕ್ಯೂರಿಟಿ ಆಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದಾಗ ಅಲ್ಲಿಗೆ ಬಂದು ಈ ಜಮೀನನ್ನು ರವಿಕುಮಾರ್ ಸೋರ್ಸ್. And charge sheet ಅಲ್ಲಿ 7 and 8. Yes, sir. File discharge.
Liberty may be given, lordship.
307 will not interfere.
Please.
The learned.
Maybe post it after 2 weeks, but I'll find my detailed objections. Apologies.
Yes. The learned counsel for the petitioner, after arguing the matter at length, would seek leave of this court to avail the remedy of filing a discharge before the concerned court. The liberty so sought is granted. In the event the petitioner would file an application seeking their discharge, the concerned court shall answer the same on its merit.
Please, much obliged.
Much.
Ordered according. With the aforesaid observation, petition stands disposed, ordered according.
26.
Please, Lord. Lord, company's mismanagement. Lord, on the allegations of misappropriation, PCR, Lord, was filed.
ಎರಡು ಕೇಸ್ ಇದೆಯಲ್ಲ? Who's for the respondent state?
Yes, Your Lordship.
Complainant ಯಾರು? ಜಗದೀಶ್ ಸರ್ ನೀವೇನಾ?
Private individual. Respondent number 2.
ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
ಆಗಿದೆ.
ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್. ಆಗಿಲ್ವಾ? ನೋಟಿಸ್ ಆಗಿಲ್ಲ.
Notice and not been issued, Your Lordship. In the year 2022.
There is no interim order also.
Lord, there is no interim order.
Lordship, when Your Lordship was sitting in Kalburgi bench, at that time Your Lordship has told that the
ಕಲಬುರ್ಗಿ ಬೆಂಚ್ 21 ಅಲ್ಲಿ ಕೂತಿದ್ದು ನಾನು. ಧಾರವಾಡ.
The first petition, the petitioner in first petition, he is the petitioner in petition of.
Correct, but notice ಆಗೇ ಇಲ್ಲ ಯಾವ್ದ್ರಲ್ಲಿ.
Yes, yeah, notice hanging.
The learned additional SPP is directed to accept notice for the first respondent, emergent notice to the second respondent, returnable by the
Lord.
27th.
One indulgence, Lord. PCR, Lord, without affidavit, not following proposition.
Where is
of
the
Srivatsa.
PCR?
Page number 21, Lord.
Page 21,
Very verification, huh?
verifying. Yes, only verification is given.
Call for, where is the order under 156(3)?
Next page, Lord, page 30. Call for report.
When was this? 2022?
Please, Lord.
Yes, Your Lordship.
Notice the offense charge sheet ಆಗಿದೆಯಾ?
Fine, 406, Your Lordship. That is the main offense.
Companies Act.
Yes, Your Lordship. The matter was pending for the NCLT and more on Lordship, in this case.
Charge sheet was filed 2023. 2023 charge sheet is filed.
But ಎಲ್ಲಿದೆ affidavit?
Two judgment says that. Once the
That
charge
is
sheet
reversed
is
by
filed.
Supreme Court. What I had held is reversed by Supreme Court. Charge sheet ಆದ್ಮೇಲೆ ಆಗಲ್ಲ ಅಂತ. Goes to the root of the matter. We'll see. The petitioners accused
Five, my Lord.
Accused number 1, Your Lordship.
1 and 5.
Accused number 1 to 4.
ನಿಮ್ದು?
I am for 5.
1 to 5, my Lord.
Accused number 1 to 5 in these two petitions are at the doors of this court, calling in question the registration, the proceedings in CC
755 of 2020.
proceedings in CC 755 of 2024 registered for offences punishable under section 1 ಅಲ್ಲಿ prayer ಇದೆ madam, page 16 prayer. The learned counsel for the petitioner takes this court through the documents appended to the petition, seeking to demonstrate that the crime is registered pursuant to the order of reference of the learned magistrate under subsection 3 of section 156 of the CRPC and CRPC in a private complaint that did not accompany to itself an affidavit as is necessary in law. There is no narration in the complaint also that they have approached the jurisdictional police at the outset as obtaining under subsection 1 of section 154, and the jurisdictional police have not acted upon the said complaint, and then they have approached under the higher authority under subsection 3 of section 154 of the CRPC. In the light of so and so, there it is an altogether different circumstance that it is besides the point that a charge sheet is also filed pursuant to the investigation by the police. The non-filing of an affidavit would cut at the root of the matter in terms of the law laid down by the apex court in the case of Babu Venkatesh versus State of Karnataka, reported in 2022 SCC online SC page 200. In that light, there shall be an interim order of stay of further proceedings in CC 755 of 2024. One additional SPP 2 emergent notice returnable by the 4th of July, list the matter on 4th of July. The registry is directed to secure the trial court, the records in PCR, so and so, number, PCR number in
235/22.
In PCR number 235 of 2022 from the concerned court by telephonic instructions. Huh?
57.
Hmm. Then by the successive return as per circular, correct. No representation behalf of the petitioner. There was no representation behalf of the petitioner on 21/4/2025. Even today, there is no representation behalf of the petitioner.
The charge was framed on 23/10/2024.
23/10?
2024.
The learned additional SPP submits that the charges in the case at hand were framed on 23/10/2024 and the trial is on. The subject petition is preferred on 20th December 2024, long after the charges being framed by the concerned court. In that light, the subject petition would not be cannot be entertained in the light of the judgment of the apex court in the case of Meenakshi Bala versus so and so. Kelly madam kodtare. So in that light, petition stands disposed, reserving liberty to the petitioner to urge all the contentions before the concerned court at the relevant point in time. Ordered accordingly. Next.
28.
The alleged offences 376/420.
376/420.
376/420.
ಎಷ್ಟು ವರ್ಷ relationship?
8 years.
8 years. Served unrepresented?
Yes, yes.
Yes.
Both the first petitioner and the respondent number 2
promised to marry, yeah?
Yes, promised to.
Yes,
and also residing in the same roof since 2024 May.
Same roof?
Same. ಒಂದೇ ಮನೆಯಲ್ಲಿ.
ಒಂದೇ ಮನೆನ?
That is page number.
Promise guarantee ಮಾಡಿರ್ತೀರ ನೀವು?
89, page number 89, rental agreement. 90, she mentioned, this is the prosecution document in the charge sheet. She mentioned Srimati Rupavati, aged about 26 years, wife of Shashank. That is first petitioner.
Wife of Shashank.
Wife.
ಮದುವೆ ಆಗಿದ್ದೀರಾ ಹಾಗಾದ್ರೆ?
ಮದುವೆ ಆಗಿದೆ. ಆಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟರಲ್ಲ ಹಾಗೆ.
Rental agreement.
Rental agreement.
Rental agreement.
Wife of who is Shashank? Petitioner is not who, you are Shashank.
Petitioner number 1.
Who are the other petitioners? Idara?
His mother. 2 is mother. 3 is neighbor.
Neighbor?
Neighbor.
Why?
He advised them. He participated in the marriage talks. The engagement ceremony performed on 14/4/24.
14/4/24.
14/4/24.
Why did it fail?
Because of some misunderstandings in pertinent to marriage expenses.
Now you are ready to marry?
By the time he was genuine intention to marry her.
Now you have no intention.
She sent me to jail also.
I'm genuinely not interested.
Genuinely not interested.
And marriage.
So from the beginning you had no intention to marry.
There was intent. In fact, she was a widow. She lost her husband in the year 2016 itself.
Oh, you have taken advantage of that.
No. She's my childhood friend, according to prosecution.
Oh, all the more dangerous. Yes. All factors correct agide trial ge.
And the marriage date fixed on 16/17/11/2024. The second petitioner paid the advance amount to the chowdhury as well as beautician as well as the
chowdhury as well as
beautician. And photographer.
Oh, pre-wedding shoot.
Pre-wedding. In the month of February 2024 itself. In fact, my lord, the marriage, there was a panchayat among the family members in the month of December 2023. On that day itself, they fixed the marriage. Being a mother, the second petitioner, my lord, paid all the advance amounts. Later, in the month of March, there was some misunderstanding. pertinent to the marriage expenses. Because she don't have husband, she is a widow. The second petitioner is.
ಅದಕ್ಕೂ ಎಕ್ಸ್ಪೆನ್ಸಸ್ಗೂ ಏನ್ ಸಂಬಂಧ?
ಅವ್ರ ಹತ್ರ ದುಡ್ಡಿಲ್ಲ. ಇಷ್ಟೆಲ್ಲ ಕೊಟ್ಟಿದೀವಿ. ಮ್ಯಾರೇಜ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್, ಚೌಲ್ಟ್ರಿ ಕೊಟ್ಟಿದೀವಿ, ಬ್ಯೂಟಿಷಿಯನ್ ಕೊಟ್ಟಿದೀವಿ,
Childhood friend, you should have been magnanimous.
She is a teacher.
He is a teacher.
He is a teacher.
So what?
More reason.
So,
More reason to be magnanimous.
merely the marriage was not performed as on the date, fixed date. She lodged this.
ಅದಕ್ಕೆ ಕೇಳಿದ್ದು ಇವಾಗ ಮದುವೆ ಆಗ್ತೀರಾ ಅಂತ. ಹೆಂಗು 1 ವರ್ಷ ಆಗಿದೆ ಅಷ್ಟೇ ಇದೆಲ್ಲ.
ಜೈಲಿಗೆಲ್ಲ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಜೈಲಿಗೆಲ್ಲ ಹೋಗಿದ್ದಾರೆ.
ಅದಕ್ಕೆ ಕೋಪನಾ?
ಕೋಪ ಅಂತೇನಿಲ್ಲ, ಮಾತುಕತೆ ಮಾಡ್ಬೋದು ಸ್ವಲ್ಪ ಬೇಕಾದ್ರೆ.
ಮದುವೆ ಮಾಡ್ಕೊಂತೀರಾ?
ಕೇಳ್ಬೇಕಷ್ಟೆ. She is not interested. He is 3 years younger than her.
23 years ಅಷ್ಟೇನಾ ನಿಮ್ಗೆ? The petitioners accused 1, 2 and 3. Madam, ಯಾವಾಗ ಸರ್ವ್ ಆಗಿದೆ ಅಂತ ನೋಡ್ಬಿಡಿ. Accused 1, 2, 17th? 17/4. 2025. Should we give another opportunity?
Next week maybe.
Because 17/4 ಆಗಿರೋದು. Interim order ಇಲ್ವಾ?
Interim.
17/4 ಸರ್ವ್ ಆಗಿದೆ. ಒಂದು ಡೇಟ್ ಕೊಡೋಣ. The petitioners are accused 1, 2. ಇಲ್ವಾ? ಇಲ್ಲ, ಆಗೋಗಿರ್ಬೇಕಲ್ಲ. ಇದೆಯಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ. Detailed interim order. This court on 2/4/2025, while issuing emergent notice to the respondent, has granted an interim order of stay of further proceedings. The complainant is said to have been served on 17/4/2025. Therefore, I deem it appropriate to grant one more opportunity for representing herself. List the matter on 20th. Interim order subsisting will continue till the disposal of the petition. Next.
29.
Kindly have next week. Instruction to file a wakalat. Kindly short date or 2 months. Defect account.
ಹಾಕಿದ್ದಾರೆ. ಏನಿದೆ offense?
Offense is 406 and 420, my lords. There is a CBI case ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ.
ಆಯ್ತು, ವಕಾಲತ್ ಹಾಕಿ. The learned counsel so and so undertakes to enter appearance for the second respondent. Registry to print the name of so and so is appearing for the second respondent. List the matter on 20th. Objections if any by then. 20th ಸಾಕ 27th ಹಾಕ್ಲಾ?
27th.
27th. Objections if any by then. Interim order subsisting will continue to the next date of hearing. Yes.
30.
For the petitioner in the connected matrimonial.
ನಾಲ್ಕಿದೆ.
Please, my lord.
What's this?
My lord, offences under 420, 506, 341, 324 and under the banning of unregulated deposit schemes act, my lord. In fact, the petitioners in the second and third petitions are also depositors.
ಆಯ್ತು, respondent served.
5.
Please, my lord.
ಯಾವತ್ತು ಸರ್?
5.
5. This court, in terms of the order dated 7/4/2025, owing to the fact that the companion petitions had all had the benefit of interim order as granted by the coordinate bench, granted an interim order in the case at hand as well. The complainant has been served on 5/5/2025. Therefore, to give one more opportunity for the complainant to get herself represented or appear as the case would be, list this matter on 27th. Interim order subsisting shall continue till the next date of hearing. Next.
31.
ಇಬ್ರಿದ್ದೀರಾ?
I am a Swandak.
All right.
Prosecution against a public servant, my lord, without sanction.
Sanction. 354 sanction ಯಾಕೆ ಬೇಕು ಸರ್?
But it's a public servant, my lord, while.
ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ ಆಚೆ ಕಡೆ ಏನ್
Alleg-
ಮಾಡಿದ್ರೆ
alleg-
ಸ್ಯಾಂಕ್ಷನ್ ಬೇಕು?
Allegation, my lord, while
In
discharging
the
is.
course of discharge of official duties, 354A is sexual harassment against a woman. That is in the course of discharge of official duties.
354 and 366, my lord,
366, ಆಯ್ತು.
charge sheet is submitted.
ಎರಡು ಕೋರ್ಸ್ ಆಫ್ ಅಫಿಷಿಯಲ್ ಡ್ಯೂಟೀಸ್. ಮತ್ತೆ
On the date of the alleged incident, my lord, was on.
Witness ಅಲ್ವಾ victim ಅದಕ್ಕೆ.
ಓ ವಿಕ್ಟಿಮ್ ಇಸ್ ವಿಟ್ನೆಸ್.
Even, my lord, order of taking cognizance, my lord, is without touching the facts of the case. It is
ಏನ್ ಕಾಗ್ನಿಸೆನ್ಸ್
cognizance.
ಅದು ಬೇಕಾಗಿಲ್ಲ ಈಗ ಇನ್ ದಿ ಲೈಟ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇನ್ ಪ್ರಮೀಳಾ ದೇವಿ.
And in the case of Inox Air versus state of.
ಯಾವುದು?
Inox Air versus state of Andhra Pradesh.
ಐನಾಕ್ಸ್ ಹಳೇದಾಗೋಯ್ತು.
Recent judgment on notice.
Pramila Devi's latest judgment where order of cognizance, if it suffers from non-application of mind, it does not vitiate.
I'll look at the said judgment next week.
ಏನ್ ಲುಕ್
Next week.
ಬೇರೆ ಏನ್ ಗ್ರೌಂಡ್ ಇದೆ ಹೇಳಿ?
The major ground ಇವೆರಡು ಇದೆ ಅನ್ಕೊಂಡ್ ಬಂದಿತ್ತ ಮುಂದೆ.
ಏನಿಲ್ಲ ಇದು. ಸ್ಯಾಂಕ್ಷನ್ ಬೇಕೇ ಆಗಿಲ್ಲ ಇದಕ್ಕೆ.
I was under the
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಲ್ಲ?
Earlier round came before your lordship and then they
ಸೊ
withdrew it.
ಇದು ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಂಡ್ಬಿಡಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಅಬ್ಸರ್ವೇಷನ್ ವಿಲ್ ಡೆಫಿನೆಟ್ಲಿ ಕ್ರಿಯೇಟ್ ಅ ಪ್ರಾಬ್ಲಮ್.
I'll take instructions and.
ಯಾವ ಇನ್ಸ್ಟ್ರಕ್ಷನ್? ಐ ವಿಲ್ ಪಾಸ್ ಅನ್ ಆರ್ಡರ್.
13th.
ಐ ವಿಲ್ ಪಾಸ್ ಅನ್ ಆರ್ಡರ್. ಏನಿಲ್ಲ ಇದು.
Next week.
But if I give a finding of what you have done.
Please.
Police,
ಅಲ್ಲಲ್ಲ public prosecutor. Public prosecutor.
ಓ ಇದು ಲಾಡ್ಜ್ ಹತ್ರ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದು.
Yes.
ವಿವೇಕ್ ರೆಡ್ಡಿ ಅಪೇರ್ ಆಗಿದ್ರಲ್ಲ,
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿರ್ಲಿಲ್ಲ ಅವಾಗ.
ಪಾಪ ಪಿಪಿ ಅಂದ್ರು. ಅಂದ್ರೆ ಪಬ್ಲಿಕ್ ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಪಾಪ ಸಿಗಾಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅವರು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರ್ಬೇಕು, ಅಲ್ಯಾಕ್ ಲಾಡ್ಜ್ ಹತ್ರ ಹೋದ್ರು ಅಂತ ಗೊತ್ತಾಯ್ತು.
Allegation is that my lord, he was near. Next week it may be taken up, my lord. ಏನೋ ತಮ್ಮುಂದೆಲೆ ಬರ್ತದೆ ಅದೇನು.
ಅಲ್ಲ ಅಫ್ಕೋರ್ಸ್ ಇನ್ನೆಲ್ಲ ಹೋಗಕ್ ಸಾಧ್ಯವೇ ಇಲ್ಲ. ಎಸ್ 13th ಬೇಡ, 20ನೇ ತಾರೀಕು ಬರ್ಲಿ ಬಿಡಿ.
Please.
ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ.
ಕೊಡ್ಬೇಕಾ? ಪಬ್ಲಿಕ್ ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಎಲ್ಲಿರ್ಬೇಕು ಅಲ್ಲಿರ್ಬೇಕು. ಹಿಂದೆ ವಿಟ್ನೆಸ್ ಹಿಂದೆ ಲಾಡ್ಜ್ಗೆ ಯಾಕೆ ಹೋಗ್ಬೇಕು?
ಅವರೆಲ್ಲ ಪ್ಲಾನ್ ಮಾಡ್ಕೊಂಡು ಮಾಡಿರೋದು ಸ್ವಾಮಿ ಅದೆಲ್ಲ.
Why did you get trapped into that plan? ಅವ್ರೇನೋ ಕರೆದ್ರು ಲಾಡ್ಜಿಗೆ ಬನ್ನಿ, ನೀವ್ ಯಾಕೆ ಹೋದ್ರಿ? ಅದು ಕೋರ್ಟ್ ಅವರ್ಸ್ ಅಲ್ಲಿ. ಕೋರ್ಟ್ ಬಿಟ್ಟು ಕೋರ್ಟ್ ಅವರ್ಸ್ ಅಲ್ಲಿ ಯು ಫಾಲೋ ದ ವಿಟ್ನೆಸ್ ಅಂಡ್ ಗೋ ಟು ದ ಲಾಡ್ಜ್. ಅದಕ್ಕೆ ಕಂಪ್ಲೇಂಟ್ ಬಂದಿರೋದು. ಎಸ್
32.
Respondent number 2 in this matter.
My lord, petition seeking to squash the charge sheet for
Quash.
offences.
Quash.
Quash.
Squash. Yes.
For offences punishable under 409, 406, 468, 471 and 120.
I seek for a week's accommodation. I'll file my objections to the IA.
Charge sheet
Recently.
ಹಾಕಿದ್ದೀರಾ?
My lord,
Charge sheet is filed?
charge sheet is filed, my lords. The entire charge sheet is filed.
406, 420.
As far as the allegations are concerned, my lords, it is as far as the accused number 4 is concerned. Accused number 4 mortgages a property for the loans which are availed by a company where the petitioners are directors of the company. Now the company is not made a party in the charge sheet, my lords. The allegation is as far as the accused number 4, the property belongs to accused number 4 and the accused number 4 is the one.
Who are you, accused 1 and 2?
Accused number 1 and 2 are the directors of the company which has availed loans from the second respondent, my lords. We are no way concerned with the property nor the title deeds which are mortgaged in favor of the respondent number 2, my lords.
Yes, who are you?
And in
Complainant.
fact-
Hello, Nimsh.
My lords.
KSFC.
KSFC.
They have availed the loans.
Who?
By misrepresenting
Petitioners.
the petitioners. They have availed the loan and they got this lady, one Parvathamma, to get her property as collateral security. Third party collateral security has been given through these 1 and 2. There is a tacit understanding between 1 and 2 and also one Parvathamma.
ಏನ್ ಲೋನ್ ಏನಾಯ್ತು?
Malats, first of all, this property itself is not there. Malats, they have availed one submission.
what happened to section 29 proceedings?
One submission, my lords. Section 29 proceedings, this is NCD facility, what we have given. Section 29 proceedings came to be taken by another financial corporation, that is CSIIDC. This is whatever what we have extended is NCD facility, non-convertible debenture facility to the petitioner. I will file my objections to the IA.
But it will charge frame
Well, it's
agilva.
in charge sheet has already been.
Charge frame agilva.
Charge frame agilva.
Must have been 2017
Well,
charge
as
sheet.
far
sir.
as the accused number
PCR of
6.
2013.
Well, as far as the accused number 6 is concerned, my lordships have already squashed the charge sheet, my lords.
Page.
Well, it's in fact, I've produced the copy separately, my lords. On the last occasion, I produced the copy separately. 64448 of 2018. Lordships may kindly turn to page, paragraph number 13 at page 10.
Page number? Page
No, this is a document.
No, he was
Well,
legal head.
It is
Legal
held-
head go idukku
well,
sambandha illa.
it is held by my lords that the entire charge sheet is filed on the basis of the correspondences between the corporation and the police. Absolutely no material is on record, my lords. Absolutely no material.
File your objections, yes. List the matter. Ondwara?
1 week, my lords.
List the matter on 17th. Objections, if any, by the respondent, complainant by then.
Great.
Next.
33.
I am for the respondent number 2, my lord. Today I filed my wakalat.
Learned counsel so and so submits that he has entered appearance for the second respondent complainant. The registry to print the name of so and so is appearing for the second respondent complainant. 2 weeks, Becca?
Yes, my lord.
List the matter on 27th. Objections, if any, by the respondent by then. List interim order subsisting would continue till the next date of hearing. Next.
On submission, my lord. On submission, my lord. On seeing the online, it has been noticed that this matter is listed on 10/6 of 2025. He has been filed in a discharge application to 239 application before.
Hakidar already.
Hakidar.
But my lord, charge is not yet framed.
Discharge application
ಹಾಕಿದ್ದೀವಿ ಅದು ನಾನು accused number 2, my lord, I am the son of the accused number 1. Lord,
Discharge application
ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಹಾಕಿದ್ದೀನಿ.
ಅದನ್ನೇ ಪರ್ಸು ಮಾಡಿ ಮತ್ತೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇಟ್ಸ್ ನಾಟ್ ಎ ಮ್ಯಾಟರ್, my lord, to be continued because I am not no way connected with the accused firm, my lord. I am only a son.
ಹಾಗಾದ್ರೆ ಒಂದು ವಾರದಲ್ಲಿ ಹಾಕಿ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೊಂಡಿದ್ರಿ. ಐ ಟೇಕ್ ಇಟ್ ಆನ್ 20th.
2 weeks ಇರಲಿ ಸುಮ್ಮನೆ.
20th 2 weeks ಏನೇ ಸರ್? ಇವತ್ತು 6th 20th
27th it could be.
ಆಯ್ತು 27.
Interim ಮಾಡಬೇಕು.
ಹೇಳಾಗಿದೆ.
34.
Yesterday's matter.
Just wait, yesterday's matter. My lord, these provisions, order 21, rule 22 and order 21/35.
Your contention is if the execution is filed within 2 years,
Yes.
notice need not be issued.
No.
Not correct.
Covered by several
Oh,
judgments.
Kodi sir.
And one judgment of Delhi High Court.
Paragraph.
I'll Which one? Paragraph number 24, my lord. 24 and 25. Page 19, my lord.
24 and 25.
And Delhi High Court judgment is very clear on order 21, rule 22.
Idyavadu? Supreme Court.
This is Supreme Court.
This is not clear, is it?
This also clear.
Then
Yeah.
clarity ಎಲ್ಲಿದೆ ಹೇಳಿ.
Clarity.
Let me see. We'll pass orders on Monday.
Yes, ma'am.
Yes.
Because even under section 47 of.
Correct,
CBI.
correct. We'll see. Yes. I had seen something else. Yes. Monday.
35.
For petition, two other connected petitions has been not posted yet.
No, ಪರವಾಗಿಲ್ಲ ಏನು ಹೇಳಿ.
Senior ಇಲ್ಲ.
ಅದೇ ಹೇಳಿ ಫಸ್ಟ್ ಏನೇನೋ ಹೇಳ್ತೇವೆ. ಎಸ್ ಪವನ್.
Lord, the taxes.
ಗೊತ್ತು ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೆ ಆಮೇಲೆ ರೀಕಾಲ್ ಮಾಡಿದ್ಯಲ್ಲ. ಅದೇನೋ ಸರ್ಕ್ಯುಲರ್ ಇಸ್ ನಾಟ್ ಎ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಅಂತ ಹೇಳ್ಕೊಂಡು ಅದನ್ನ ಯು ಸೆಡ್ ವಿಲ್ ಸೀಕ್ ಗೆಟ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ ದಟ್.
The whole problem is, my lord, all MLAs and MPs are having education institutions.
ಅದಕ್ಕೆ ಇದೆಲ್ಲ ಪ್ರಾಬ್ಲಮ್.
They are the lawmakers. They don't want to make the law against their education institutions. Because of that, my lord, no either municipality or, my lord, corporation not able to collect single rupees of tax. This is the biggest problem.
We'll answer this.
Yes,
right?
please.
Yes, sir. Very senior.
Next week, Monday or Tuesday.
List the matter on Thursday. Next. Is made clear, no further adjournment would be granted in the matter.
Call along with these matters.
ಕೊಡಿ ಅದು ಕೊಟ್ಬಿಡಿ. Tag the petition along with so and so.
Please, oblige.
Much worse. Interim order.
Interim order subsist.
Orders 36.
Post immediately after service of notice upon the second respondent. Interim order, if any, shall continue to the next date of hearing.
37.
Same order.
Covered by, my lord, last date of hearing issue.
R2?
R2 reported dead, my lord.
RT is dead. Again covered.
Covered by A.
Yes, Jagdish, if it's covered, we'll close it. Complainant is no more. Justice Hemant Chandra Gowda ಅವ್ರದ್ದು.
Please.
ಏನ್ ಮ್ಯಾಟರ್?
ಲಾಸ್ಟ್ ಡೇಟೇ ಕ್ಲೋಸ್ ಆಗ್ಬೇಕಾಯ್ತು. ಅವ್ರು R2 ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಲಿ ಅಂತ, ಬಟ್ ಈಸ್ ನೋ ಮೋರ್. Because 1 and 2 already caution.
Accused number?
1 and 2.
Oh, the Gautam Chand and others.
Please.
Same case.
Your accused number?
3 and 5. My lord.
Yes. The petitioners are accused 3 and 5. Accused number 1 and 2. The coordinate bench of this court, in terms of its order dated 31st October 2023, had quashed the proceedings by the following order. Page 81 in the Indorghaki. This court had issued notice to the complainant on the score that without hearing the complainant, the order could not be passed, notwithstanding the fact that the issue stood covered by the judgment rendered by the learned single judge, this court. The police report indicates that the complainant is no more. Therefore, hearing the additional SPP for the state, I deem it appropriate to grant the same benefit to these petitioners who are accused 3 and 4 as is granted to accused 1 and 2 in terms of the order passed by the coordinate bench. Same order.
Please.
38.
My lord, it's a banning of unregulated depositor scheme.
Buds Act.
Buds Act. Idರಲ್ಲಿ lordship has allowed the petition on the score that amount involved is only 9,000 rupees.
Correct. Adu.
One of the that complainant is also
9,300 ವಾಪಸ್ ಕೊಡ್ತಾರೆ ಅಂತ ಹೇಳಿ.
that complainant is also no more.
ಅಲ್ಲೂ ಕಂಪ್ಲೇಂಟ್ ನೋ ಮೋರ.
ಹೌದು. But the entire transaction, my lord, its company is.
This is different accused now.
Different accused.
Will answer in this. No representation behalf of the petitioner. Needful to be done in the next 2 weeks. List
But
the matter.
Order, the problem was the lordship's order. Page.
That's 9,300 rupees.
Page 23, final order, my lord.
Correct. Page 20.
Yes, my lord. It says FIR is quashed.
Kwe antagilla. We'll see. Yes.
So now we are in a position not able to invest. He is dead.
The learned additional SPP on instructions would submit that the complainant is no more. this court, que accused number one adu,
Section number 1.
one of the accused.
Accused number 1.
Accused number 1 had quashed the proceedings on this score that it is the amount involved in the said transaction was 9,300 and that he would return the money to the complainant. The learned additional SPP submits that the order depicts quashment of the FIR itself, which has caused an impediment to the prosecution to proceed against the other accused. Therefore, I deem it appropriate to clarify that the order dated 10th July 2024 is applicable only to the petitioner accused number 1. The present petition is preferred by accused number 2. There is no representation on behalf of the petitioner. List the matter on 27th.
26th.
26th, all right, 26th. Special court Friday, no?
This matter 26th, any other day than Friday.
26th, Beka?
Any other day than Friday, ma'am.
All right, so no problem. Very Monday to Thursday, no repeat ಮಾಡ್ತಾ ಇದ್ರೆ. Yes, next.
13(9).
Appealing for petitioners in this matter. PF and the copy has been served to the other side. Interim order of stay was granted. It is.
Also, charge was framed on 26/10/2023.
ಏನು ಇಲ್ಲ ಇದರಲ್ಲಿ ಅದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದು.
ಅದಕ್ಕೆ stay ಕೊಟ್ಟಿದ್ದು.
There is nothing in this. ಸುಮ್ಮನೆ ಮನೇಲಾಗೋ ಜಗಳ ಎಲ್ಲ 498 ಮಾಡಿತ್ತು. Yes. Complainant not served.
Accused number 2 and 3.
The needful learned counsel for the petitioner seeks 10 days time to do the needful. In the event needful is not done in the next 10 days, the interim order would get automatically vacated. Yes, next.
40.
Lords, could this matter please be had on Wednesday, my lords? I'm led by Nagesh sir in the matter. Today some personal inconvenience. Requested for Wednesday, my lords.
The first time dismissed ಮಾಡಿದ್ದು, second time cognizance ಮೇಲೆ ಹೋಯ್ತು, ಮತ್ತೆ third time.
These minutes. Same matter.
There is no interim order.
No, lords. Today
At the
some-
request,
Wednesday ಆಗ್ಬೋದು.
at the request of the council appearing for the petitioner, list on Wednesday. Grateful. Next.
41.
Rectification of office of early hearing.
The office
Hemant?
objection is that a rule is not issued, that's why IA is not.
You can't file an early hearing application.
The difficulty here is this is an order passed in the year 2022, transferring my suit from commercial court to civil court, my lords. It's covered by 2 judgments of the Bombay High Court as well as the Madras High Court, my lords.
All right. List the matter in preliminary hearing on Wednesday.
Much obliged.
Yes, next.
42.
My lords, I appear for the petitioner on this matter, my lords.
Yes, madam.
My lords,
Early hearing, idrallo.
my lords,
You have filed or he has filed?
I have filed.
Huh.
My lords, this is a writ petition preferred by the defendants.
Yes.
The petitioner.
Challenging what?
Challenging an order impleading petitioner number 2 and 3. Petitioner number 1 is the original defendant. During the pendency of the suit, the plaintiff, who is the respondent here, has impleaded petitioner number 2 and 3. I'm questioning that, my lords. The ground on which I'm saying so is that the allegation is that the scheduled property was, this is a suit for declaration, possession and injunction. The allegation is that during the pendency of the suit, the property has been gifted to petitioner number 2 and 3, and therefore they are necessary parties. My lords, the gift deeds are also produced over here.
It is not gifted?
My lords, it's gifted, but the properties are different. They allege that their site is in survey number 3/2, but our site is not there. Therefore, the property that is gifted, 3/5 is the plain scheduled property, 3/2 is the property gifted.
Will dispose his early hearing application and post it on Wednesday in preliminary
Please,
hearing.
my lords, my only difficulty is the parties are all over 80 years.
No, no.
And the suit is also
On
proceeding.
Wednesday, we'll, please, yes.
My lords, if your lordship may call it in preliminary hearing.
Only preliminary.
Very.
Yes, because they're all old matters.
Please, my lord.
Yes, less the matter, application IA 1 of 2025 early hearing stands rejected. Less the matter in preliminary hearing on Wednesday, that is 11th.
Very well. Thank
Yes.
you.
43.
41 ಅಲ್ಲ ಅದೇ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಿ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟೆಡ್
Hearing for the
ಯಾವತ್ತು
respondent.
ಹೇಳಿದ್ರೆ 11th ಅಲ್ಲ
11th.
ಸೇಮ್ ಅದೇ
Lordship,
For the
kindly
petitioner.
pass over the matter.
Your Lordship, this is for orders, so we'll have to furnish the
Lordship may
PF.
kindly
for the-
pass over the matter.
ಪಾಸ್ ಓವರ್ wait ಮಾಡಿ where's your file
My senior is on the way. He is coming.
Lordship will,
vacating stay ಇದೆ sir
Yes.
and there is also furnishing of the PF that we may have to take up.
don't worry vacating stay you answer we'll take it on Wednesday
Please, sir.
if you don't submit then we'll vacate
Please,
the
Your
interim
Lordship.
order
Please.
what is this PF rectification of office objections in the statement of objections yours then issue notice to R6912 why have you not taken steps
We will take steps, Your Lordship. Wednesday, it will be kindly
this the
posted. Before
matter
that,
on Wednesday Friday the next
please,
on the half day yes Wednesday ne barli no
please, sir.
yes Wednesday interim order subsisting will continue to the next
44.
For the respondent, kindly pass over the matter.
Lord,
On
statement of
rectif-
objection is not served, my lords.
serve ಮಾಡಿ ಅದೇ objection the respondent shall serve the copy of the statement of objection upon the counsel for the petitioner forthwith lest the matter on 17th sorry 18th
Lord, interim order to continue.
interim order subsisting will continue to the next date of hearing
45.
For the petitioner, my lords.
Yes.
Filed a memo for withdrawal by certain petitioners, only some of the petitioners.
how many petitioners
Lords, about
counsel for the petitioner has filed a memo seeking to withdraw the petition of the following petitioners causeless element. The petition stands dismissed qua those petitioners. What about the others?
my lords, they have filed a memo for dispensation of notice to respondents. These respondents have not contested in the matter.
Respondents, sorry, yes.
These respondents have not filed an objection. They didn't contest in the court below, my lords. That's why I filed a memo for dispensation of notice.
What happens to the other answered? What is the matter? Why so many respondents?
Respond number 1, sir.
170 respondents, sir.
Please, my lords.
470. Why, sir?
My lords, it's a suit for partition about
Partitions.
18 acres of
It is of
land.
1991 suit.
And there is an interim order here.
Please, my lords.
Why? What have you challenged here?
My lords,
FDP proceedings.
please.
Court
my lords.
Commissioner's
you?
report, madam.
I'm the plaintiff, my lords.
Why are you challenging the FDP proceedings?
My lords, the court commissioner has submitted a report saying that the land cannot be fragmented and shares can be allotted to the plaintiffs, as rather expressed an opinion to sell the land and divide the proceeds of the sale to the plaintiffs.
Now the land is already sold.
No, my lords, it's still in position.
2 cents of land is coming for each his one. It's an agricultural land. So therefore, the report has given by the commissioner.
That's
It's not
ಸ್ಟೇ ಇದ್ರೆ
feasible.
ಸರ್ವಂತೂ ಆಗಲ್ಲ ಇವರಿಗೆ ಕಂಟಿನ್ಯೂ ಆಗ್ತಾನೆ ಇರುತ್ತೆ ಎಂಟ್ರಿ
Contesting respondent, no matter.
Contesting respondent ಯಾರು?
On my application only, this order has been passed, that is respond
It
number
is
176.
176.
Yes, please.
That's
So
matter
remaining
could-
respondents, I think.
That's the
not
matter could be
material.
taken up on Monday, my lords. Senior wants to appear in this.
We'll
matter.
take it. List the matter on 16th.
Grateful.
Yes.
Interim order, my lords.
Interim order subsisting will continue. 16th in preliminary hearing.
Grateful.
Interim order subsisting will continue to the next date of hearing.
46.
A week's time is granted to do the needful.
47.
May I please your lordship, Milos, I beg to appear through VC, Milos, may permit me.
47.
Milos, yes, Milos. 47, I am for the petitioner, Milos.
All right.
Milos, office objection has been mentioned, Milos. It says that the appeal would be lie.
There are two issues on
Maintainability, Milos. The appeal would lie against application under Order 7, Rule 10, Milos. Here, my application was dismissed, not returned. The plaint was not returned, so Milos, Order 43 will not apply.
One moment. Yes, what's the maintainability?
On appeal, I don't think this is an appealable order.
Correct.
But my
What is
lords,
the other one?
revision, this is a revisable order. Writ petition is not maintained. 7 Rule 10 application rejected.
Oh, it won't come under revision.
No,
Yes,
revision will not be
27
made.
petition. 127.
Not be
Available
maintainable.
anyway.
Please.
File a CRP, sir.
Because my lords have powers to convert this, because I have judgments placed on record.
Yes.
So, Milos, may kindly convert this, Milos, because this matter is.
The office objections qua maintainability stands sustained, not with regard to the appeal remedy available, but the order is revisable. Therefore, the petitioner ought to have preferred a CRP. The learned counsel for the petitioner submits that this court convert the subject petition to that of a CRP. In the light of the order being revisable and maintainable only by by filing a CRP, I deem it appropriate to convert the same as a CRP.
Please.
For the statistical purposes, so and so. Yes. List on.
I'm so great.
List on. We'll take it on Thursday next.
Please.
Grateful. Deeply authorized. Deeply authorized.
Later. So, then we'll take it on 19th. Yes.
48.
Lord, I appear for the petition.
Disposal.
Yes, my lord. My lord,
what disposal, sir? Respondent here.
Sunil Rao. In fact,
Not to proceed in evidence or so till the next date of hearing. Who are you?
my lord, fifth defendant before the trial court. I sought to examine my husband by giving him a power of attorney. That application has been rejected on the ground that no health ground is cited. Along with the memo for disposal, I also filed a decision of this honorable court which says that a husband can be examined even without a power of attorney by virtue of section 120 of the Evidence Act.
Or Bunbudley. List on Monday.
Great.
Memo for disposal stands rejected. List on Monday in preliminary here.
Interim order means.
Interim order subsisting will continue to the next. Interim order idea.
Ide. Not only insofar as
Wednesday.
Wednesday. Great.
Next.
49.
A week's time is granted. Do the needful. Next.
50.
Same order.
51.
Lords, the respondent number 2, I have not sought any relief. Besides, my lords, the respondent number 2 has already filed wakalat.
All right.
Filing memo along with his, so the director is resigned 2020-22 itself.
R2 na?
R2. They are claiming against
No claim ಅಂತ ಅವರೇ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ.
memo.
I have no claim, my lords.
File a memo.
In fact, my lords, in the cause title itself, I have mentioned he's a pro forma party and no relief is being sought against him.
But why do you file? Yes. The matter is listed on the fresh process fee to be paid to the second respondent, to serve the second respondent. The second respondent himself, the second respondent is now represented by counsel and submits that he has resigned long before the entire proceedings could emerge. The learned counsel for the petitioner also submits that he has not claimed any relief against the second respondent. Therefore, the second respondent be deleted from the array of parties.
May I
make
one submission, my lord?
I am the plaintiff in the suit, man. I have claims against him.
Against him?
Against respondent number 2. I don't have a claim in this.
In this petition?
In this petition. In plaint I have.
In this petition, we'll delete. Delete second respondent in the subject petition and not in this suit.
Please.
Yes.
Lords, this is a writ petition challenging the order of my application for under Order 7 Rule 10 being rejected. I had previously filed a commercial appeal. This honorable court, my lords, if my lords were to...
Yes, sir. Idu CRP ಆಗ್ಬೇಕಲ್ಲ.
Idu CRP.
Lords, CRP may not be maintainable in my humble opinion. The reason being, my lords, if my application is allowed, the suit does not end, my lords. Only the commercial court will not have jurisdiction. The suit needs to be transferred.
On jurisdictional issues.
Yes, my lords. So therefore, a writ is maintainable.
That's all. Yes.
Lords, the other
We'll
submission.
take it in preliminary hearing. Yes.
Very well, my lords. The only difficulty I have is, my lords, on the last date of occasion,
the learned respondent counsel also had agreed that they will not precipitate the matter before the commercial court. The commercial OS is on Monday, my lords. And I had the benefit of the interim order.
I am the plaintiff, my lord.
You had agreed that you would not.
Only for last hearing date I had, my lord. I
Extend
am
it to
ready
the next
for.
hearing date also. We'll take it on Wednesday in preliminary hearing.
Very well.
Yes.
May I
Or
request
I should
for?
pass an order, I'll pass an order.
No, my lord, I will not proceed. Can I request for 18th, my lord?
All right, no, not 18th is.
Wednesday, my lord.
Oh, Wednesday, fine. 18th. The learned counsel for the petitioner submits that the respondent plaintiff had undertaken that he would not pursue the matter before the concerned court. Learned counsel, the second respondent would
My lord.
reiterate.
For one, my lord.
For plaintiff would reiterate.
For the Monday only, my lord.
For reiterate the undertaking, list the till the next date of hearing, list on 18th.
Great.
Pledge.
51.
For petition, my lord, I paid the process fee in the morning, my lord.
Learned counsel
Seeking
submits
interim prayer,
needful has
my
been done, office to verify.
Lordship may kindly see. Interim prayer is there, not the.
Office to verify, list the matter on next.
11th is the next date before the trial court, my lord. Before that.
9th.
Monday or Tuesday.
ಯಾಕೆ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿಲ್ಲ ಇಲ್ಲಿವರೆಗೆ?
File misplaced ಆಗಿದೆ.
Let it be list on 11th. List on 11th. Yes, next.
10th, your lordship.
Next, yes.
52.
Appear for the petitioner. Idral R2 has been placed ex parte before the trial court, my lord. Notice to R2 may be dispensed with. This is a case, my lord, where
Memo.
I shall file it, my lord. Then
Having served R1 ಗೆ?
R1 has been he's
already
represented.
there.
Please,
What is this IA1 dispensation?
please.
ಎಲ್ಲ ಕೇಳ್ಬಿಟ್ಟಿದ್ದೀರಾ?
Allah, my lord, this is a case where my deletion application was rejected. I am defendant number 2 in the trial court for recovery suit. Defendant number 2 had entrusted a particular work to defendant number 1, who in turn entrusted the responsibility to the plaintiff. If my lord may kindly turn to page.
Anyway, not on merits at this stage. Yes.
The suit is before the commercial court on 17th for evidence.
Well,
my lord could have this
list
next
the
week.
matter on 13th. The learned counsel for the petitioner submits that he has not claimed any relief against the second respondent, therefore would want to delete the second respondent from the array of parties. The memo so filed is accepted. Second respondent stands deleted. The first respondent is already represented. Therefore, list this matter on 13th in preliminary hearing.
I'm grateful.
Next.
53.
Complaint
Publishing of
objection during the course of the day.
PF week's time is granted to do the needful. Yes.
54.
Same order.
55.
Serial number 54,
May
we
be
have
permitted to
served
serve the
copies.
to the trial court. Okay. I may be permitted to serve the copies to the trial court advocate.
ಆಯ್ತು ಮಾಡಿ 53 ಅಲ್ಲಿ counsel of the petitioner is also at liberty to serve on the counsel who represents the respondents in the trial proceedings. Yes.
My lords, in serial number 54, as per the direction of this honorable, we have served copies of writ petition along with documents on advocate who represent in trial court.
But ಅವ್ರು represent ಮಾಡ್ಬೇಕು.
ಅಲ್ಲ, ಇದರಲ್ಲಿ on last occasion 23/4 ಅಲ್ಲಿ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ. So by that time the trial court has posted the matter for hearing for evidence on 9/6/2025. So ಅದಕ್ಕೆ 5/6 ಗೆ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. So before that ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ ಮ್ಯಾಟರ್ ತರಿಸ್ಕೊಳ್ಳಿ ಅಂತ.
ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ will continue at 2:30. Yes. Madam, adjournments ಕರೆದ್ಬಿಡಿ.
55.
Call adjournments page wise, wait. Yes.
Page wise adjournments. Page 11, 55 and 56. Page 12, 57 to 63.
1 minute. 63. Next.
Page 13, 64 to 70.
66, my lord. 66, my lord.
66. Vacating interim order.
For the respond number 1 and 2 in this case.
Interim order.
Today morning I filed Vakala. 2 weeks time.
Respond number
1 and 2.
1 and 2. Learned counsel so and so.
66.
Dispense with ಅಂತಾಗಿದೆ.
I filed Vakala 2.
Why dispense with? Let's see. On the matter is called.
Serial number 55, my lord.
67 ಏನೋ ಅಂದ್ರಲ್ಲ. Vacating petitioner.
My lords, appearing for the respondent, my lords, in 67.
The learned counsel for the petitioner submits the application is served upon him only yesterday date haki. Therefore,
My
list the
lords-
matter on.
My lords, I
list
appear for the
matter on,
respondent, my
18th.
lords.
18th interim order subsisting will continue till the next date of hearing.
Serial number 55, my lord, 55.
55, wait, sir. Yes, 68 and.
I appear for the respondents, my lord. I pray for a short take.
Vacating in petitioner, yaru.
Appear for the petitioner, my lord.
No objection.
No objection.
Learned counsel for the respondent seeks adjournment. The petitioner counsel has no objection. List the matter on 27th.
My lord, I request the interim order may be extended.
27th interim order subsisting will continue to the next date.
Execution has been stayed pending a section 34 appeal.
And for the respondent, my lord.
Final arguments on 21st.
Interim order ilva?
My lord, I sought for the withdrawal of the amount, my lord. They have deposited, pursuant to this order of this honorable court, they have deposited the amount, my lord, before this honorable court. I am seeking 50%
Yes.
withdrawal of the amount, my lord. There is urgency, my lord.
Stay of execution proceedings pending the outcome of the appeal, section 34 appeal.
Like,
That's set down for
what is modification?
There was some discrepancy in the calculation of the arbitral award plus interest, my lord.
Instead of
Modification should go before the same honorable judge.
True, my lord. This honorable court was pleased to direct me to deposit 13 crores 39 lakhs or something. So,
That's what, that modification if you want before the same honorable judge.
my lord, let it,
The plea submission is that the 34 appeal itself is set down for final argument.
my lord, there is delay application in that section 34, my lord. I sought for the withdrawal of the amount. They have, what they have deposited before this honorable court.
You want modification or withdrawal of the amount? What is it?
My lord, I am the petitioner.
Correct. Modification ಬೇಕು ಅಂದ್ರೆ ಅದೇ court ಗೆ ಹೋಗಿ. The counsel for the petitioner has filed an application seeking modification of what order date? Modification of order dated so and so in IA 1 of 2025. If the order, the petitioner is seeking modification of the order, the matter be placed before the just Narendra Prasad,
Please, ma'am.
Honorable Chief Justice so and so. Yes. Interim order, if any subsisting, will continue till the next date of hearing. Yes.
Date may be.
Page,
I'll mugskom barli. Yes.
page 14, 71 to 74, page 15, 75 to 81, page 16, 82 and 83.
Your Lordship, 83,
Ah.
may I request for reporting settlement on 25th June, Your Lordship.
All right, the counsel for the petitioner seeks time till 25th to report settlement. List the matter on 25th at 2:30 PM.
Great.
Bill number 55, my lord.
55
Steps,
ಏನು?
they have to take the steps.
Because
Steps ಗಂತ ಇದೆ.
Respondent number 2 is to be served. I'm filing memo, he is not necessary for the purpose of this revision, this petition.
The learned counsel for the petitioner files a memo seeking deletion of seeking dispensation of issuance of notice to the second respondent
In this
as no
petition.
claim is made against them. Yes, what is this?
Well, the main petition is for revision against the order whereby the amendment of these.
Revision? What revision?
This is not a revision,
Ah,
the
yes.
petition for challenging the order of the trial court whereby the application for amendment has been allowed. It's the second application which is being allowed for the same very paragraph.
We'll
After the evidence has commenced and he has made lot many admissions in my favor, now he's wanting to withdraw
We'll
those.
take it on 18th.
Plus the only issue is on 11th, the trial court is fixed for now evidence. I'm saying the proceedings before the.
Evidence already started. I have marked the documents also.
No, not because then I have to
All
cross
right,
examine.
list on 9th.
Well, because I have come from Chandigarh.
Monday.
I have come only, well, I have come from Chandigarh, then I'll not be able to come.
On Monday.
Because I have come from Chandigarh, I'll be flying back today.
All right, we'll see.
I'll see, I'm only making a request, then may have it on Wednesday, then I'll join through VC in case.
No problem. I'll pass it over. We'll see. Yes.
Just now, all right.
Not in the lunch hour.
No, after the lunch,
After
2:30, then I'll
Yes.
make a prayer on 2:30 minutes.
My lord, serial number 58, my lords. The interim order needs to be.
Interim orders will get.
Number 57, my lords. I have to take summons to respond number 2, my lords.
All adjourn ಆಗಿದೆ ಅದು. Yes.
57, my lords. Interim order may be extended.
ತಗೊಂಡಿಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ sir, ಇಲ್ಲ.
57 ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ.
My lord, kind indulgence. One memo for posting, my lord, CRP. My lord, the agency is, my memo has been rejected because the arbitration application is, my lord, pending, the suit has been filed. I filed, there is a commercial suit at commercial court, it has to be transferred. My memo has been rejected. Now
Monday.
that, Monday, my lord.
Monday ಕೊಡಿ.
Please.
95 further council is not very well.
ಮಧ್ಯಾಹ್ನ wait. FR number.
FR number ಬರ್ದಿದ್ದೀನಿ.
FR ಅಲ್ಲ, ಅದು ಕಂಪ್ಲೈ ಮಾಡಿ.
ಮಾಡಿದ್ದೀವಿ.
It's still been called. Why are you
Court officer. Court officer? Court officer?
Court officer? Court officer?
Oh,
Hello.
Supreme Court remanded matters. Yes, Lord. The mining matters. Mr. Dama Seshadri Naidu is online.
Well, respond to that.
Please, Mr. Prasanna Kumar. Inform them, Lord, that I will be mentioning.
Tell them I'll take it at 3:30.
Please,
Lord, grateful. We'll wait for that.
Tarvade Deneth madam, we can solve problem.
Yes.
ಅದನ್ನ ಹೇಳಿದ್ದೀರಾ?
Lord, sorry to make a mention, Lord. Serial
Yes.
number 74 has become infructuous.
I don't feel sorry for that, sir. Yes. Yes. Disposed as. ಬರ್ಕೊಂಡ್ರಿ.
Your Lordship. List number 2, serial number 15, Your Lordship.
List number 2 ಕರೆದಿಲ್ಲ, ಕರೀತೀನಿ.
ಅಲ್ಲ ಅದರಲ್ಲಿ
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ತಾನೆ.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ, ಬಟ್ ಅರ್ಜೆನ್ಸಿ Your Lordship ಮಂಡೇ ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮ್ಯಾಟರ್ ಇದೆ. ಆಸ್ ಪರ್ ದಿ ಎಕ್ಸಿಕ್ಯೂಷನ್.
Wait.
ಮಂಡೇಗೆ.
Wait, sir. Yes. Continue the list. Raghavan sir ಒಂದ್ಸಲ 2:30. 1 minute. I'll take wait.
Petitioner. But morning, Mr. Raghavan has concluded his
Where is the
arguments.
respondent?
Mr. Joshi has to commence.
Where? Otherwise, I'll grant stay then.
But will permit me to questions that were raised by my learned senior.
Then we'll grant stay.
Have been negative by the other high courts.
We'll see. We'll have to consider. There are high courts which have allowed it, which have negatived it. Both. Correct?
Ones that have negatived it severely outnumber the ones that have allowed it. Matter has also been carried up to the Supreme Court.
And what has happened there?
Supreme Court has rejected the SLP that was filed.
Against what?
Where the Gujarat High Court had held that commercial court would have jurisdiction to entertain execution petition.
So is there any submission to make, or I'll proceed to pass orders?
Petition needs to be made.
Kodi. Neeve ಮಾಡಿ. Yes. Monday matter ಇದೆ ಅನ್ನಲ್ಲ?
No, my lord, matters today.
Today.
They have taken a passover, my lord.
Oh, wait.
For hearing on an application I have filed for.
Wait. ಹೇಳಿ.
The first set of citations is all the other high court judgments.
ಯಾವುದು?
The high court judgment is my learned friend had produced Chhattisgarh and Kerala. I produced Delhi, Rajasthan, Andhra Pradesh, Gujarat, and Allahabad. The Delhi High Court judgment, my lord, will see para 28. Page 19. As far as the contention for senior counsels for the judgment debtors of proceedings for execution, an arbitral award as a degree being not within the jurisdiction of the commercial court or commercial division of this court is concerned. Section 10 of the Commercial Courts Act, inter-alia, provides that when subject matter of an arbitration is a commercial dispute of a specified value, all applications or appeals arising out of such arbitration under the provisions of the Arbitration Act have been filed on the original side of the court shall be heard and disposed by the commercial division. Such commercial division is constituted in the High Court. It is not in dispute that subject matter of the arbitration, award whereof is under execution was of specified value. Same here, dispute of about 2.5 crores. On the next page, the arbitral award negates the contention of the decree holder of the agreement being of sale and has held the decree holder to be entitled to reimbursement of the amounts incurred pursuant to the agreement. Such a dispute under clause 6 and 7 of section 2(1)(c) of the Commercial Courts Act, read with explanation herein, to constitute a commercial dispute. Thus, the subject matter of arbitration in the present case is a commercial dispute of a specified value within the meaning of section 10 of the Arbitration Act. To be fair to the senior counsel of judgment data, they did not seriously controvert the aforesaid. Their contention, however, this is exactly the contention that was raised by Judge. Their contention, however, was that since the appeal does not arise out of arbitration under the provisions of the Arbitration Act within the meaning of section 10(2) of the Arbitration Act, the execution was not within the jurisdiction of the commercial division, and the appeal thereagainst does not lie to the commercial appellate division under section 13 of the Commercial Courts Act. It was further contended that the Arbitration Act is concerned only with arbitration proceedings in challenge to the arbitral award and is not concerned with execution of the arbitral award of the Act. In section 36, merely providing for the award to be executed as a decree of the civil court in accordance with the provisions of the CPC. It was contended that the execution petition is thus not an application arising out of arbitration under the Arbitration Act to be entertained by the commercial division of this court. Needless to say, this question was also not raised before and has not been considered by the commercial division in any of the orders. The 31 onwards is where they analyze this argument.
Next.
36 is their conclusion. It is not as if on adjudication of a dispute resulting on the judgment or decree or award of an arbitral tribunal, the dispute between the parties comes to an end or nothing remains to be adjudicated between the parties. Section 47 of the CBC Part 2 title execution itself provides that all questions arising between the parties to the suit in which the decree was passed or their representatives related to execution, discharge, or satisfaction of decree shall be determined by the court executing the decree and not by a separate suit. It is evident therefrom that a judgment or a decree of the court on the award of an arbitral tribunal do not put an end to the dispute between the parties, and it is not as if execution is merely an administrative task with no adjudication involved. It would be incongruous to hold that the jurisdiction of the commercial courts extends only to adjudication of commercial disputes to the stage of adjudication and not to the adjudication of commercial disputes arising in the course of execution. Once it is so, the word dispute in 2(1)(c) would extend to adjudication of disputes arising under execution of arbitral award, subject whereof falls within the jurisdiction of the commercial court, and commercial court and commercial division would also have jurisdiction or application for execution of arbitral awards. Similar view has been taken along by Rajasthan.
Division bench.
Division. Allow me to see page number 34 is where it starts. Paragraph 16, 17, and 18. It is on page 46. Paragraph 16 or page 46. Section 10(3) and 15(2) of the Commercial Courts Act both are relevant for deciding controversy involved in the subject matter, and they are reproduced as under. 17 starts at the near the bottom. A conjoined reading of section 10(3) and 15(2) of the Commercial Courts Act makes it clear that an application under 36 of the Arbitration Act seeking execution of the award satisfies the requirement of being application arising out of such arbitration under the provisions of the Act of 1996. So the words in 10(2). If such application is pending for any principal court of original jurisdiction in a district, the same shall have to be transferred to commercial court exercising territorial jurisdiction over such arbitration as such commercial court has been constituted. In view of section 10(3) of the Commercial Courts Act, since awards in the present set of cases have been rendered in arbitral proceedings, their execution applications filed under section 36 of the Arbitration Act having regard to provisions of section 15(3) of the Commercial Courts Act contemplates transfer of all such pending applications to commercial court as a legal corollary thereto, would also be liable to be filed and maintained before the commercial court and not the ordinary civil court, principal court of district judge. Insofar as the judgment of Chhattisgarh High Court in Southeastern Coalfield versus Padam Kumar is also relied on in their compilation. Learned counsel for the petition is concerned, we are with great respect not inclined to concur with the view taken by that court that the word application mentioned in subsection 2 of section 15 of the Commercial Courts Act would only mean an original application and not an application for execution, which is preferred after the award has been delivered. In our considered opinion, there is no warrant for taking such narrow interpretation of section 15(2) of the Commercial Courts Act. Analogy which the learned judges of Chhattisgarh High Court have taken from proviso to section 15(2) of the Commercial Courts Act is that since no suit or application where final judgment has been reserved by the court prior to the constitution of commercial division of commercial court should be transferred either under subsection 1 or subsection 2 of section 15.
Yes, I have seen everything.
Yes, all the high courts have got this. I have filed one more compilation, my lord, with the Gujarat High Court judgment.
Correct.
Now, paragraph 26 onward. It was observed, page number 9. It was observed that since the award was enforceable in terms of the Code of Civil Procedure in the same manner as it was the decree of the court having jurisdiction over the subject matter could be the court competent to execute it as per section 38 of the CBC. It was concluded that since present case jurisdiction of the subject matter which was part of arbitration ordinarily lies with the commercial court, and it was because of this reason that the application for setting aside the arbitral award was transferred to the commercial court. It was the commercial court which was competent to enforce the arbitral award as if it were a decree of that court. The decision of the Delhi High Court in Bayer Intellectual Property so has been that is also along the same line. It was the contention canvassed before the Delhi High Court on behalf of judgment debtor. The jurisdiction of the commercial court is only over suits or arbitration, subject matter whereof qualifies in the commercial dispute, and not over proceedings of decrees passed in the said suits over enforcement of arbitration. This has been challenged.
It's finished.
This order was challenged before the Supreme Court, in which an SLP was rejected.
That is noted by the Allahabad High Court.
Yes.
Yes. Andhra Pradesh High Court also notes that SLP is rejected. Yes.
Now, what the interpretation that is given by Leonard Senior is that section 9, section 34 petitions will still come before the commercial court. Only for execution it must go before the
regular court. Under order 21.
Order 21 also uses the word application. Order 21 rule 11 says application to be made. Same word as in section 10. All applications and appeals arising out of arbitration act. Now, without reading section 36, we cannot file an order 21 petition or an application for enforcement. It is only when it is read with 36. Therefore, under section 10, I am required to file an execution petition before the commercial court, which is what I have done. But the proceeding before the commercial court today is for hearing on an application I filed for disclosure of their assets. There is no immediate threat of any warrant or any coercive action being taken against them.
Anyway, I'm hearing it, we'll reserve it and pass orders. In the light of the matter being reserved, we'll stay it for a week.
Manoj, instead take an undertaking from me that I will not take coercive action. Let the order be
How
passed
can
on
you
that
take
application.
coercive action?
Let that application be, it is only for disclosure of assets.
Whatever, we'll see. No, because this cuts at the jurisdictional issue, whether I follow other courts or not. In a week's time, we'll do it.
It's in the compilation.
ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
Second set of Supreme Court decision also in 2022.
23. This is MR Shah.
And the division bench of the Gujarat High Court. Those get subsequent.
Our Chief Justice. Now who's in the Supreme Court?
Lordship, the Supreme Court decision referred to is under section 34, not under 36.
Para 26 and 27, Supreme Court says that all applications in that particular, para 26 and 27.
This requires an answer, we will answer.
Certainly, because most of the high courts have answered, except for Kerala High Court and Single High Court, single judge, which seem to have taken.
The others are division benches.
Others are all division benches and all have taken a consistent applications are visible.
Please, both book it. Heard the learned senior counsel KJ Raghavan appearing for the petitioner and learned senior counsel Dhananjay Joshi along with Kashyap. What's his name? So and so for the respondents. Heard reserved. In the light of the matter being heard and reserved, and the fact that the matter is listed today before the concerned court till the next date of hearing the proceedings before the concerned court be deferred. And not stated it. Yes.
Grateful.
Yes. No, our Punjab and Chandigarh in Mandarla. Imdala. Who's the respondent? Is here?
Yeah.
Ah, is here. Yes. What's the matter now?
So the respondent filed, number one, filed a suit against me for recovery of money. So in the plaint was in para 7, he made certain amendments. Then he files an application for amendment, which was initially allowed by the trial court. Now I didn't oppose that. Now thereafter he led evidence. The only sole witness he examined, I cross-examined him. During the cross-examination, certain facts have come in my favor. Many admissions were made. I'll refer to those admissions. After those admissions have been made by the witness in my favor,
Another amendment.
Another amendment has been filed. Now the court has allowed in view of Order 6 Rule 17 proviso, the amendment cannot be allowed after the trial has started and there is a bona fide, no due diligence, rather because the first amendment with respect
Unless
to the
exceptional circumstances.
yes, that he has failed to show. That is the only argument I can, in case I can show those documents.
No fresh prayer.
ಮತ್ತೆ ಯಾಕೆ ಹಾಕಿದ್ರಿ? Why did you file then?
Only thing to adjudicate the matter, only thing is I have mentioned 1 crore 13 lakhs was the due. So total sales. The claim amount is 92 lakhs only. You are now also 92 lakhs only. No change.
ಏನ್ ಚೇಂಜ್ ಮಾಡಿದ್ರಿ?
Total sale was 1 crore 78 lakhs. I stated in the first original claim 1 crore 13 lakhs.
Only with regard to that.
Only with regard to that. Nothing else. But to show that 1 crore 78 lakhs, I produced the invoice. Delivery note.
It's not going to change the nature.
No,
of
it
the
will. Your Lordship may kindly see page 81. Just page 81. He relies upon the statement of accounts, which is produced on the record. During the cross-examination, he also, in the examination in chief, he also files a certificate under section 65.
See, it is like this. In the plaint, there is a schedule. A particular survey number is mentioned. That is erroneous.
No, it's not like.
No.
All right.
It's erroneous. In the Order 6 Rule 17 application, it is sought to be amended at the fag end of the trial. But that cuts at the root of the matter because it is the survey number that he had to correct. Now he says his claim does not change. 92 lakhs is 92 lakhs. Sale of what?
Plus chemicals and reagents. We are a hospital. They supplied us some chemicals by the different 12 bills. In para 7 of the plaint, initially he relies upon 12 bills on with respect to
Will
the
record a statement that his claim will not change, only the figure of
plus,
sale changes.
Your Lordship may kindly see page 81 when he examines. He admits all these facts. He relies purely on the basis of a account statement which was being made by a computer, and he gives a certificate under section 65B that this is my account statement. Now he wants to say a different account statement which can't be permitted. My Lordship may kindly see page 81. I'll just read a few cross-examination, few lines from his cross-examination. The entire documents are now sought to be changed. 7 new bills are sought to be added in the plaint, that he supplied 7 more bills in respect of that, and the entire.
He's not claiming anything extra out of those
No,
bills.
the total amount he's not claiming. Definitely, there's no issue on that.
Yes.
The only issue is now he's wanting to incorporate 7 other sales and say that amounts.
If that was amounting to changing
No,
the
no.
claim itself, it's a different.
The total amount he's not changing, therefore he's playing smart. The total amount he keeps the same amount, 92 lakhs. But then he says that earlier the material was supplied by 12 bills. Now he's wanting to say material was supplied by total 19 bills. He wants to incorporate 7 more bills.
No, whether it is 1 crore 32 lakhs or 1 crore 78 lakhs, what difference would it make when his claim itself is not going to
The
change?
difference would be, Malas, when he admits that in the cross-examination that this was my account statement which I was making. Now he's wanting to incorporate another account statement with respect to showing different sale amounts, different purchases, different sales. Total 19 bills he's wanting to incorporate in the plaint instead of 12. Your Lordship may kindly see page 49, the initial plaint. Page 49, the initial plaint, 12 bills were, the claim was based on 12 bills, page 49.
Yes,
This
12 bills.
12 bills, he's detailed with respect to sale, he says 29. So total amount due, he says 92 lakhs. Now in the cross-examination, Your Lordship may kindly turn to page 81. The witness makes a totally different statement. Your Lordship may kindly see the total, page 81, last third line from the bottom. The total sale amount against the defendant number so and so was 1 crore 45 lakhs as alleged in the legal notice. It is true to suggest that I have mentioned the amount which was received from the defendant number 1 as 53 lakhs. So he admits that I have paid him 53 lakhs. I have not mentioned the details regarding total sale amount in my plaint. It is true to suggest that in my amended plaint, I have mentioned in para 7A regarding total sale amount of rupees 1,13,000 so and so. It is true to suggest in para 5 and 7 of my affidavit regarding total sale amount of so and so. Witness further voluntarily stated that wrongly it is mentioned. It is true to suggest that in my legal notice, I have stated that defendant number 1 had paid an amount of 53 lakhs. So it admits the payment of 53 lakhs out of the total amount. Whereas in the claim petition, in the suit, he sells only 23 lakhs. Then, whereas in my affidavit, I have stated that defendant has paid a total amount of 21 lakhs only. Witness further voluntarily stated that there is a mistake while filing the affidavit and the plaint. It is true to suggest that till today I have not filed any applications before the court to get rectified the mistake. Then the specific question is asked. It means your affidavit is incorrect. So he says, yes, there is a mistake in respect of the date and other times. So he admits all those things. Now, to wriggle out of that part of the cross-examination, an amendment application is filed stating that the material 19 bills were sought. That application, Your Lordship may kindly see. Then he now says that total material was supplied by different 19 bills. He wants to incorporate 7 other sales, and he cleverly makes a different account statement saying that 7 material was supplied by different 19 bills, and now he cleverly makes that 92 lakhs he saved. Now he's wanting to incorporate another account statement. Therefore, I am saying that this is rather male fide on his part. This is my claim. And if Your Lordship may see the judgment of the Supreme Court says after provisions of Order 6 Rule 17, this can't be. It's rather male fide on his part to incorporate and get wriggle out of these admissions which he has made before the court. Right. Your Lordship may kindly see in this compilation page 20, where after dealing with all these things,
please indicate the paragraphs and give.
All right, I'll just
ask your counsel.
Yeah.
Madam, there are 2 sets, same.
That is a respondent copy.
We have given it to me.
All right, sorry for that.
Yes. That's copy. Respondent copy. Change paragraphs. Just note mark the paragraph, note the paragraphs and give.
Will mark.
I'll dictate on Wednesday. Yes.
All right. Your Lordship I may not be available.
Online.
All right. The only issue is because on Wednesday, the trial court is fixed for
Don't worry, in the morning
cross-examination.
itself we'll do it.
All right, highly obliged. I can join through VC in case it's required. Obliged, sir. Thank you for patiently.
Continue the list. Why was it passed over?
Because there is already the other accused are quashed. Charge sheet has been quashed against other accused. I produced all those two judgments also. Page number 97 and.
We'll take it on Tuesday. List on Tuesday. Yes. Next. R1 to R6. Yes, sir. Steps, sir.
Koti, we have served copies on
On the council.
House.
Barley ಅವರು.
ಅಲ್ಲ ಇದು ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಅಲ್ಲಿ 23/4 ಗೆ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆದಂತ ಸಮಯದಲ್ಲಿ ಬೈ ದಟ್ ಟೈಮ್ ದ ಮ್ಯಾಟರ್ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ಎವಿಡೆನ್ಸ್.
ಆಮೇಲೆ 2/5ಕ್ಕೆ ಲಿಸ್ಟ್ ಆಗುಂಟು.
ಅಲ್ಲ 2/5ಕ್ಕೆ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ. 5/6ಕ್ಕೆ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರು ನಿನ್ನೆ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಾಗಿತ್ತು, ಆಗಿಲ್ಲ.
2/5.
ಸೆಕೆಂಡ್ ಮೇಗೆ ಲಿಸ್ಟ್ ಆದಂತ ಸಮಯದಲ್ಲಿ ನಾವು ಸರ್ವ್ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ ಕಾಪೀಸು. ಈವನ್ ಆಫ್ಟರ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಆಮೇಲೆ ನಾವು ಅವ್ರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿದೀವಿ ಇಂಥ ದಿನನೇ ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ಬರುತ್ತೆ ಅಂತ ನೆನ್ನೆ ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲೂ ಮೆಸೇಜ್ ಮಾಡಿದೀವಿ ಅವರಿಗೆ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ.
ಸರಿ.
ಅವ್ರು ಏನಂದ್ರೆ ಈವನ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಇದೇ ಟ್ಯಾಕ್ಟಿಕ್ಸ್ ಯೂಸ್ ಮಾಡ್ತಾರೆ. ಸೊ ನೌ ಐ ಹ್ಯಾವ್ ಕ್ವಶನ್ಡ್ ದ ಆರ್ಡರ್ ಪಾಸ್ಡ್ ಬೈ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರಿಗಾರ್ಡಿಂಗ್ ಮಾರ್ಕಿಂಗ್ ಆಫ್ ವಿಲ್ ಥ್ರೂ ದ ಬೆನಿಫಿಷರಿ ವಿಚ್ ಕೆನಾಟ್ ಬಿ ಪರ್ಮಿಟೆಡ್ ದ ಲಾ. My lord, the will can be produced through the attesting witness only. But the trial court, when the matter is
where is that?
My lord, order is at page number from starts from 22, my lords. Idu ella evidence agi cross examination agi when the matter posted for final arguments, our side arguments was concluded. By that time they filed this application under section 151.
Heard the learned counsel appearing for the petitioner. The counsel for the petitioner submits that copies of the petition have been served upon the counsel who represented the respondents before the concerned court. List this matter on.
Matter is posted
as. Sorry. List this matter on 20th June in preliminary hearing. Till such time further proceedings before the concerned court shall remain stayed. Next. Post immediately after service of notice upon respondent.
In respect of R6 and 7 dispensation.
Needful be done in respect. Deletion.
Yes, my lord. R6 and 7 placed expert in trial court.
Dispensation. Counsel for the petitioner files a memo seeking dispensation of issuance of notice upon respondent 6 and 7. The same is accepted at the risk of the petitioner and the notice to 6 and 7 stands dispensed. Post immediately after service of notice upon respondents 1 to 5.
Date be fixed, my lord.
Immediately after service, registry to put up the matter after service of notice. Next.
Good.
Then our time tells
For the petitioner.
14%.
Yes.
Form C issued, huh?
Issue ID.
Yes.
My lords, I have served the copy to respond number 2, my lords.
ಇಲ್ಲ ಇದಾರಲ್ಲ.
Respond number 2 serve ಆಗಿಲ್ಲ ಅಂತ ಬಂದಿತ್ತು ಸ್ವಾಮಿ.
Don't worry about it. Who is
senior ಇಲ್ಲ ಸ್ವಾಮಿ.
He is R1 na?
R1.
Who is R2?
R2 is educational colleague.
Collegiate education. What's the matter?
My lords, it is relating to execution petition which he has filed in city court, my lords.
So?
Regarding MA order, my lords. We have filed writ appeal. In the meantime,
Writ appeal.
Writ appeal we have filed, my lords. In the
What happened in the writ appeal?
It is still pending, my lords. It has not come before the court.
Stay idea.
Stay ಇದೆ ಸ್ವಾಮಿ. ಇನ್ನ stay ಇಲ್ಲ ಸ್ವಾಮಿ. Stay ಇಲ್ಲ. ವೆಕೇಶನ್ ಮುಂಚೆ ದೇ ಹ್ಯಾಡ್ ಫೈಲ್ಡ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಅವರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿರೋ ಸ್ವಾಮಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆರ್ಡರ್ ಮೇಲೆ ಅದ್ರ ಮೇಲೆ ಈ ರಿಟ್ ಅಲ್ಲಿ ಸ್ಟೇ ತಂದಿದೆ ಸ್ವಾಮಿ. ಈ ಮಂತ್ ಅಲ್ಲಿ ವಿಲ್ ಮೇಕ್ ದ ರಿಟ್ ಟು ಕಮ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್ ಅಂಡ್ ವಿಲ್ ಟೇಕ್ ನೆಸೆಸರಿ.
Yes. Nothing doing. If that is the only ground, I'll dismiss it. What is under challenge now? Entire proceedings in execution.
Yes.
Anything else, sir?
My lords, my senior will come on Monday, my lords. Maybe taken up Monday, my lords.
That is, if stay is granted by the division bench, you tell me. Otherwise, there is nothing.
Monday it may be taken, ma'am.
Somara tagonte. List on Monday in preliminary hearing at the request of the counsel for the petitioner. It is made clear no further adjournment would be granted in the matter. Somara Banni. Post immediately after service of notice upon response 1 to 4. Interim order, yeah?
Interim order. Interim order may kindly be extended.
Maintainability Act. No representation. List after 2 weeks. Next. What modification? What has happened?
The observation is the application is filed on 31/7/2021 on the day of the petition. But that is not the day the application for interim maintenance is filed.
What application was filed? You have filed modification, is it?
Yes,
Ah.
Lords, if your lords may kindly have, they have produced.
No. First, take me to the order.
If your lords may kindly have the order, page 10, my lords. There is a reference at page 7 and 10 in respect of the date of the maintenance petition and the application.
When was the application seeking maintenance filed?
1/4/2023, my lords.
1/4/2023.
2023.
In what proceeding?
In this maintenance petition.
In 125 proceedings?
Yes, my lords.
Anything else, madam?
My lords, I'm paying interim maintenance on the day of this order, 50,000.
125, for what purpose it is filed? For what purpose it is filed? In a proceeding under the, in a 24 petition, if an application is filed separately, it's a different thing. Now 125 proceeding is meant for maintenance.
But this order is passed on an application filed on 1/4/2023, my lords.
No problem. Anything else? Then paying or not paying?
My lord, in the name of modification, they want review of the order. They want waiving of
I
the.
asked you one simple question. Are they paying or not?
They are paying only maintenance, not area they have not paid. From November, they are paying only maintenance from the date of the order. Area they have not paid. They have asked for waiving of the areas.
Arrears, my lords. In the past, we have continuously paid 25,000, which was ordered by the sessions. Post this honorable court's order, we have continuously paid 50,000. In terms of arrears, my lords, that in my modification, that's my alternative prayer. At least to give me 4 months time to pay the arrears. Because my lords, it's a huge sum. I just need time. That's my alternative prayer. My first prayer is in respect of to make it from the day of the order. If not, at least alternatively to kindly give me 4 months to pay the arrears.
My lord, 6.5 months have passed.
Both rejected. It was not your petition.
Yes, my lords.
You can't seek relief in his petition.
It was challenged over my order, which was passed by.
You have not challenged it. They have challenged. They have sought enhancement of maintenance. You did not seek any order to be quashed.
An order was passed by the sessions court wherein an amount of 50,000 was reduced to 25,000.
Correct, I have restored it.
From the date of the application.
No modification. Anything else, madam?
Some time may kindly
This
be
court,
given for arrears to be paid.
how much is the arrears?
Well, it's almost around, it will come about
13 lakhs,
13
my lord.
lakhs.
13 lakhs 18,000.
See. How many rupees?
13 lakhs 18,000 rupees.
18,000. No change?
Yes, my lord.
Yes.
Just about 4 months time. I am paying continuously. I am not.
Will grant 3 months time?
I don't have a problem, my lord.
Yes. This court, order on IA, this court disposed the criminal petition in terms of its order dated 22nd November 2024. An application seeking modification of the order is now preferred by the respondent husband on the score that the order of the concerned court is passed on an application filed in the year 2023. 2023. While the records would indicate that the application under section 125, the petition under section 125 of the CRPC was preferred in the year 2021, which was reversed or reduced by the Court of Session in Criminal Revision Petition 38 of 2023 in terms of its order dated 16/6/2023. Therefore, there is no modification of the order that is warranted. The learned counsel for the respondent would now submit that the arrears in the case at hand is 13,82,000.
18,000, 18, 13 lakh
18,000, oh, yes, reduced. 13,18,000, and therefore would require some time to clear the arrears, and would submit that the husband has been paying maintenance diligently. In that light, I deem it appropriate to grant 3 months' time from today to clear the arrears that are to be paid to the wife by the respondent. Except the aforesaid indulgence shown, there is no warrant to modify the order as is sought by the petitioner, as is sought by the respondent, ordered accordingly. Yes.
Copy has been served in respect of respondent number 1 to 3, my lord. Respondent number 4 servant.
Yeah, IA 1 of 25.
First step the proceedings before the LAC proceedings, my lord. Not to disperse the compensation.
We'll list it on Tuesday. Is the office objections IA 1 of ನೀವು ಹಾಕಿರೋದಾ?
ಇಲ್ಲ, respondent 4 copy serve ಮಾಡಿಲ್ಲ ಅಂತ.
Serve ಮಾಡಿ ಈಗಲೇ. Yes, list the matter on Tuesday.
23 or 24th, my lord. ಅವ್ರ ನಂಬರ್ ಕಾಲ್ ಮಾಡಿದೆ ಏನು ಟ್ರೇಸ್ ಆಗ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲಿವರೆಗೂ ಟ್ರೇಸ್ ಮಾಡ್ತಿಲ್ಲ.
Find out ಮಾಡಿ I will serve the
10 days you need to find
10
out.
days.
Oh. List the matter on 23rd.
Please.
24th at the request of the counsel appearing for the petitioner. Yes, next.
What I appear for petition.
Vacating interim order. Wednesday. List on Wednesday.
I want to be extended.
Interim order till next year. Yes.
For the petitioner, let's.
File this application, vacating the interim order. Opponents of the plaintiff filed a suit for injunction against the defendants, including petitioner hearing, for permanent injunction restraining them from interfering with the peaceful procession, and also they have sought for order of injunction restraining them from putting up any construction. Trial court granted injunction. That has been confirmed by
First appellate court has confirmed it.
confirmed it.
There is the warrant to vacate it.
Construction.
Despite the refusal to grant injunction.
Stay order granted by this one.
Yes, sir.
Let
So
also may be maintained.
detailed order is passed.
Please.
We are
After hearing use.
On the, after hearing on it. Yes, after hearing.
17/9/2024.
later on.
The council was present on the day when the matter was.
However, may not be, now they are putting up construction.
Yes. This, the coordinate bench of this court, after hearing the counsel for respondents 1 and 2, the plaintiffs, had passed a detailed order granting stay of the, granting injunctory relief in favor of the petitioner, the defendant. They said an application is preferred seeking vacation of the said order. Since the order was passed after hearing respondents 1 and 2, the matter requires to be heard. The application would be heard along with the main matter, post the matter in B group.
Let them not put up construction.
Yes, next.
No, my lord, we have purchased, my vendor purchased in the year 1999. We purchased in, my lord, in 2022. They say they are, it is acquired.
In CITB, na?
Let's CATB Davangere minutes, 20 guntas of land was acquired. Remaining extent, my lord, we are not touching. We are constructing the commercial
20
building
guntas al matra.
only in 20 guntas. If it is beyond, my lord, we will give up our claim.
No, if it is beyond, I will direct demolition of whatever they have constructed.
Yes, my lord.
Compensation without.
ಅವ್ರದ್ರಲ್ಲಿ ಅವ್ರು ಕಟ್ಕೊಂಡ್ರೆ ನಿಮ್ಗೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ಬೇಕು ಅದು ಕಟ್ಟೋದು ನೋಡೋಣ
Let a court commissioner be appointed, my lord, let your lordship, my lord, get the report from the ADLR.
ಅದು ನಿಮ್ದು ಅವ್ರದ್ದು ಅಂತ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ ಫೋಟೋಲಿ ಇಲ್ಲ ಫೋಟೋಗ್ರಾಫ್ ಅಲ್ಲಿ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ ದಟ್ ಈಸ್ ಯುವರ್ ಸೇ ಈಸ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಇಟ್ photograph will not resolve the dispute. Creates further dispute.
I got the injunctive relief in both the courts. This honorable court granted stay. No one, based on that, they are putting up.
I will record his submission that he is not putting up construction in your property.
Please.
It is only in the property belonging to CITB Davangere.
But as of now, my lord.
Well, I will record his submission. If it is other way, later when we appoint a commissioner, we'll see.
Please, my lord. You are now, my lord, your lordship.
Subject matter of suit, my lord, it's a matter of evidence. Now, my lord, if they put up construction and complete it, my lord, I will become, my lord.
ಅವ್ರದ್ರಲ್ಲಿ ಅವ್ರು ಮಾಡ್ಕೊಂಡ್ರೆ ನಿಮ್ಗೇನ್ ಪ್ರಾಬ್ಲಮ್?
ಮಾಡ್ತಾ ಇಲ್ಲ, ಈಗ ನಮ್ಮದ್ರಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Yes.
That is why injunction was granted in the year 2022 itself.
The learned counsel appearing for the petitioner submits that pursuant to the interim order granted on 17/9/2024, the construction that is put up is in the property belonging to the City Improvement Trust Board Davangere, which is 20 guntas of land. The land abutting the 20 guntas is.
But only one clarification. Total acquired land is 20 guntas. 6.5 guntas was used for outer ring road, and 13.5 guntas, the construction is being put up. Please.
The learned counsel appearing for the petitioner submits that 20 guntas of land was acquired by the City Improvement Trust Board Davangere. Out of the 20 guntas of land, 6.5 guntas is put to 6.5 guntas is put to use for the purpose of formation of the road, and the remaining 13.5 guntas is where the present
commercial building is
commercial building is being constructed by the board.
Please.
His property is adjacent,
in this very same survey number, they are the revenue side purchasers according to them. There is no conversion order, no layout plan. Their site cannot be identified at all.
Anyway, yes, the learned senior counsel submits that the construction is being put up by the CITB in the property belonging to the respondents. If that be in the light of the submission of the learned counsel appearing for the petitioner, the CITB shall not put up any construction in the property belonging to the respondent. If they so do during the pendency of this petition, they would be doing it at their own peril. Lest the matter, the application for vacating the interim order shall be heard along with the main matter. Lest the matter in B group on 27th June.
Please.
Next.
My lords, the plaintiff.
Renta.
This inordinate delay of 5 years, 2 months is condoned while preferring the mispetition for setting aside the ex parte order that is impugned in the present writ petition. 5 years, 2 months. There is a reason, my lords, for which
Ex parte order.
Ex parte, but there was absolutely knowledge. Just pass on.
You demonstrate knowledge, you will dismiss it.
Just I'll pass on, man. Just few dates.
Consideration of interim prayer.
Yes, sir. Mispetition ಈಗ delay condone ಆಗಿ proceedings ನಡೀತಾ ಇದೆ. That is the reason why I made an application.
OS 10/14.
My lords, that is, I filed a suit for specific performance of the contract on 4/12/2014.
All right.
My lords, 8/1/2015, Wakalat D1 to D5. Yes, on 18/2/2017, order on IA number 3, defend number 1 to 5, a written statement was permitted to be filed. Next, on 6/4/2017, memo for retirement of D1 to D3. Next, court issues notice on 4/7/2017. Next, my lords, that was received, my lords. Thereafter, they have not represented with any advocate. Therefore, the suit was decreed on 24/8/2017. Then 18/12/2018.
His application hakidda.
Yes. On 18/12/2018, execution case was filed. Then on 20/12/2018, notice was issued. This is kindly mark it. 18/1/2019, wakalat filed by respondent number 1 to R1 to R3.
All right.
Copy of the wakalat is placed on record, my lords. Next on 18/6/2022, NOC wakalat and wakalat filed by SP advocate.
So 3.5 ವರ್ಷ.
ಹೌದು. Next on 19/11/2022, wakalat filed by NKK advocate. This is important. 17/11/2022, miss case is filed. And along with the continuation of delay application.
All right.
Now thereafter I objected for it. Now on 6/4
ಈಗ 24 ಅಲ್ಲಿ ಅಲೋ ಆಗಿದೆಯಾ?
ಹೌದು 24 ಅಲ್ಲಿ allow ಆಗಿದೆ.
On 16/9/2023, the defendant while the miscellaneous petition was examined, there was an evidence, page 170, section G.
What is the explanation?
Explanation, just
Wait, what is the explanation?
Explanation is that D1 is the father, D2 and D3 are the son and daughter. Now what the children say, the children preferred a mispetition here, D2 and D3. What the children says is that father took an wakalat signature with blank signature, and they have not stated that the purpose for which they have taken a signature, and they have no knowledge regarding the suit. This is the absolute, this is the reason. Kindly see page 166, that is Roman letter 6, para number 6. Page 166.
Where is the reason?
My lords, the reason, my lords, what had happened was that, my lords, I had not placed a order. I filed along with a memo.
Hello, we did separate order in the release.
Quite separate. I placed along with a memo. My lords. The reason starts at para number 10, page 7.
Yes, sir. No reason at all.
The order is not available to me.
Not available to you. A copy ಕೊಟ್ಟಿಲ್ವಾ?
ತಗೊಳ್ಳಿ ಸರ್.
And reason ಎಂತ ಇಲ್ಲ ಇದರಲ್ಲಿ.
Kindly see the deposition of the petition.
Deposition is after 6 years.
Yes, madam. The reason is they came to know of this order only in the year 2022. That is.
You may come to know of the order in 2032 also.
Factual.
No, sir, nothing.
Kindly see this, madam. Kindly see this deposition. Deposition at.
ಈಗ ಏನಾಗ್ತಾ ಇದೆ?
Please, sir.
ಈಗ
ಈಗ ಕ್ರಾಸ್ ಆಫ್ PW1 ಫೈನಲ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ ಮಿಸ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ.
Anyway, we'll hear it. Yes. The petitioner is the plaintiff in OS 10 of 2014. The respondents, the defendants. The suit comes to be decreed by the judgment and decree dated 24/8/2017. The decree is sought to be executed by filing an execution petition on 18/12/2018. Notice is issued in the execution on 20/12/2018, and the respondents enter their appearance on 18/1/2019. After about 3.5 years of entering of appearance, and after 6 years of the decree, a miscellaneous application is filed seeking recall of the decree on the score that they were not heard in the matter. The application is resisted to by the petitioners on the score that it is hopelessly barred by limitation, and there is no explanation rendered that is plausible for filing an application after 6 years of the judgment and decree. The learned counsel for the respondent submits that respondents come to know only in the year 2022. Only in the year 2022, which is clearly belied by the narration of dates herein above. The matter would require consideration. Therefore, till the next date of hearing, further proceedings before the concerned court shall remain stayed. Next.
Great.
List on 27th.
For hearing.
List on 27th and preliminary hearing. Yes, we'll do it.
Waiting for the response in this matter, my lord. Lord, kindly.
Petitioner appointment.
Kindly have it on next week in this matter, my lord. I have filed an application for vacating stay.
List on 18th.
Interim
Please.
order may be extended.
Interim order subsisting will continue next. Next.
Appear for petitioner, my lord.
Respondents.
Respondent number 5, your lord.
Dispensed with anta ide R1 and R2 ವಕಾಲತ್. Who dispensed with? ನೀವು ಹಾಕಿದ್ದೀರಾ application?
Lordship, and they are not contesting the matter in the court below also. your
They are
lordship.
not filed written statement
They have
also.
not filed written statement. Now they are coming and seeking time. By
Why
their
did you
own.
come here
In
then?
fact, it is a collusive suit, my lord.
Collusive suit.
Please.
Imda.
Well, it may be taken on Tuesday, my lord. Senior is not.
Interim order list on 18th.
This one.
Yes.
Interim order may be.
Interim order subsisting will continue to the next date of hearing.
This.
Petition has filed a suit for bare injunction against the state.
Really petitioner
Respondent number 4.
vacating stay. You are the panchayat.
Panchayat property. The petitioner has filed a suit in the year 2015 for a bare injunction. He files an application for temporary injunction which was rejected. Lord, in an appeal also it is rejected. Again, he came up before the honorable court. Lord, with revision, where this lordship has said that he must approach the trial court and the trial court should dispose of within 3 months. It was done in June 2023, Lord. Thereafter, the matter was, evidence was ready and the argument was heard, replay argument was done, but thereafter he filed an application for appointment of a commissioner. That was rightly rejected by the trial court, Lord. And there was no need at that stage to appoint a commissioner. Against which this is.
We'll see, he is not there. List the matter on 18th, awaiting the appearance of the counsel for the petitioner.
Is it preliminary?
In the same stage, vacating stay. Yes, next.
I appear for petition in this matter, Lord.
ಯಾವ್ದು madam? ಅರ್ಚನಾ ಹೇಳಿ.
Lord. I appear for petition, Lord. I'm the judgment debtor, Lord, in an eviction suit.
How is 724 only, they are taken 3 years period. Performance should, it is an ejectment suit. In the ejectment suit,
Vacation of shops.
5/7/2024, they were supposed to vacate your law.
ಆಯ್ತು ಯಾವಾಗ?
1 year ಆಯ್ತು, 1 year ಆಗಿದೆ.
There was 6 shops more consisting of.
18/3/2025 order ನೋಡಿ.
Yes, Lord. I have undertook to vacate, Lord.
Vacate within
I
reasonable
have
time.
delivered 4 shops, Lord, as that is complied, Lord.
4 shops you have delivered. ಇನ್ನ
Delivered.
ಎಷ್ಟಿದೆ?
2 shops is there, but I sought only, Lord, until the 30th of July, that's all, Lord. I'm ready to.
Previous application, the CL2 is there, your law. That license is expiring on 36/2025, your law.
ಆಮೇಲೆ 13 ದಿನ ಬೇಕಲ್ಲ ಎಲ್ಲ ಎತ್ತೋಕ್ಕೆ.
Previous time ಕೇಳಿದ್ರು, ಯಾವತ್ತು
Affidavits are ready, Lord. 30th June it has been.
13th
June, Lord, the license is getting expired. Lord, I
ಯಾವತ್ತು?
need one more month, July 30
July.
ವರೆಗೂ. 30th July ವರೆಗೂ ಅಷ್ಟೇ.
30th June.
13th ಅದು ಗೊತ್ತು.
ಜುಲೈಗೆ ವೆಕೇಟ್ ಮಾಡಿ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡ್ತೀನಿ ಆ 2 shops.
Learned counsel for the petitioner submits that the order dated 18/3/2025 is complied with and 4 shops have been handed over to ನೀವ್ಯಾರು?
Landlord.
4 shops have been handed over to the landlord. Insofar as the remaining 2 shops are concerned, the counsel for the petitioner undertakes that he would vacate the shops on or before the 13th of July 2025. The said undertaking is placed on record. List the matter on 14th July 2025. Interim order subsisting will continue till the next date of hearing, subject to the aforesaid condition. Yes, next.
My lord, sorry, earlier matter 69, there is an interim order.
Continue ಮಾಡಿ.
Please, sorry.
Wait ಕೊಟ್ಟಿದ್ದೀನಿ, continue
I
ಮಾಡಿ.
didn't. Round of litigation have been drafted for the past 40 years.
I 20, list on 20th. Preliminary.
ಅಲ್ಲ,
ಬೇಡ್ವಾ?
as per ಅಲ್ಲ, my lord, as per the undertaking of the respondent, this court, they have filed undertaking affidavit also before this.
What undertaking?
They have undertaking not to construct further construction. Yes, please, there is an affidavit filed by the, as per the IA1 is passed by the modification of the status quo order. This, as per the status quo, IA number 1, they have filed the, this undertaking affidavit also.
List on 20th in preliminary hearing. Yes,
please. Allah, status, earlier status quo
Interim
order
order will continue.
Please.
Yes. Interim order subsisting will continue to the next date of hearing.
Hearing for petition.
All applications pending will be considered along with the main matter of the plenary.
Hearing for
Lords,
petition.
may I request that this matter may be taken up on Monday, my lords. Engaged the senior, second half he had little inconvenience.
Huh?
Second half the day, my lords, 3:30 he had an appointment.
Yeah, vacating stage illala.
ಇಲ್ಲ ಇಲ್ಲ ಇದು preliminary hearing ಬರಬೇಕಾಗಿದೆ.
ಅದೇ
My
so
lord,
based on
prosecuting I have filed.
Wednesday in preliminary hearing.
My lords, I appear for respondent number 3. I have not been served with the IA that is listed.
ಅಲ್ಲ ನೋಟಿಸ್ ಇನ್ನು ಇಶ್ಯೂ ಆಗಿಲ್ಲ ಇದರಲ್ಲಿ ಯಾರಿಗೂ.
Notice issue ಮಾಡಿದ್ಮೇಲೆ will direct.
ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿಲ್ಲ. Some records have been called showing that one memo is filed.
List on Wednesday.
Monday.
Monday ತುಂಬಾ ಇದೆ ಮತ್ತೆ ತೊಂದರೆ.
Thursday ಮೇಲೆ.
Thursday ಇಲ್ಲ. Monday, Wednesday or Friday? Friday? Friday. Yes.
Petition my lord. Plaintiff writ petition my lord. Now plaintiff my lord was filed the suit for my lord declaration and possession my lord.
List the matter on 18th, awaiting the appearance of the counsel for the respondent. In the event he would not be present, orders would be passed hearing the petitioner. Interim order, yeah?
Interim order.
Interim order subsisting will continue to the next date of hearing. Yes, next.
In the preliminary hearing my lord. Preliminary hearing.
No. Yes.
Like examination chief.
No, ಎಲ್ಲ ಅದಕ್ಕೆ ಆಗಲ್ಲ.
Only 3 documents.
Vacating stay ಇದ್ರೆ ಮಾತ್ರ. Yes, next.
For the petitioner's counsel, what had happened was there's a suit filed. I am the defendant in the original suit.
Who has moved the matter?
Matters moved by us. There is a situation that had arisen, which is that the defendant has a counterclaim, but thereafter the defendant went into CIRP pursuant to the orders of Delhi Milord NCLT. The consequence was that the suit claim as filed by the plaintiff is no longer something that can be proceeded.
There is an interim order.
Yes, Lord.
Why did you move it then?
But because the main matter has to be disposed and because of that CIRP is held up. That's really the point.
2021 pending is. We'll see. List the matter on 27th.
Grateful.
Heard the learned senior counsel. 27th interim order subsisting will continue to the next date of hearing. Yes. 27th, yes.
Appearing for the petitioner.
We'll take it on 27th.
One humble submission. If the matter may be listed along with another written petition.
Number
4252 of
tag the
20.
petition along with WP.
4252 of 2024.
But good.
Please.
27th, next.
Obliged.
Those 27th.
Appealing for, seeking for writ of mandamus.
Writ of
Suit for
mandamus.
partition, my lord,
ಏನಕ್ಕೆ? What mandamus?
to dispose of the matter at the earliest.
ಯಾವ ವರ್ಷದ್ದು sir?
Suit is of the year 2019, my lord. And the parties and the your lordship
Suit for-
annexed, suit for partition and separate position.
ಅದು 5 ವರ್ಷದಲ್ಲಿ ತೀರ್ಮಾನ ಆಗುತ್ತಾ?
ಇದು ಈಗ ಎಲ್ಲಾರುನು 70 dependents my lord, annexure A my lord. Dependent number 1 is aged about 74, 69, 61, 72,
You are
65.
plaintiff, is it?
My lord, I am the one of the
Dependent number
dependent.
4.
Yes, my lord, one of the dependent approached, my lord, instead of all the dependents, my lord. Therefore, my lord.
List the matter on 20th. ಇರ್ಲಿ ಅದೇನ್ ಜಲ್ದಿ ತೀರ್ಮಾನ ಆಗಲ್ಲ ಪಾರ್ಟಿಷನ್ಸ್ ನೆಕ್ಸ್ಟ್.
ಅಲ್ಲ ಅದೇನಾಗಿದೆ
ಕೋರ್ಟ್ ಇಸ್ ಬರ್ಡನ್ ಸರ್, ವೇಟ್ ಎಲ್ಲ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತಾ ಹೋದ್ರೆ ಆಗಲ್ಲ.
Manoj, serial number 78, I appear for the petitioner, Manoj.
It's on 27th.
Manoj, there's some urgency in this matter. I would not have troubled your lordships otherwise. Firstly, my lords, the parties are senior citizens. And secondly, my lords, I'm making a very simple request that my request for video conference examination be permitted. As per the rules, the court has to permit it if they find merit. Instead, the court is treating it as an IA.
Minute, that's all the prayer?
Please, my lords, that's all I'm saying. Kindly see, my lords, I've annexed the rules at page 38. In page 38 is the procedure.
Monday in preliminary hearing. Yes.
Very well. I'm grateful, my lords.
Lordships, in serial number 80, may I seek a pass over, your lordships? Senior is on his way, is coming, is on his legs in the other court. I'm sorry, appearing through VC, your lordships.
Just on 20th, yes. Next.
Lordships, interim order is there in the connected matter, your lordships. 6233, there's in.
Extended, yes.
Please.
Permanent injunction suit, my lord.
The lordship, in this case.
Section of court commissioner application, my lord.
Reject agidya.
Yes, my lord.
Correct agide.
Your lordship,
My lord,
it becomes
here the case
infructuous
is, my
because.
lord, we are running.
Infructuous.
Why?
Because your lordship, the suit has been decreed. They filed a miscellaneous application.
Yes, sir.
CRP was filed and we've conceded it to let the proceedings be from the stage where it had stopped. We had agreed to it, your lordship.
My lord, suit is restored by this honorable court. And during the pendency of the case, we moved.
How will this survive, sir? It is in
My
a
lord,
suit
here
that
the
had
case
been
is
decreed.
case is the defendant's.
It is for petitioner's evidence is
After
already done.
restoration of the suit only, we have filed this application, my lord. The suit is still pending.
When was the order passed?
CRP order passed on.
Adala, madam. When was the order in order 26 rule 9 passed?
My lord, I will tell you.
Before the suit got decreed, right?
No, my lord. After the
restoration.
Yes, sir.
Court commissioner is appointed.
Court commission application is rejected on 17/3/2025.
Suit restore agide avatu.
8/1/2025.
Application hakide avatu.
Application. March of 2025 only. Page number, annexure K, my lord.
So it is
99.
after,
Page
after
number 99.
restoration. What is this?
Your lordship.
Everything has happened after restoration.
Page number 99. Annexure K.
First time ಬರ್ತಾ ಇರೋದಾ?
Second time. My lord, we are running the school, my lord, in the
Monday preliminary hearing.
Please.
For the petitioner in this matter, that's for the petition. But the suit for declaration and injunction came to be decreed, my lord, against which I have preferred an appeal, regular appeal before the appellate court, first appellate court, wherein, my lord, I have filed an application for stay of the further proceedings pursuant to the decree. That application came to be rejected, my lord, against which, my lord, this writ petition. The impugned order, my lord, at page number 17 may kind.
What's the next date there? This is first time coming.
The execution has been moved. 11th is the next date of hearing in the execution. They are
Monday,
seeking for possession.
Monday preliminary hearing. Yes, next.
Oblige. 10th may kindly.
Monday or Wednesday?
Please.
ಯಾವ್ದು ಬೇಕು?
Wednesday ಅಂದ್ರೆ again 11th ಬಂದ್ಬಿಡುತ್ತೆ. Execution ಇದೆ ಸ್ವಾಮಿ.
ಅದಕ್ಕೆ ಮಂಡೇನೆ ಬನ್ನಿ.
ಇಲ್ಲಿನ notice has served, that's it.
Wait. Yes. Next. Settlement ಅಡ್ಜನ್ ಆಗಿದೆಯಲ್ಲ? Yes. ಕರಿತಾ ಹೋಗಿ. ಇದೆಯಾ? ಎಷ್ಟನೇ ಮ್ಯಾಟರ್ ಮೇಡಮ್ ಅದು ಇವ್ರದ್ದು? ದಮ ಶಿಷ್ಯರನ್ನೇ. ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಇದೆಯಾ? ಇದು ತುಂಬ ಇದೆ ಇದು. ಅಲ್ಲ ಜೇಮ್ಸ್
The lordships kindly Dharwad VC list, please. Please. Please.
Steel Hypermart. Where is Prasanna Kumar?
The other side not remand.
Not sought certain amendments, not which has been
Supreme
allowed by
Court
your
has
lordship.
directed expeditious disposal, sir.
Amendment in an objection ready ಮಾಡಿ ಕಳಿಸಿದೀನಿ ಮೇಡಮ್. I may require 1 or 2 days time to get approval. I know last time, not your lordship was kind enough to not allow the application. They also for not filed the amended.
You are there, madam. All right, Wednesday.
Please.
When Thursday ಹಾಕೋಬೋದಾ so if possible?
ಹಾ, ಇದು Thursday ಆಗುತ್ತೆ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಆಗುತ್ತೆ.
Thursday.
Please.
Thursday.
As I am online, I wonder whether it's my matter.
Sir, 4 o'clock sharp, I will take it.
So be it.
Yes.
4 o'clock, sir.
ನಿಮ್ದಲ್ಲ ಮೇಡಮ್, ಇನ್ನೊಂದು.
This Dharwad matter, one mistake on my part.
ಏನು?
ಅದು ಇವತ್ತು ಲಿಸ್ಟ್ ನೋಡದೆ ಅದು ಹೆಸರಿಲ್ಲ ಅಂತ ನೋಡಿ, I could not get the file, but this is Dharwad matter.
ಹಾ, ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಅದು.
ನಾನು ಇದು ನಮ್ಮ ಬೆಂಗಳೂರು ಲಿಸ್ಟ್ ನೋಡಿದೀನಿ.
ಅದರಲ್ಲೂ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ has directed expeditious disposal.
6 was the date given by your lordship. I had also noted down.
ಮತ್ತೆ
ಇದರಲ್ಲಿ ಅದು ಲಿಸ್ಟ್ ಬಂದಿಲ್ಲ ಅಂತ ಬರಲಿಲ್ಲ.
ನೋಡೋಣ,
let him start. Please.
84 is
Sir, you can start, I'll hear. Then for his submissions, I will fix a date.
So be it.
Yes.
I'm willing.
4 o'clock, sir.
Please.
Yes.
So.
Next week.
ಏನಿದು?
This matter was heard by your lordship, my lord, sir. The petitioner was moving towards his house, my lord. So the police officials were appointed as to check the drink and drive, my lord. While checking drink and drive, my lord, so the
drunk and drive,
my lord. So the petitioner, the allegation is that, my lord, petitioner is about to.
ಏನ್ 353 ನಾ?
307, they invoke 307, my lord.
ಓ, ಅದು ಕಾರಲ್ಲಿ
drink and drive check ಮಾಡಬೇಕಾದ್ರೆ 307. And the coordinated bench of this honorable court, my lords, held similar issue. My lords, there is a circular by the commissioner of police.
Close it. ಯಾಕೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? ಇರ್ಲಿ ಬಿಡಿ, ನೀವು ಫಸ್ಟ್ ಟೈಮ್ ಕೇಳ್ಬಿಟ್ರಲ್ಲ.
No, my lords.
Yes. Next Friday ಆಗಲ್ಲ, Thursday. Yes. ಅದು ಒಂದ್ಸರಿ ಕೇಳ್ಬಿಟ್ಟ ಮೇಲೆ ಆಗೋಯ್ತು.
Similar issue is already covered.
Interim order subsisting will continue till the disposal of the petition. Yes. Next.
My lord, I appear for the
7A.
ಇಲ್ಲ, ಇದು SIT mining matter. SIT mining.
Interim order ಇದೆಯಾ?
Interim order ಇದೆ. Detailed order.
My order?
ಇಲ್ಲ.
Yes. 27th.
Great.
Interim order subsisting will continue to the next date.
Please.
I appear for the petitioner. Section 499 defamation.
See, the order dated 4/7/24.
Stay ಇದೆಯಾ?
Yeah.
Same. 27th. Interim order subsisting will continue to the next date of hearing.
Please.
Next.
Grateful.
In these matters.
Wiretapping ಇದು?
No, not wiretapping.
Oh, that 2000 rupee notes demonetization.
Demonetization with bank officials.
ಅಲ್ಲ ಆಲ್ರೆಡಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ ಸರ್, ಟೈಮ್ ಬೇಕು ಅಂತ. ಅವ್ರಿಗೆ ಆಲ್ರೆಡಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ದೀನಿ ಸರ್, ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಬೇಡಿ, ಟೈಮ್ ಬೇಕು.
ಅಬ್ಜೆಕ್ಟ್ ಮಾಡದೆ
ಚೆಕ್ ಮಾಡಲ್ಲ, ಅದು ಇನ್ನೊಂದು ಕೋರ್ಟ್ ಖಾಲಿ ಇದೆ, ಅಲ್ಲಿ ಕಳ್ಸಿ.
ಯಾವ್ದಿದು?
22.
ಮಾಡ್ಲಾ? ಇಲ್ದ್ರೆ ನಾವ್ ಯಾವಾಗ ತಗೊಂತೀವಿ ಅವಾಗ ತಗೋಬೇಕು. 27. ಇದಾರೆ ಬೇಕು ಅಂದ್ರೆ ಕಳಿಸ್ತೀವಿ. 24th ಆದ್ರೆ ಹೂ ಅನ್ಬಿಡ್ತಾ ಇದ್ರೆ. Yes. Interim order subsisting will continue to the next date of hearing. Yes.
Serial number 89, all the connected matters pertain to a BDS scam matter, my lords.
ಯಾವ scam?
BDS scam.
BDS scam.
Against all the public servants, matter has been quashed.
Oh, these are others.
It is. Creation of records, creation of all the.
Your ಮೇಲೆ
Against Indar Kumar, my lords, accused number 2.
Public servants for want of sanction I have quashed. ನಿಮಗೆ ಯಾವ sanction ಬೇಕು?
All sanctioned on the merits of the case, my lords. Senior counsel Sandesh had argued the matter substantially, my lords.
I will take it. List on interim order ಇದೆಯಾ?
Interim order is there in place.
Again 27th.
Name of Arnav may be deleted from the cause list, my lords.
Arnav ಇಲ್ವಾ?
ಅಲ್ಲ, NOC ಕೊಟ್ಟಿದ್ದಾರೆ, so his name has to be deleted.
Preet is there.
Please.
Registry ಇದರಲ್ಲಿ ಮೇಡಮ್ 89 ಅಲ್ಲಿ registry to delete the name of Arnav Bagalwadi as appearing for the petitioner. Yes. Next. 90.
Petitioner in the first matter.
Petitioner for 90.1.
LOC.
LOC ಅವ್ರದ್ದು, ನಮ್ದು for quashing the ROC complaint.
Actually, this is regarding LOC, and there are criminal petitions as far as directors are concerned.
ಏನ್ ಮಾಡೋಣ ಹೇಳಿ?
Both are
ಒಂದೇ.
posted for direct.
Posted for what?
It was argued earlier. Tuesday, my lords, as far as charter account is concerned.
Tuesday.
Tuesday.
Tuesday it will be repeating till it is disposed. Yes.
Your lordship, could it be on?
No, it will, whenever you come, we will take it.
13th, 12th, sir.
Whenever you come, we will take it. Yes.
No.
ಅವ್ರದ್ದು ಕೇಳಿರ್ತೀನಿ, whenever you come, we will take it. Yes, next.
It was argued actually. It was argued.
I know it's argued also. Yes.
Could it be 13th, my lords, 12th?
ಪರವಾಗಿಲ್ಲ, ಅದಿರ್ಲಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ, ತೊಂದ್ರೆ. Yes.
Interim order to be.
Settle continues.
Great.
Lords, I appear for respondent number 2. Kindly have it next week, my lords.
On the 16th or the 17th?
Please, my lords.
All right, yes.
Much obliged.
17th. Interim action ಮಾಡ್ಬಿಡಿ ಎಲ್ಲದರಲ್ಲೂ. Special court matter ಇದೆಲ್ಲ. 92 is by special order.
92. This case, my lord, I'm appearing for the respondent.
ಇದು ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಒಂದಿತ್ತಲ್ಲ ನಾಯಕ್ ಸರ್ ತಮ್ದು.
Next matter, please.
ಅದೇನಾ?
93.
Yes.
Shall I make a submission in that?
ಹೇಳಿ ಸರ್.
Interim order of stay granted.
ಹಾ.
Interim order itself speaks the entire issue, please.
In which?
In that 93, please.
Yes.
It speaks about the final.
ಇವರು ಇದಾರಲ್ಲ ಇಲ್ಲಿ. ಆಯ್ತು, ಇದು ಅಡ್ಜನ್ ಮಾಡ್ಬಿಟ್ಟು ತಗೋಣ.
Please.
ಪಾಷಾ ಸರ್.
This case, my lord, I moved the matter, my lord. Because
you moved the matter.
Yes, my lord. Reserve for
ಇದು ರಿಸರ್ವ್ ಆಗಿತ್ತು.
Yes, my lord.
Yes.
They submitted that, my lord, 379 and 420 not come together. Because 379 is there, and either it's theft or 420. 120B is there, my lord. Accused number 16 is the minor owner, and accused number 16 is also party. And extract they entrusted the as per the lease, my lord, the lease area to the accused number 16. They conspired together, accused number 1 to 16. They extracted mine in some other area also, and transported the mine, the minerals.
The mine.
Mineral to the Mangalore port. That is the reason, my lord, this 120B is there. That is the reason, my lord, 379 as well as 409 and 420 is applicable. And that they cited one decision. It is not applicable to this case, my lord.
ಅಷ್ಟು ಹೇಳಕ್ಕೆ ಮೂವ್ ಮಾಡಿದ್ರೆ.
No. On that day, it's ಅಷ್ಟು ಹೇಳಬೇಕಿತ್ತು.
ನೀವು ಇದ್ರಲ್ಲ ಅವತ್ತು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದೀರಾ?
ಅವತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದೆ, ಬಟ್ ಅವತ್ತಿನ ದಿವಸ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ ನನಗೆ. Yes, sir. And they said,
ಇಷ್ಟೇ ಹೇಳದೆ.
And Sanjay case also, my lord.
ಅವರು ಸರ್ ಹೇಳಿದ್ದೀರಾ ಅದು?
Sanjay case,
my lord, also here, you lordship, kindly, my lord, these petitioners, they purchased, my lord, in the port plot. My lord, Mangalore new port plot, my lord, 139,000 metric ton of iron ore.
Because he moved it, I have not done it. Otherwise, our order is ready, we will do it.
The question of conspiracy does not arise. When they have purchased in the port plot, conspiracy should be prior to commission of offence.
The port auction will ತಗೊಂಡಿರೋದು.
Yes,
port,
in the
port you have taken it.
Purchase
it from the port.
In the port auction, my lord, it was purchased.
No,
it is purchased from accused number 8, my lord.
Pardon?
ಇನ್ನೊಂದ್ರಲ್ಲ kinetic ಏನಾಯ್ತು?
No, but this is not a port. Even this port also, my lord, it's applicable because without any aspirants to purchase the proper my iron ore, they can't transport the 20,000 metric tons to Mangalore port. And in that case, my lord, the shortage of the ore, my lord, they have taken a contention. Even then, my lord, it's not permissible. And in this case, my lord, they purchased various place and transported. They are also transported the iron ore.
Lord, sorry, this lordship, here accused number 16 is the mine lease holder, my lord.
This is what his contention is. I'll take it on Tuesday. Aden reply ಕೊಟ್ಬಿಡಿ. ಅವತ್ತು ಮತ್ತೆ will. Otherwise, the order is ready. He moved it. I had to post it.
Lord, I guess
Tuesday ತಗೊಳ್ಳ?
Tuesday, my lord.
Tuesday ನಿಮ್ಗೆ ಯಾವಾಗ ಫ್ರೀ ಆಗುತ್ತೆ ಅವಾಗ ಬನ್ನಿ.
Yes.
After 3:30.
Yes, my lord.
ಸಂಜೆ ಕೇಸ್
ಅವ್ರಿಗೆ ಕೊಡಿ.
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೆ.
ಕೊಡಿ.
Interim order to continue.
That's it. Interim order stands extended till the disposal of the petition. Yes, next.
Plus, this is the case wherein please not I appear for all the.
ಎಲ್ಲಿ ಅವರು ಇದ್ರಲ್ಲಿ?
Plus, the order dated 15/9/2023.
That's
passed by this.
my order. Yes.
Your lordship's
Detailed order.
It's
a detailed order.
That is a detailed order. I am permitted to read it, please, my lord.
Not necessary.
Not required. Plus,
Yes, sir. Complainant ಯಾರು?
84. I am for the.
ಹೇಳಿ sir.
Lord, I seek 2 days time, Lord. I shall argue on Monday itself.
Why?
Lord, 2 days, my Lord. Because, my Lord, they have submitted certain documents, my Lord.
When did they submit? 2 months ago.
My Lord. Lord, this, Lord, prior to this complaint, my Lord, there was a suit filed by us, my Lord. Wherein, my Lord, there is an order.
You tell me anything. How will Atrocities Act get attracted?
Lord, it's a sequence of, my Lord, your Lordship may kindly see the complaint, my Lord. Complaint at the starting stage itself, my Lord. They have, Lord, your Lordship may kindly see the first sentence of the complaint.
ಎಲ್ಲ ದುಡ್ಡು ಇಸ್ಕೊಂಡ್ಬಿಟ್ಟು ಆಮೇಲೆ atrocity.
ದುಡ್ಡು ಇಸ್ಕೊಂಡಿಲ್ಲ. That is what. That is the reason, my Lord. Your
ಅದನ್ನ
Lordship had directed
6 months ಇಂದ ಹೇಳ್ತಾ ಇದ್ದೀರಾ, ದುಡ್ಡು ಇಸ್ಕೊಂಡಿಲ್ಲ, ತೋರಿಸ್ತೀನಿ ಇದೆ. ಎಲ್ಲ ತಗೊಂಡಾಗಿದೆ. They have produced everything, bank statements.
Bank statements are produced, my Lord. My Lord, there are 2 documents they are relying upon, my Lord. One is the sale deed. One is the exchange deed, my Lord. Lord, your Lordship may kindly see.
You having taken entire consideration, you have executed the sale deed.
Lord,
After execution of the sale deed, you initiate proceedings under the Atrocities Act.
No, my Lord. It was not after.
If this can't be misused, what else can be misused?
My Lord, one submission.
They go to the civil court. Civil court refuses an injunction.
ಆಮೇಲೆ atrocities case.
Correct. There was an order of injunction, my Lord. They have come up to my property, trespassing to my property, my Lord, with filthy language. That's what my case is, my Lord. Till Supreme Court, they had been to still Supreme Court, my Lord. The Supreme Court has rejected their claim.
What claim?
For injunction, my Lord.
Injunction.
For setting aside an injunction order.
So ಅದಕ್ಕೆ atrocities case.
No, my Lord. Prior to that, the atrocity case was initiated, my Lord. It is not only atrocities, my Lord. The case includes a 420, my Lord. That is the case, my Lord. It is not only atrocities, my Lord. Your Lordship may kindly see the complaint. At the first sentence of the complaint, it just speaks for itself, my Lord.
ಓದಿ. ಏನ್ first sentence?
Your Lordship.
ಇರ್ಲಿ ಬಿಡಿ.
Page 16.
ಓದಿ.
Page 16, my Lord. ನಮ್ಮ ಜಮೀನಲ್ಲಿ ಅಕ್ರಮ seven hills ಡೆವಲಪರ್ಸ್ ಅಂಡ್ ಟ್ರೇಡರ್ಸ್ ಡಿ ಸುಧಾಕರ್ ಶ್ರೀನಿವಾಸ್ ಜಿ ಮತ್ತು ಭಾಗ್ಯಮ್ಮ ವೈಫ್ ಆಫ್ ಶ್ರೀ ಶಿವಮಲ್ಲಯ್ಯ ಎಂಬುವರು ಸುಳ್ಳಿನಿಂದ ಕೂಡಿದ್ದು ಮೋಸದ ಕ್ರಯಪತ್ರ ನಮ್ಮಿಂದ.
ಮೋಸದ ಕ್ರಯಪತ್ರ.
ಪ್ಲೀಸ್
ಹೌದಾ?
ಪ್ಲೀಸ್.
ವೈ ಡಿಡ್ ಯು ಟೇಕ್ ಮನಿ? Consideration ಯಾಕೆ ತಗೊಂಡ್ರಿ ಸೇಲ್ ಡೀಡ್?
The very suit itself was filed, my Lord. It is non-est factum, my Lord. Under the pretext of.
If you have already filed a suit, contest the suit. How will it become a case under Atrocities Act, you tell me?
Lord, it is not only atrocities, my Lord. I am relying upon, my Lord. The entire case is, my Lord, it is a fraudulent transaction which are transpired.
Where is the money?
My Lord, the entire sale.
Where is the money?
My Lord, that is the reason, my Lord. They have produced the entire set of documents.
ಇಷ್ಟೇ ಆಗಿರೋದು. You have sold it to them, taken all the consideration. Somebody has given you a better offer, so you want to wriggle out of this.
Please.
Initiate proceedings and wriggle out.
It is not that way, my
Lord. Twist them to come to a settlement to get everything back.
Two documents, my Lord. One is the sale deed, one is the exchange deed, my Lord. My Lord, they sell the property. They exchange a property to the property at Chalkire, to the property at Yelanka, my Lord. They extend the difference of amount. They obtain a loan. Your Lordship may kindly see the loan, my Lord. What they obtained over and above the sale price, my Lord. It is more than 100 crore. What
100 crore.
Please, my Lord. Your Lordship may kindly see. The document says, my Lord.
ಎಷ್ಟಕ್ಕೆ ತಗೊಂಡ್ರಿ ನಿಮ್ಮಿಂದ? ಅಷ್ಟೇ 25 crores ಗಾ?
Nine crores, my Lord.
9 crores.
Please, my Lord.
Now you feel the value is more, so initiate.
It is not value, my Lord. My Lord. Your Lordship.
ಎಷ್ಟು ಎಕರೆ ಇದು?
It is 1 acre 33 guntas.
Where?
Yelahanka.
All right, yes. Monday.
By Wednesday, my lord.
Umpteen number of times. it is
Monday
adjourned.
last time.
Wednesday, my lord.
Unless it is
No,
a-
no, Monday, yes.
as last chance.
Monday last chance.
Last chance ಅಂತಾನೆ ಇದು ಒಂದು ಆಗ್ತದೆ.
It may be noted.
One more last chance.
Finally last chance.
Or,
Lord, by Wednesday, my lord.
no, sir.
Monday, I'm not.
Come,
Please, Lord,
come
by
back, sir. Where are you going?
Lord, Chikbalapura, I have an argument.
Chikkbalapura. California ಹೋದಂಗೆ ಹೇಳ್ತಾರೆ. ಬನ್ನಿ.
Arguments, my lord. By
Yes,
Wednesday.
yes. No, no, no.
Wednesday, my lord.
Monday.
Wednesday, please, my lord.
Monday you come after 3:30.
Lord, Wednesday, my lord.
Monday you come after, illa, Tuesday you come.
Tuesday.
Yes, Tuesday.
Tuesday, please, my lord.
Just on Tuesday.
Please, my lord.
Interim order may kindly
That will
be.
be interim order. 27th, yes. 94 ಎನ್ನಿ ಕೇಸ್ ಅಡ್ಜರ್ನ್ ಆದ್ಮೇಲೆ ಬರ್ತಾ ಇದೀರಾ?
Sorry.
27th, yes.
Post for judgment lord already submitted in 94.
Yeah, ಏನಿದು?
Two departmental inquiry. One is my lord.
ಬರ್ಲಿ ಅವ್ರು ನೋಡಿ. 20th ಹಾಕಿ. Yes, list on 20th. Next.
Notes. I appear for the petitioner in 95.1 and 95.7, my lords.
20th, yes.
Obliged. There is an interim.
Interim order ಇದ್ರೆ continue.
Obliged.
Cat named Daisy, yes, reserved.
Please, get. Let's, once again, the
Therefore, the
exoneration in the
ಏನಿದು?
departmental
Trap case,
inquiry.
Trap case. 7A.
7A.
What stage proceedings?
Millards, it's not started, Millards. It is already
Interim order
exonerated.
ಇದೆಯಲ್ಲ?
Interim order is there.
20th, yes.
May I?
Objections ಹಾಕಿದ್ದೀರಾ?
May I just pass
After
out
23rd,
the,
my lord.
Objections ಹಾಕಿದ್ದೀರಾ?
Objection ಹಾಕಿದೀವಿ. After
ಹಾಕಿ-
23rd, my lord. 24th or 25th.
27th ಬರ್ಲಿ ಬನ್ನಿ.
Yes, please.
Departmental inquiry.
Departmental. Exonerated, I was.
What I heard yesterday ಅದೇ ತರ.
ಅದೇ ಇದ್ರೊಳಗಡೆ ನಾನು FIR ಅಲ್ಲೂ ಇಲ್ಲ. I am not an accused in the FIR. Trap was done and somebody else has been arrested.
Departmental inquiry is you're exonerated?
Yes, I have been exonerated.
Let's see. 27th interim order subsisting will continue till the next date of hearing. ಇದು put it into the file.
Please, ma'am.
ಯಾವ್ದು ಅಬ್ರಾಹಂ ಇದಾರ? ಯಾವ್ದು? One I heard there.
Millards, this is a case where Millards,
Yes,
a
finish the
private
submission.
complaint was filed against the erstwhile officer of the BDA.
All right.
Private complaint.
You have challenged that, is it?
Millards, including Millards, the PMLA, the provision under the PMLA Act has been involved.
ಇದ್ರಲ್ಲ.
Idrolagade, Millards, the trial court, it has no jurisdiction at all. Instead of returning the complaint, Millards, refer the matter for the investigation. It will
Even
cut to
under the
root-
PMLA.
PMLA, entire case has been referred as it is. Millards, I can understand, Millards, if the court has no jurisdiction, that's why I am referring only for these offences when I can understand. Millards, the entire complaint as it is, it has been referred to the investigation. And Lokayukta police, Millards, realizing that they don't have the power under the PMLA, they will remove that and only register for the offence under the provisions of the PC Act. Millards, a private complaint, the Priyanka Srivatsava has not been.
We'll see. We'll hear it on Tuesday. Tuesday at 3:30. Tuesday is all right?
Wednesday, Your Honor?
All right. Tuesday, Wednesday, any day you want.
Sorry, Your Honor, Thursday.
All right, Thursday.
Because I have matters in the
No
special.
problem. That is why I asked you.
Thursday.
Yes, Thursday.
Just pass it.
List on Thursday. Come after 3:30.
Yes.
Yes. Next.
For petitioner. Millards, interim order.
That list.
Please.
Pokso case, 16.6.
99 N.
Pokso case,
16 years, 6 months.
6 months.
Stay
Settlement
ಇದೆಯಾ?
ಅಂತ ಆಗುತ್ತೆ.
Stay ಇದೆಯಾ? Stay ಹೆಂಗ್ ಸಿಕ್ತು?
ಅಲ್ಲ ಮ್ಯಾರೇಜ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ಬೇಕು ಅಂತ ಕನ್ವಿನ್ಸ್ ಆಗಿತ್ತು ನನಗೆ.
16 years, 6 months.
ಅಲ್ಲ 2.5 years ಮಗು ಇದೆ ಮೇಲೆ ಮಗು ಇದೆ ಅಂದ್ಬಿಟ್ಟು ಕನ್ವಿನ್ಸ್ ಆಗಿ
16 ಪಾಯಿಂಟ್ಸ್ ಈಗ ಎಷ್ಟು ವಯಸ್ಸು?
ಮಗುಗೆ 2.7.
ನಿಮಗ್ ವಯಸ್ಸು ಎಷ್ಟು ಸರ್ ಈಗ?
ನನಗೆ
ನಿಮ್ಗಂದ್ರೆ ಮದರ್ಗೆ?
ಮದರ್ಗೆ 21.
At the time of incident she was 16.6.
ಡಾಕ್ಟರ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟರು. ಮ್ಯಾರೇಜ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ಬೇಕು.
Let's see. Wait. List on 27th. Is it 20th? ಅದು 20th. ಎಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿರೋದು ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
ಇದರಲ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಫೀಸರ್ ಹ್ಯಾಸ್ ಟು ಫೈಲ್ ದಿ ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಮೇಲೆ 2017.
Here for the complainant.
Yes. No, no. For the petitioner, I am.
We'll take it on Tuesday. List on Tuesday.
Please.
Yes. Rudresh, ಏನ್ ಮಾಡಿದ್ರಿ 10 ಲಕ್ಷ?
ಎನ್ಕ್ವೈರಿ ನಡೀತಾ ಇದೆ. ಸೊ
ನಡೀತಾ ಇದೆ ಅಂತಲ್ಲ?
They have conducted the inquiry. I have appeared before the.
Very good.
We have issued
Disposed ಯಾಕೆ? ಬೇಡವಾ? ಎನ್ಕ್ವೈರಿ ನಡೀತಾ ಇದೆಯಾ?
ನಡೀತಾ ಇದೆ.
The counsel for the petitioner is before this court seeking the following prayer. The learned counsel for the petitioner in person submits pursuant to the orders passed by the pursuant to the directions of this court. Departmental inquiry.
Not department.
What inquiry?
So they have filed a FIR against.
A crime has been registered against the Tahsildar who had demanded 10 lakhs over the telephone to the petitioner himself. Therefore, the petitioner in person submits that the petition be disposed, reserving liberty to knock at the doors of this court in the event of need. Recording the said submission, the petition stands disposed, reserving such liberty. Yes.
My lord, kindly be taken on record on this.
Yen crime?
Memo, my lord. We have issued notice to the complainant friend, my lord, Umesh.
ಬಂದಿದಾರಲ್ಲ ಅವರು? ಯಾಕೆ ಬರ್ಲಿಲ್ವಾ ಅವರು?
ಉಮೇಶ್ ಅವ್ರು ಬಂದಿಲ್ಲ, ಇನ್ನು ಬರ್ತಾನೆ ಇಲ್ಲ ಅವರು.
Notice has been issued to him.
ಬರ್ತಾರೆ. Do it, leave it, don't worry. Yes.
But the FIR is registered only against me.
Against you?
Against me, my lord. Therefore, I have filed a petition for quashing the FIR. Matter was heard thrice.
ಅಲ್ಲ ಇದು ಮತ್ತೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಬೇಕು ಅಂತೀರಾ?
Yes, my lord.
ಇದು this is a crime registered against you.
Against me. They have demanded 10 lakhs.
Then we will have to pass a detailed order. It can't be like this, sir. Yes, the list on Tuesday. We'll pass a detailed order.
One Supreme Court judgment.
ಕೊಡಿ ಏನು ಕೊಡ್ಬೇಕು ಕೊಡಿ.
Memo, my lord.
Yes, next. Yes.
Tuesday, my lord.
ಅದು 353.
353.
Yes, next.
Memo, my lord. Memo.
ನಿಮ್ದೇನು ಸರ್? ಜಡ್ಮೆಂಟಾ?
ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದು ಮತ್ತೆ ಎನ್ಕ್ವೈರಿ ಕಂಡಕ್ಟ್ ಮಾಡಿದಲ್ಲ.
ಅದು ಪರವಾಗಿಲ್ಲ ಬಿಡಿ.
Yes.
Petitioner. This is after 7 years, your lordship, they have.
After 7 years.
Because of the incident, your lordship, they registers an FIR.
My lords, the
Largest
trial court
complaint.
specifically made an observation that prima facie is available. The FSL report also suggests the same.
ಸ್ವಾಮೀಜಿ.
ಹೌದು. ಇನ್ಫ್ಲೂಯೆನ್ಷಿಯಲ್ ಅದನ್ನು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
ಇನ್ಫ್ಲೂಯೆನ್ಷಿಯಲ್ ಸ್ವಾಮೀಜಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ, my lords. The trial court has only specifically made that observation in the
20th. That's one parted but Supreme Court remand
my lords.
Interim order may be.
Evidence has not commenced for so long.
Interim order
Witnesses ಮೇಲೆ FIR ಮಾಡಿಸಿ ಅದು ಬಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ ಇವಾಗ.
20th. ಬಿ ರಿಪೋರ್ಟ್ ಯಾವುದು?
ಇವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ after the complaint is filed by the victim, my lords, the people who ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಯಾರು ಐ ವಿಟ್ನೆಸ್ ಆಗಿರ್ತಾರೆ ಅವ್ರ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ, ಫಾಲ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ. ಅದು ಬಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ. I will provide the B report as well before this honorable court. Witness ಗಳನ್ನೆಲ್ಲ ಈ ತರ ಇದು ಮಾಡ್ತಾರೆ.
ಬಟ್ 7 ವರ್ಷ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
My lords, she was subjected to harassment for 7 long years. Pokso idu.
Correct sir. Pokso ನೀವು 17 ವರ್ಷ ಇದ್ದಾಗ ಆಗಿದೆ ಅನ್ಬಿಟ್ಟು 25ನೇ ವರ್ಷಕ್ಕೆ ಹಾಕಿದ್ದೀರಾ.
My lords, that is not the case. ಏನು ಅಂದ್ರೆ he has threatened her for so long.
We'll see.
When ಇನ್ನೊಂದು ಅವ್ರು
ಮಾಡಿದಾಗ ನೋಡಿ,
ಯಾವಾಗ ಅವ್ರ ಕಸಿನ್ ಕರ್ಕೊಂಡ್ ಬಾ ಅಂತ ಕೇಳಿದಾಗ that is when the breaking point. That is when the case she has come out.
ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ ಬಾ ಅಂತ ಹೇಳೋದು.
ಇಲ್ಲ ಸ್ವಾಮಿ, that's allegation, that's their allegation.
Yes, my lords.
List on 20th. ಅವತ್ತು ಮುಗಿಸೋಣ.
Grateful man.
Finally, my lords,
finally.
Interim order may be extended.
Don't extend the interim order. Yes.
105 appear for the petitioner
What is this?
This is with respect to the KPID Act, my lords, and multi-state cooperative societies.
Oh, that multi-state matter.
Yeah, please, my lords, please.
Yes. 27th interim order subsisting will continue till the next date of hearing.
Gratefully.
Say, POCSO matter. Reverse POCSO, my lord. 14 years by my lord.
Who appears for the respondent?
I appear for the respondent.
An unvoiced appearance.
I have filed statement.
4 years delay, my lord.
I appear for the
The case is so strong that it is echoing.
My apologies, my lord. I was on the way to the court. I filed my statement of objections today morning. My senior is not keeping well, my lord. A short date may kindly be accommodated. My senior will appear and argue the matter.
Heard the learned senior counsel.
It may be held on Monday.
Except allegation, my lord. Except allegation in the complaint, my lord. It's not substantiated with any corroboration. No corroboration is there. Yes. Please. Yes.
Interim order subsisting will continue to the next date. Food safety. Shanti Bhushan.
I appear for FSSAI, my lord, in this matter.
Yes. Ready?
Some other day.
Why?
Senior is not available now.
Tuesday, finally. 2012, sir.
Very well. Tuesday.
List on Tuesday at the request of the council appearing for the petitioner.
Obliged.
You are there? Yes. Tuesday. Yes.
My lord, kindly have it next week, my lord.
20th. ಇದು ಅಷ್ಟೇ ಸೇಮ್ ಡೇ 20.
Safai Karmachari's matter, my lord.
Yes.
Before vacation, they had said that they would.
What happened, madam? Payment ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀವಿ, my lord. Out of
ನಮ್ಮ
190
ಕ್ಲೈಂಟ್ಸ್
we
ಕಂತೂ
have.
ಒಬ್ರಿಗೂ ಬಂದಿಲ್ಲ. ನಮ್ಮ ಕ್ಲೈಂಟ್ಸ್ ಕಂತೂ ಒಬ್ರಿಗೂ ಬಂದಿಲ್ಲ.
My lord, out
ಯಾರಿಗೆ
of
ಮತ್ತೆ ನಿಮಗೆ ಯಾರಿಗೆ ಬೇಕು ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
no, my lords. Out of 190 we have given for 137 ಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ. Petitioners ಯಾರು 53 ಜನ petitioner in one petition, that is Grievance petition, they were not come before us. ಅವ್ರಿಗೆ ಕೂಡ ಲೆಟರ್ ಮೂಲಕನೂ ಮತ್ತೆ ಖುದ್ದು ಅಧಿಕಾರಿಗಳ
ಅವ್ರಿಗೆ ನಾವು ಹೋಗಿದ್ವಿ. ಸಪರೇಟ್ ಡಿಮ್ಯಾಂಡ್ ಇರೋದು.
1 minute. ಈಗ ಯಾವತ್ತು ಹೋಗ್ತೀರಾ?
ನಾಳೆನೆ ಹೋಗ್ತೀವಿ. ಅಲ್ಲಿ ಸಪರೇಟ್ ಡಿಮ್ಯಾಂಡ್ ಇದೆ, ಅದರಿಂದ ನಾವು
ಸಪರೇಟ್ ಡಿಮಾಂಡ್.
ಹೌದು.
No, my lords.
ಅದು I don't want to.
Allegation, my lords.
ಇದೊಂದು I may pass on this documents.
My lords, kindly see annexure C, my lord. Page number 3.
Page number?
Page number 3, my lord. ತಿಳುವಳಿಕೆ ಪತ್ರ ಅಂತ ಹೇಳಿ ಅಡ್ರೆಸ್ ಮಾಡಿ each petitioner ಗೆ we have sent it.
These documents were submitted even before 2022, my lords, and banks.
26/20/25 communication, sir.
These documents which they have submitted, my lords, after we submit those documents, they have listed us in the name of list. They have listed in the Manjurati Adesha. ಈ ಎಲ್ಲ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ ಇವಾಗ ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟೆ. May I request, my lords?
I will ask them to come appear before you on Wednesday next.
Please, my lords.
ಮತ್ತೆ I will take this on Friday or on 16th. If you have not paid, then we'll view it seriously.
My lords, page number 60, my lords, same. ಜಿಲ್ಲಾ ವ್ಯವಸ್ಥಾಪಕರು 60 ಕ್ಷರ ಬರ್ದಿದ್ದಾರೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ. ಜಿಲ್ಲಾ ವ್ಯವಸ್ಥಾಪಕರು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸಫಾಯಿ ಕರ್ಮಚಾರಿ ಅಭಿವೃದ್ಧಿ ನಿಗಮ ಕೋಲಾರ ಜಿಲ್ಲೆ ಇವರು ಮತ್ತು ತಾಲೂಕು ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ದಿನಾಂಕ 29/4/25ರಂತೆ ಸದರಿ ರಿಟ್ ಪಿಟಿಷನ್ ನಲ್ಲಿರುವ 50 ಫಲಾಪೇಕ್ಷಿಗಳ ಮನೆಯ ಹತ್ತಿರ ದಿನಾಂಕ 30/5/25ರಂದು
ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಿ GPS ಒಳಗೊಂಡ ಭಾವಚಿತ್ರವನ್ನು ತೆಗೆದುಕೊಂಡಿರಲಾಗಿರುತ್ತದೆ. ಮುಂದುವರೆದು ಸಾಲದ ಭದ್ರತೆಗೆ ಅಗತ್ಯ ದಾಖಲಾತಿಗಳನ್ನು ಸಲ್ಲಿಸುವಂತೆ ಸ್ಥಳದಲ್ಲಿ ಮೌಖಿಕವಾಗಿ ತಿಳಿಸೋದ್ರ ಜೊತೆಗೆ ಲೆಟರ್ನು ಕೂಡ ಎಂಡೋರ್ಸ್ ಮಾಡಿ. Only in one petition is left over. Rest all the petition.
ಈಗ ನಿಮ್ ಜೀವನ್
ಆ ಫೋಟೋಸ್ ನೋಡಿ ಆ ಸರ್ವೆ ಮಾಡಿರೋದು ನಿಜ, ಅವತ್ತೇ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ತಗೊಂಡೋಗಿರೋದು ನಿಜ. ನಾವು ಅವ್ರ ಹತ್ರ ಹೋಗಿಲ್ಲ, ಯಾಕೆ ಹೋಗಿಲ್ಲ ಅಂದ್ರೆ there was a separate demand made, ಅದಕ್ಕೋಸ್ಕರ ಹೋಗ್ಲಿಲ್ಲ.
137 ಜನ ರಿಸೀವ್ ಮಾಡಿದ್ದಾರೆ.
It is a fact.
Only 50 ಜನ ಬಾಕಿ ಇದ್ದಾರೆ ಮೇಲೆ.
ಈಗ ವೆಡ್ನೆಸ್ಡೇ they'll come. All right.
ಆಮೇಲೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ರೆ ಮಾತ್ರ ನಾವು ರಿಲೀಸ್ ಮಾಡ್ತೀವಿ.
ಈಗ ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ರಲ್ಲ ಇವ್ರನ್ನ,
ಮಂಜೂರಾತಿ ಆದೇಶ ಕೊಡಕ್ಕಿಂತ ಮುಂಚೆ
ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ರಲ್ಲ ಮುಂಚೆ, ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಮಾಡಿ? ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನೋಡ್ಬಿಟ್ಟು ತಾನೇ ಮಾಡಿದ್, ಮತ್ತೆ ಯಾಕೆ ಕೇಳ್ತಾ ಇದೀರಾ ಡಾಕ್ಯುಮೆಂಟ್ಸ್?
ಲಿಸ್ಟ್ ಅನ್ನು ಕಳ್ಸಿರ್ತಾರೆ. ಈಗ
ಲಿಸ್ಟ್ ಅಲ್ಲಿ
8 ವರ್ಷದ ಹಿಂದೆ we have received the documents ಮೇಲೆ.
ಈಗ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬೇಕು ನಿಮ್ಗೆ?
ಅದನ್ನು ಹಾಕಿದ್ದೀವಿ, ಅನೆಕ್ಸ್ ಮಾಡಿದ್ದ ಅರ್ಜಿ ನಮೂನೆ, ಭಾವಚಿತ್ರ 3 ರೀಸೆಂಟ್ ಫೋಟೋಗ್ರಾಫ್
ತಗೊಂಡಿದ್ದೀರಲ್ಲ ಆಲ್ರೆಡಿ.
ಅಲ್ಲ,
ಆಯ್ತು, ಪಾಸ್ಪೋರ್ಟ್ ಸೈಜ್ ಫೋಟೋ, ಆಮೇಲೆ
ಗುರುತಿನ ಚೀಟಿ,
ವೋಟರ್ ಐಡಿ,
ಅಲ್ಲ ಅದು ಸಫಾಯಿ ಕರ್ಮಚಾರಿ
ಅವ್ರದೇ ಗುರುತಿನ ಚೀಟಿ,
ಆಧಾರ್ ಕಾರ್ಡ್, ಪಡಿತರ ಚೀಟಿ, ಚುನಾವಣಾ ಆಯೋಗದ ಗುರುತಿನ ಚೀಟಿ, ಬ್ಯಾಂಕ್ ಪುಸ್ತಕ ರೀಸೆಂಟ್ ಒನ್, ಜಾತಿ ಆದಾಯ ಪ್ರಮಾಣ ಪತ್ರ, ಆದಾಯ ದೃಢೀಕರಣ ಪತ್ರ, ಚಾಪಾ ಕಾಗದ, ಬಾಂಡ್ ಪೇಪರ್ ರೀಸೆಂಟ್ ಒನ್ ಬೇಕು.
ಆಯ್ತು,
ಎಲ್ಲ ಕೊಟ್ಟ ಮೇಲೆ ಗ್ರಾಂಟ್ ಆರ್ಡರ್ಸ್ ಮಾಡಿರೋದು.
ಈಗ 8 ವರ್ಷ ಹಿಂದೆ ಕೊಟ್ಟಿರೋದು, ಈಗ ಮತ್ತೆ ಒಂದ್ ಕೊಡಕ್ಕೇನು?
ಕೊಡ್ತೀವಿ.
ಪಾಸ್ಪೋರ್ಟ್ ಸೈಜ್ ಫೋಟೋ ಅವಾಗ ಇವಾಗ ತುಂಬಾ ವ್ಯತ್ಯಾಸ ಇರುತ್ತೆ.
ಕೊಡ್ತೀವಿ.
ಮತ್ತೆ
ಇನ್ ಎಲ್ಲರಿಗೂ
ನೀವು ಪಾಸ್ಪೋರ್ಟ್ ಸೈಜ್ ಫೋಟೋ ಹೆಂಗಿದ್ರು ಚೆನ್ನಾಗಿ ಬರಲ್ಲ.
ಅಲ್ಲಿ ಇದು ಡಿಲೇ ಮಾಡ್ಲಿಕ್ಕೋಸ್ಕರ ನಮ್ಮ 53 ಜನಕ್ಕೆ ಮಾತ್ರ ತೆಗೆದಿರೋದು. ಇದು
ಏನ್ ಡಿಲೇ ಇಲ್ಲ.
ಇವ್ರು 53 ಜನ ಬಿಟ್ಟು ಬೇರೆ ಎಲ್ಲರೂ
ತಗೊಂಡಿದ್ದಾರೆ.
ಇವ್ರಿಗೆ ಮಾತ್ರ ನಾವು
ತಗೊಂಡಿದ್ದಾರೆ, ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ, ನಮ್ಮವ್ರು ಕೊಟ್ಟಿಲ್ಲ.
ಕ್ಲಿಯರ್ ಫಾಲ್ಸ್ ಅಲಿಗೇಷನ್ ಆನ್ ದ board melons.
I'll file an affidavit if that is the case.
ನಿಮ್ಗೆ ದುಡ್ಡು ಬೇಕಾ ಅಫಿಡವಿಟ್ ಬೇಕಾ?
ದುಡ್ಡು ಬೇಕು.
Moreover, ಅವರಿಗೆ ಇಂಟಿಮೇಷನ್ ಇರಲಿಲ್ಲ. Day before yesterday, I have told them petitioner has received the amount ಅಂತ. ಅವ್ರಿಗೆ ಫೀಸ್ ಬಂದಿಲ್ಲದೆ ಇರಬಹುದು ಅಂತ.
ನಮಗೆ ದುಡ್ಡು ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಫೀಸೇ ಬರಲ್ಲ. May make a request, my lords, what I have taken.
The allegation of the petitioner is that 53 petitioners in one of the petition have not been paid. All the others have been paid. The learned counsel, your name is Anita SM. Learned counsel,
Yes, Patil.
Learned counsel Anita Patil, appearing for the respondent board, submits that all 137 people have all been granted the benefit in terms of the interim order. The 53 persons whom the counsel Jeevan Kumar is alleging have not appeared with all the documents before the board. If they appear on any day with the documents that are now indicated, amount would be released without broking any further delay. The submission of Anita Patil is placed on record. List the matter on
one more request, my lords. This is in respect to 93 grant orders, my lords. There are other persons.
Adamale we'll first 93 grant orders mugisbona.
93
grant. We'll take it on merit.
Adal yak 1 month.
Where is Vaibhav? Is not there?
Vaibhav is not there.
All right.
He's traveling.
Or the all petitioners who we have already paid melon.
Right, sorry. List the matter on we'll take it on week commencing after the 16th. List the matter on 19th.
One request, my lords, what the documents which I have submitted, 76, my lords, are the next page, next documents. Page number 76. Kottidi noda.
Yen ಬೇಕು? Yen ಬೇಕು? 76 ಏನು?
ಅದನ್ನೇ ನೋಡಿ. Page number 76, my lords.
What is 76?
Their own endorsement showing that 115 grant orders.
115?
Grant orders. What they say is 93 grant orders.
I think 93 ತಗೊಳ್ಳಿ, ಆಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ.
They are also in.
ಬರೋರ್ಗೆಲ್ಲ ಫಸ್ಟ್ ತಗೊಳ್ಳಿ. I am not letting off this petition unless I direct every person to get it.
Yes. 8 petition only falls out of 93 grant orders, my lords.
Rest
we have already.
Rest we will see what is to be done. Now you finish granting money as per the interim orders to all these people.
Please.
Yes, I'll take it on 19th.
One more batch of writ petitions who come out of 93 months, that I'll give the number.
Number kudi. Yes.
That could also be.
Number kudi ಅವರು ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ ಮುಂಚೆನೆ. ಇನ್ಯಾವುದಾರು ಹಾಕಿದ್ರೆ ಹೊಸದಾಗಿ ಇವು ಸರ್ವ್ ನಾನು.
There are other 300 petitioners who they say that
whoever it is you serve copies we will consider.
There are n number of petitions, but there is no sufficient fund has been released.
Government ಇಂದ ಎಷ್ಟು ಕೋಟಿ ಬಂದಿದೆ ಮೇಡಮ್ ಬೋರ್ಡ್ ಗೆ?
84.
84 crores.
Please, my last. Adralli, earlier occasion, senior counsel has made a mention. We have to run the board in the same amount. It is not exclusively for the.
ಇದು ಕೋಲಾರ ಮಾತ್ರ 84 ಕೋಟಿ ಬಂದಿದೆ.
No, my lords, that is the misleading of the court.
ಇದು
Kolar
ಇವಾಗ-
ಮಾತ್ರ ಅಲ್ಲ, total budgetary allocation was 84.
For the entire state.
Entire state.
ಇವಾಗ additional documents ಹಾಕಿದ್ದೀನಿ. ಅದ್ರಲ್ಲಿ I'll substantiate how much money has come from central government, NKFDC, everything I'll substantiate.
I have
Audit
already.
direct ಮಾಡ್ಬಿಡ್ತೀನಿ ಅಷ್ಟೇ.
Please,
NKFDC.
Complete
it is
financial
loan under
audit direct
NKFDC.
ಮಾಡ್ತೀನಿ.
please, my
Of the board. ಅದಕ್ಕೆ ಯಾರು ಯಾವ ಕಾರ್ ತಗೊಂಡಿದ್ದಾರೆ ಎಲ್ಲ ಬರುತ್ತವ.
please, my lords.
ಆಫೀಸ್ ಶಿಫ್ಟಿಂಗ್ ಗೆ 1 ಕೋಟಿ ಖರ್ಚಾಗಿದೆ. ಅದನ್ನು
ಯಾವ್ದಕ್ಕೆ?
ಆಫೀಸ್ ಶಿಫ್ಟಿಂಗ್ ಗೆ
ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ?
ಒಂದು ಅಂಬೇಡ್ಕರ್ ಕಾರ್ಪೊರೇಷನ್ ಇಂದ ಕನಿಂಗಮ್ ರೋಡ್ ಗೆ.
That is splitting up of the Nigama, my lords.
Oh.
First ಎಲ್ಲ ಒಂದೇ ಕರ್ನಾಟಕ ಅಂಬೇಡ್ಕರ್
ಸರಿ.
ಡೆವಲಪ್ಮೆಂಟ್ ಕಾರ್ಪೊರೇಷನ್ ಅಂಡರ್ ಅಲ್ಲಿ ಬರ್ತಿತ್ತು. Then they have splitted each ನಿಗಮ. ಸಫಾಯಿ ಕರ್ಮಚಾರಿ ನಿಗಮ, ವಾಲ್ಮೀಕಿ ನಿಗಮ. ಅವಾಗ ಸ್ಪ್ಲಿಟ್ ಆದಾಗ
1 ಕೋಟಿ ಹೋಗಿದೆ.
ಅದು ಅವರು earlier they have mentioned that before MD was
Valmiki before MD.
I don't want to make any
I'll
discussion on that.
substantiate.
Valmiki before MD.
I'll
He is in the jail.
It's all
as of
my lords,
now.
it is
That is
Of
why he
all
is in
those-
jail.
It is
That
not
why he
given-
is in jail. Yes.
He is not being given by them. It is all NKFDC which is coming from the central government.
Client.
One more.
ಇಲ್ಲ, it is from the central government, NKFDC.
One more.
ನಮ್ ಕ್ಲೈಂಟ್ GM ಅಷ್ಟೇ, MD ಅಲ್ಲ.
ಅವ್ರಷ್ಟೇ ತಗೊಂಡಿರೋದು.
Melods, 1
ಎಲ್ಲ
crore.
ಅಲಿಗೇಷನ್. ಬಟ್ ನಮ್ ಕ್ಲೈಂಟ್ ಮಾಡಿರೋ 93 ಸ್ಯಾಂಕ್ಷನ್ ಆರ್ಡರ್ಸ್ ಗವರ್ನಮೆಂಟ್ ಎಲ್ಲ ಅಪ್ರೂವ್ ಆಗಿದೆ.
ಆಯ್ತಾಯ್ತು.
Melods,
ಮಿಕ್ಕಿದ
1
ಯಾವ್ದು ಆಗಿಲ್ಲ.
crore is for establishing the
I
new
will see.
department.
Now you pay this, come on 19th.
Please, Melods.
Don't dodge them, complete the payment.
If they provide with the
ಅದೇನ್
documents,
5
we are
document
ready,
ಕೊಡೋದು
Melods.
ಕಷ್ಟ ಅಲ್ಲ.
From tomorrow itself, we will
Let's-
release them.
It is there with them.
ನಿಮ್ಮ ಭಾವಚಿತ್ರ ಕೊಡಿ ಸರ್.
ಕೊಡ್ತೀವಿ.
Yes.
ಕಲರ್ಫುಲ್
ಭಾವಚಿತ್ರ ಕೊಟ್ರೇನೆ ಪ್ರಭಾವ ಆಗುತ್ತೆ. ಕೊಡಿ.
ಕಲರ್ಫುಲ್ ಭಾವಚಿತ್ರ. ಅವ್ರು ಬೇರೆ ಕಲರ್
ಯಾವ ತರ
ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಬೇಕಾದ್ರೆ ಕೊಡಿ.
ಅವ್ರು ಬೇರೆ ಕಲರ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಮೋನೋಕ್ರೋಮೋ ಕಲರ್ ಏನ್ ಕೇಳ್ತಾರೆ ಕೊಡಿ. ಆಯ್ತಾಯ್ತು ಸರಿ. ಎಸ್ ಆಚೆ.
Please. Much.
Petition this matter, matters pertaining to a clerk association matters.
ಅಡ್ವೊಕೇಟ್ಸ್ ಕ್ಲರ್ಕ್ ಅಸೋಸಿಯೇಷನ್. ಏನಾಯ್ತು ಇದು?
ನಾವು
ವೈಸ್ ಮೀಟಿಂಗ್ ಹೇಳಲಾಗಿದೆ.
ಹ್ಮ್.
ಇವಾಗ ಬೈಲಾಸ್ ಅವರು ನಾವು ಡ್ರಾಫ್ಟ್ ಇಬ್ರು ಕೂತ್ಕೊಂಡ್ಬಿಟ್ಟು ಮಾಡಿದೀವಿ. ದಟ್ ಹಸ್ ಬಿ ಅಪ್ರೂವ್ಡ್ ಬೈ ದ ರಿಜಿಸ್ಟರ್ ಆಫ್ ಸೊಸೈಟೀಸ್. ಅದಾದ್ಮೇಲೆ ಫರ್ದರ್
ಯಾವ when do you approve it?
ಡೇ ಬಿಫೋರ್ ಯೆಸ್ಟರ್ಡೇ ಮೀಟಿಂಗ್ ಆಗಿದೆ.
ಆಯ್ತು, will grant them 2 weeks.
Please.
Learned counsel.
ಅಲ್ಲ ಬೈಲಾಸ್
Amended
ಡೇ
bylaws.
ಬಿಫೋರ್
So
ಯೆಸ್ಟರ್ಡೇ
amended bylaws approve ಮಾಡಕ್ಕೆ to bought them their benefits. ನೀವು ಅದನ್ನ ಇನ್ನು 2 ವರ್ಷ ಕೂತ್ಕೋಬೇಡಿ. Yes, list the matter on 27th. 27th. There I will direct approval to be done immediately. Yes, 27th.
Much obliged.
Next.
Petitioner in this case, Lordship were pleased to quash the proceedings the earlier date, Your Lordship. Then memo for being spoken to was filed by the de facto complainant.
ಯಾವ್ದು ಸರಿ? Which one?
112. On 5/11/2024, the proceedings were quashed, Your Lordship.
ಆಮೇಲೆ recalling ಹಾಕಿದ್ರಾ?
Yes, they
ಬಂದೇ
filed
ಇಲ್ಲ
a
ಅವರು?
memo for being spoken to, saying that de facto complainant was not heard.
Now he is served.
He is served.
498
Also, wakalat has been filed.
ವಕಾಲತ್ is filed.
Yes, Your Lordship.
ಎಲ್ಲಿದೆ? ಟಿ ಕುಮಾರ್ ಸರ್ವ್ಡ್ ಅಂತ ಇದೆ. ಅದೇನಾ ಇದೆ ಯಾವ್ದು ಮೇಡಮ್? Yes, anyway, 27th ಹಾಕಿ interim order subsisting will continue to the next date of hearing.
Much obliged.
113.
113, I appear for the petitioner in this.
For the respondent.
It's an interim order, my lordship may be.
4th July, interim order subsisting will continue to the next date of hearing.
Let's immediate
Objection
next week.
ಹಾಕಿದ್ದೀರಾ?
Immediate next week, my lordship.
ಯಾಕೆ urgency ಇದೆ?
Interim order ಇದೆ.
7A or 13?
7.
20. Based on 27th, yes.
Please.
ಭಾಗವತ್ ಸರ್ ಇದು ಅಷ್ಟೇ 27th.
This is a case where, my lord,
Where?
this was 7A. She is the commissioner at that time, Telekere. She was the commissioner, municipal commissioner. She issued notice on the complainant that you are on and often coming to the office to make kata. Unless you pay the taxes, we cannot do anything. Don't pressurize. You are insisting to take bribe. illegally.
Professional tax, personal tax.
Hello, annexure C is the not one.
What tax?
The property tax, Lord.
Property.
Property tax. She purchased a property, his wife.
Hmm.
Husband, my lord, goes to the office on and often, my lord, says, you please pay kata. Kindly trap, oh, my lord, when the bill collector went and collected the taxes, they say it is the collected bill. Kindly see annexure B, not kindly see for a moment, annexure B and C.
Turned pink.
Nagasena is, my lord, cover the case.
Turned pink.
ನಾನಿಲ್ಲ, ನಾನು ಆಫೀಸಲ್ಲಿ ಇದ್ದೇನೆ.
ಎಲ್ಲಿದ್ದೀರಾ?
ಬಿಲ್ ಕಲೆಕ್ಟರ್ ಹೋಗಿದ್ದಾರೆ. ಇಲ್ಲ, ನೋ ಬಿಲ್ ಕಲೆಕ್ಟರ್ ಹೋಗಿದ್ದಾರೆ. ಕರೆಕ್ಟ್ 3 ಲಕ್ಷ ಇದೆ ಟ್ಯಾಕ್ಸ್ ಅಂತ ಕರೆಕ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೋಗಿದ್ದಾರೆ. ಖಂಡಿತ ಇವನ್ ನಾಟ್ annexure C ಫಾರ್ ಎ ಮೂಮೆಂಟ್ ಪೇಜ್ 47.
ನಾಲ್ ಸೆಲೆಂಟ್ ಟೆಸ್ಟ್ ಏನಾಯ್ತು?
ಅದಿಲ್ಲ, ನಮ್ಮೇಲೆ ಮಾಡಿಲ್ಲ. ನಾನು ತೋರಿಸ್ತೇನೆ ನೋಡಿ. annexure C ಇವನ್ ಮಾಡಿದ್ರು 47 ತಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್
ಮಾಡಿದ್ರು ವಾಟ್ ಅಲ್ಲ ಮಾಡಿದಾರ ಕೇಳಿದೆ.
ಖಂಡಿತ ಪಂಚನಾಮ which is produced. Kindly see, Lord, how what he says. The bill collector says, Lord, I have collected this amount for the purpose of payment of towards the tax. ಅಂತ ಹೇಳ್ತಾರೆ. annexure C page 47 ಅಲ್ಲಿ ತಾವು ಒಮ್ಮೆ ನೋಡಿ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡೋದನ್ನ ನಾನು ಪೇಜ್ 47. ಯಾರಿಗೆ? ಸುವರ್ಣಮ್ಮ ಕೊಟ್ಟಿದೆ, ನಾಗಾಚಾರಿ ಕಂಪ್ಲೇಂಟ್ ಅವ್ರ ಹಸ್ಬೆಂಡ್. ಖಂಡಿಸಿ ಲಾರ್ಡ್, ಲಾಸ್ಟ್ ತಮ್ಮ ಹೆಸರಿನ ಆಸ್ತಿ ವರ್ಗಾವಣೆ ವಿಚಾರ ನಿಮ್ಮ ಯಜಮಾನರು ವರ್ಗಾವಣೆಯ ಕಚೇರಿಗೆ ಬಂದು ಅರ್ಜಿ ಸಲ್ಲಿಸ ಲಂಚದ ಆಮಿಷ ಹೊರಡುತ್ತಿರುವುದು ಕಂಡು ಬಂದಿದ್ದು ಯಾವುದೇ ಆಮಿಷ ಒಳಗಾಗದೆ ನಿಖರವಾಗಿ ತೆರಿಗೆ ಪಾಸ್ತಾಗ್ತದೆ.
Money recovered from the petitioner?
ಇಲ್ಲ,
not from the but names are there.
ನೇಮ್ ಇದೆ ಸ್ವಾಮಿ, ನೇಮ್.
Audio recordings.
Audio recording is there, demand is there, everything is there.
ಅಲ್ಲ, ಅದೆಲ್ಲ ತಾವು ನಾಗಶೇನ್.
Who has demanded?
But even the petitioner has demanded.
Who has accepted?
Not the other accused, not it is
during,
there in the
during the trap. Who was caught?
But the accused number 1 and 2.
How many times trap?
Once, not only.
Once, not a failed trap. So accused number 1 is not trapped at all.
Not while accepting the bribe amount, but demand is there, not and audio recording is there.
ಅವು ಪೇಜ್ 90 ನೋಡಿ, ಅವ್ರಿಗೆ ಹೇಳಿಕೆ ಕೊಡ್ತಾರೆ.
I'll demonstrate. Let learn senior complete, not I'll demonstrate.
ನಾಗಶೇನ ಜಡ್ಜ್ಮೆಂಟ್ ತಮ್ಮದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕನ್ಫರ್ಮ್ ಆಗಿದೆ. ಅದರಲ್ಲೂ ಆಡಿಯೋ ರೆಕಾರ್ಡ್ ಇತ್ತು. ಅಲ್ಲಿ 1,80,000, 2,80,000
ಡ್ರೈವರ್ ಇಸ್ಕೊಂಡಿದೆ A2.
ಹೌದು. ಇಲ್ಲಿ ಬಿಲ್ ಕಲೆಕ್ಟರ್ ಹೇಳ್ತಾನೆ ಟ್ಯಾಕ್ಸಿಗೋಸ್ಕರ ತಗೊಂಡಿದ್ದೇನೆ ಅಂತ. ಮೇಡಮ್ ನೆವರ್ ಸೆಡ್ ಯು ಕಲೆಕ್ಟ್ ದಿ ಬ್ರೈಬ್ ಅಮೌಂಟ್. ಖಂಡಿತ ಪೇಜ್ 90 ಹಿ ಗಿವ್ಸ್ ಅ ಸ್ಟೇಟ್ಮೆಂಟ್. ನಾನು ಓದ್ತೇನೆ ಅವನು ಸ್ಟೇಟ್ಮೆಂಟ್ ಅನ್ನ. ಯಾರು? ನಿಶಾಂತ್ ಕಾಂತರಾಜ್ ಅಂತ ಬಿಲ್ ಕಲೆಕ್ಟರ್. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಮೂಲಕ ತಿಳಿಸುವುದೆಂದರೆ 3/8/23 ವೈ ನಾಗರಾಚಾರ್ಯ ಮನೆ ಖಾತೆ ಮಾಡುವಂತೆ ಕಚೇರಿ ಸಲ್ಲಿಸಿದ್ದು ಸದರಿ ಅರ್ಜಿದಾರರು ಕಟ್ಟಡ ಸೋಲು ಕಂದಾಯ ಮಾನ್ಯ
20th. Yes.
20th. Great.
Entry ಮಾಡಬೇಕು.
20?
Entry ಮಾಡಿ is there, not?
That will continue.
ಇಷ್ಟೇ ಇರುವುದು. ನಾಗಶೇನ ಕವರ್ಸ್ ಅದರ್ವೈಸ್ not.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕನ್ಫರ್ಮ್ ಆಯ್ತಾ ಅದು?
ಹೌದು, ಅದನ್ನು ಹಾಕಿದ್ದೇನೆ.
SLP ವಜಾ ಆಗಿದೆಯಾ ಅಥವಾ ಡೀಟೇಲ್ ಆರ್ಡರ್?
In limine.
In limine.
Leave is not granted. Limine is in limine.
115.
Represent the respondents. Lord, in this matter, my lord, the petitioners has taken no objection from me, my lord.
I will not. You cannot play with the court orders. List on Monday.
Monday. My lord, may I make one submission?
List on Monday.
May I make one submission? One submission. The interim order, my lord, may be vacated.
We'll vacate the interim.
Earlier, my lord, this court has passed that dictated the order.
Adu kodi madam.
Lord, my lord, your lordship may kindly next week.
No.
They have taken file, my lord.
Don't worry, sir.
There are 2 writ petitions. In both the writ petition, interim order is substituted. I'll argue in the next week, my lord.
They have taken the file. Why are you worried?
Please, I may be permitted to retire.
Permitted to what?
Retire from the case. I have retire from the case. I have filed.
We'll see. Yes. What was the observation last occasion?
The last occasion, my lord, since the interim order has been obtained by misrepresentation, the interim order got vacated. Since he was not present on that particular day, again the interim order got.
ಇನ್ನೊಂದು ಕಂಪೈಲ್ ಪೆಟಿಷನ್ ಕೊಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಅದಕ್ಕೆ ಸಾಕು.
On 11/3.
We have
ಇಲ್ಲಿ
not,
ಕೊಡಿ.
we have not made any misrepresentation of facts, my lord, before your lordship in this
Observation
matter.
made by the court.
14/2/24.
No, subsequently on 11/3, my lord.
ಯಾವ 11/3 ಸರ್?
11/3/25, my lord. In fact, my lord, this court
ಏನು
has
ಬರ್ದಿಲ್ಲ ಇಲ್ಲಿ.
ಅಲ್ಲ ಅದೇ orally dictated. Subsequently, since he was not present, the interim order got extended.
Learned counsel appearing for the petitioner submits that the file has been taken away by the petitioner. The counsel for the respondent submits that the interim order has been obtained by suppressing several material facts. In that light, list the matter on Monday. I will vacate it on Monday.
Tuesday, maybe.
Monday.
My lord, Monday I am not in station.
Monday.
My lord,
Monday, sir.
my air tickets.
Monday. Air ticket.
Please, Tuesday.
Monday.
My lord,
Yes.
I am not in
You
station.
are not there. File ತಗೊಂಡು ಹೋಗಿದೆಯಲ್ಲ. Why are you worried?
Then, my lord, your lordship may kindly permit
Monday,
me to
Monday. We'll do that on Monday.
Please.
Next.
116.
This matter is about the non-grant of FCRA registration and challenge to that.
Your lordship, can we have it in the next week, your lordship? Due to some personal inconvenience, the senior is unable to appear today, your lordships.
FCRA registration.
FCRA registration.
Is an interim order?
Yes,
There is
your
an
lordship.
interim order.
And we have filed IA-1 for correction of the interim order, your lordship.
12th, yes. List on
Please, your
12th.
Much.
At the request of the council appearing for the petition. Next.
117.
Lord, in this case, Lord, I am for the petitioners. Connected matters have been allowed, my lord.
Allowed?
Lord, this is a
Oh, ಇದು
slum.
ಮೊನ್ನೆ.
Slum.
Monday.
Next, any date.
Next Friday.
Because I want to read that decision,
Next
Lord.
Friday.
Please. Because it is not uploaded, my lord.
I know. It's not, yes.
Please.
20th.
118.
Appear for the petition, my lords.
Lordship, permit me to appear for the impleading
Wherein
applicants council.
we've sought some
We have filed an
relief.
application to implead.
My lords, the petition, my lords may kindly just see the prayer.
What is this, madam?
The prayer, my lords,
My lord,
the
before my
petitioners.
learned friend, my lord, commences.
No, 1 minute.
I have filed an application to.
No, I am the petitioner.
filed
Can
an
the
application to
petitioner
implead.
not submit before some?
Wait, sir. Yes.
Petitioners are all patients of cystic fibrosis. Cystic fibrosis is a rare disease which has been included in the National Rare Disease Policy.
Correct.
There are about 40,000 patients with cystic fibrosis in the country. And the situation is such that annually the medication required, cystic fibrosis is a disease where mucus collects in the lung pipes. And the annual expense for treatment is about 2 crores. And the drugs are not manufactured in India. The drugs are patented drugs and there are no generic drugs manufactured in India. So now the prayer we have sought, there are many companies. There is a US based company, there's an Argentina based company. There are many companies which manufacture drugs, but all of these drugs have to be imported and the costs are prohibitive. Now what we have sought for, my lords, in my prayer is either the government provide a scheme for treatment of cystic fibrosis patients, or government under section 92 of the Patents Act or section 100 of the Patents Act provide for compulsory licensing, which it has the powers to do. So we are saying, let the government say whether it will do that for cystic fibrosis, and also to facilitate some diagnosis and treatment locally for patients. And in fact, the interim prayer we've asked for is under the National Policy for Rare Disease. What is the action taken by the government?
Who is the impleading applicant?
Now, impleading applicant is a company called Vertex Pharmaceuticals, which is a US-based company, is one of the manufacturers in the world.
Why do they want to get?
Exactly. There is no relief against them. I will file my detailed objections to their IA. They cannot come and scuttle somebody's petition where there is no relief against them. Whether the government, their only claim is, if the government passes compulsory licensing orders, then our patent will be affected. My lords, that is not something that this petition has to decide, because the petition is not for the rights of the pharmaceutical companies. And we are not opening a floodgate. There are many other pharmaceutical companies the world over who make cystic fibrosis drugs. We are asking, the government has an obligation to its citizens who are patients of rare diseases. Before even there is a requirement of hearing the impleading applicant, I will file my objections. I will file, but in the meanwhile, at least, in fact, it's been
No
a year.
interim orders, wait.
Union
yes.
has also
No,
not filed
interim
its
orders. I'm
objection.
not seeking, I'm not seeking any interim orders of any kind. I'm only seeking, the only interim relief I've asked is let them give an action taken report, the government, on what they have done under the National Rare Disease Policy for cystic fibrosis.
That will ask.
To that extent, in fact, it's been a year. Notice was issued once or twice. In fact, my lord said to pass in 2 weeks. At least to that effect, that under the National Rare Disease Policy,
Yes.
to that effect.
We want
let them
to file our objections to the maintainability of the petition as well as
Maintainability,
on the merits, because this is in the nature of a PIL. The reliefs that they're seeking are in the nature of a PIL. So we would like to file objections on the maintainability as well as the merits of.
Who is my friend?
You leave the
I appear for the union.
No, the Union. Union
Union
can
of
file
India,
its
madam.
objections. Let
Yes.
them file their objections.
No, let him file.
Yes.
No, maintainability apart, but look at the problem, whether it is before this court or before the division bench, that's a different thing.
I understand that, but
if it is framing of a policy for the purpose of treating rare diseases.
That certainly the union cannot object to such a thing and will support it if and when. But then again, it would be in the nature of a PIL, and that is something that
What file your objections, you file. No
we
problem.
will.
Yes.
Even, and you file to that impleading application.
I will file. Since this is included within the National Rare Disease Policy, in fact, at page 128.
No, what have you done? Action taken report
Let
also.
them file that action taken report. That's all I'm
You
asking.
append that to the statement of objections and file
objections. We will.
Let there be
I'll take it
some
on-
timeline.
I'll take it on 27th.
Grateful.
Yes, list them, heard the learned senior counsel Jaina Kothari appearing for the petitioner and the counsel, I forget your names.
Anu Judupa.
So and so appearing for the respondent Union of India. The learned counsel, a learned senior counsel representing the petitioner would submit that the action taken report on the policy for treatment of rare diseases by the Union of India should be placed on record. The learned counsel representing the Union of India would submit that the objections would be filed as the threshold maintainability of objections would be filed with regard to the threshold bar of maintainability of the petition as the relief that is sought is in the nature of a PIL, and would seek 2 weeks' time to file statement of objections.
And the action taken.
Objection so and so.
There is a national policy for rare diseases, so that may also be.
No, we are asking what is the action taken under that rare disease policy? Policy is
They
there.
will place it, yes.
Let them
So
file.
the learned senior counsel submits that the impleading applicant is not a necessary party to these proceedings, and therefore she would file statement of objections to IA 1 of 2025. Objections be filed by the next list the matter on 27th.
27, great.
May I make one request, Milord? I'm appealing for the impleading applicant's counsel, Milord. If I can request the petitioner's counsel to give us a copy of the writ petition. We came to know about this thing, Milord, from the allegations made in an article.
You should be having it.
How have they filed an impleading IA themselves
If they will not-
without even
we
knowing
can
what
obtain.
is?
No, that's, we have said in our impleading application, Milord, it's on.
You can
They can
give
just give us a
e-copy.
copy, Milord. It'll.
We'll do that.
Yes.
Great.
Great, great.
19.
Yes. 27th, yes, interim order subsisting will continue. ಇದು ಅಷ್ಟೇ.
20. My lords, I appear for the petitioner.
ಇದು ನನ್ನ ಹತ್ರನೇ ಬರುತ್ತಲ್ಲ. List the matter and preliminary hearing on Wednesday.
Grateful, my lord. Thank you.
GMCPC is mine only now, yes.
Yes.
Special order. ಬೇಡ ಬರ್ಲಿ.
121.
That's I appear for the
All
petitioner.
surrogacy?
Yes, please, my lord.
There are
My
11
lords.
matters listed to.
Will allow everything.
Oh, you
Lords.
better.
Kindly pass over the matter, my
One
lord.
request.
Senior is on his legs before another court, my lord,
My lords,
on a
one
parted
request.
matter.
ಗೌತಮ್ಮ.
Please, my lords.
There are 19 surrogacy matters pending.
ಇದು ಎಷ್ಟಿದೆ ಇವತ್ತು?
11 ಇದೆ.
ಇನ್ನೂ
may I
19
please
ಇದೆಯಾ?
pass over the list so that
So 30 totally.
plus 8, 11 plus 8, 19 matters.
11 plus 8.
So I'll pass over the list, my lords. If it can, a date
ಕೊಡಿ
can be
ಕೊಡಿ.
fixed for.
ಒಂದು 19 matters dispose ಮಾಡ್ಬೇಡ, covered ಅದು.
And the matter is already pending before the Supreme. The very same issue of a single unmarried woman trying for surrogacy is pending before the Supreme.
Correct. I have, notwithstanding that, I have allowed 2-3 petitions. What happened to the writ appeal? What happened? Writ appeal.
Pending ಇದೆ. It's not moved yet.
Yes.
They're seeking a stay.
Kindly pass over.
Passed over.
Pass over, my lords.
ಇವಾಗ ಯಾವ ಪಾಸ್ ಓವರ್ 4:45 ಎಸ್
Date may kindly be fixed.
ಆಲ್ ರೈಟ್ ದಿ ಡೇಟ್ ಎಲ್ಲ ಅದನ್ನ ಲಿಸ್ಟ್ ಆಲ್ ಆಫ್ ದೆಮ್ ಟುಗೆದರ್. ವೆನ್ ಡು ಯು ವಾಂಟ್? 20th 19th? ಎಸ್, ಲಿಸ್ಟ್ ಆನ್ 19th. ಎಲ್ಲ ಕವರ್ಡ್ ಅಲ್ವಾ ಮೇಡಮ್ ಇದು?
Different this issues that
ಅಲ್ಲ, ಯಾವ್ದು ಇದರಲ್ಲಿ ಏಜ್ ರಿಲ್ಯಾಕ್ಸೇಷನ್ ಕೇಳಿರೋದು ಯಾವ್ದು?
ಏಜ್ ರಿಲ್ಯಾಕ್ಸೇಷನ್ ಕೆಲವೊಂದಿದೆ. ಇನ್ನೊಂದು ಕೆಲವೊಂದು ದಿ second child they are seeking through surrogacy, which is not permissible at all.
ನೋ ಚಿಲ್ಡ್ರನ್ ಇದ್ರೆ ಮಾತ್ರ.
ಹೌದು. And some are of different.
Majority of them are of single unmarried women who are trying to get surrogate.
All right. Yes. 19th.
And another is very interesting because the husband is not consenting for surrogacy and the wife wants to force it.
ಆ ಥರದ್ದು ಇದೆ ಇಲ್ಲಿ.
ಅದರಲ್ಲೂ ಸೇರಿಸ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಆಯ್ತು, ಸರಿ. All interesting questions in one batch. We'll decide. Yes.
122.
This is the smart meter matter, Your Lordship. The Lordship had directed the state to produce.
Okay, why is the Advocate General waiting?
We are filing your objection. If I may request, my lord, can we have it on Tuesday or Wednesday?
Smart meter.
I'm all right with Tuesday, Wednesday.
Smart meter.
Huh?
They don't want smart meters.
The smart meter was developed in a very smart manner.
So meter is over smart.
Where, yes, where they could hoodwink people. Your Lordship, Your Lordship.
Where is which same?
We're all sailing together.
Oh.
Your Lordship, if Your Lordships recollect, the government was directed to produce the entire records.
They will produce.
Entire any government record da? Case is
pertaining to the case, sir. Yes.
My lord, this is comes under.
Comes under what?
The contesting respond BESCOM. My lord, they have issued the thing, so probably government records may not.
Sir, after the government's decision, BESCOM has issued, I guess so.
No, my lord, it's the KERC's decision.
All right. Anyway, whatever records
Produce that,
are there,
so therefore.
produce it. Government will have all the records.
We'll produce it, man. There's no.
Yes.
The
Objection
result-
copy ಕೊಟ್ಟಿದ್ದೀರಾ?
Just now.
Just now we are
Just now.
Just now. Yes. Smart objections.
Smart objections,
Yes.
please.
Any date can
Now,
we?
Thursday,
Please, Your Lordship.
19th. Sorry, not 19th. This 12th.
Please, 12th.
4 o'clock, Your Lordship.
Yeah, after 3:30. After I
Please.
finish my regular day's work.
Please.
Yes.
Because now very smartly, as a result of all of this, they're proceeding with the other ESCOMs around the state to engage with the very
So
same.
you brought out a fundamental point where the direction of the KERC itself is in error.
Correct.
So if the direction itself is in error,
Yes. And the guidelines are contrary to the act by itself.
then the very it's right from the inception.
Yes.
Who are they? What do they want? We are saying that you need not take smart meters. Insofar these petitioners, they have lost the tender. Person who has lost the tender is arguing everything but this
Who
case.
has lost the tender here?
Tender,
They are
we are
not
not
before the
part of
court.
the tender.
We are saying that these petitioners need not put smart meters because there's an old meter. They're saying no, we
No, they
we
have
want
not
to put
said
smart
that.
meters.
I'm before this
Both
court
the
because they
petition-
say, no.
there's
Both
an
the petitions, my main, what I've challenged itself, they say, no, you have to put in a smart
So in
meter.
the first
Otherwise, I would.
matter, Problings sir appeared.
He need
in
not put
one of the
because it's an
consumer.
existing meter, need not put.
No, that's all right. Yeah, but a fundamental error was pointed out by Lakshmi Madam.
Well, again,
On the next day.
what is interesting in her case is she's a petition client, a tenant who's got already a meter.
Smart meter.
No, regular meter, and this smart meter doesn't apply at all. But
Let
wants
them
to
say
challenge.
it. They let them say it.
I
Their
said in my
response is on the basis of which I'm before this court
I
where it
filed my
says,
ob-
no, you have to get yourself a smart
No, I
meter.
filed my objection saying that only communication what they're seeking to challenge is what is the price difference between a smart meter and a static meter. We have told them, we didn't say that you put this connection. And one more thing, nobody's residing in that house. I produced the photograph. And the meter is not running for. It's very interesting. The people who have lost the tender have set up two wrong people. They should, when they're filing a petition, at least they should.
Correct people at least should come up.
Those lordships are not.
And not a newly constructed house. It's only for a fresh meter and a temporary meter as per KERC regulations.
The extent to which the state has gone through to just go all the way to take photographs of his house, if they could just, amazing. It's as good as how devious the way they have drafted it.
It's our own employees who are briefing them. That is why we have to do.
Oh, that's the thing, is it?
That's the thing, Manoj. So we have to be even more careful because the system is that.
So they are shooting from.
I mean, Manoj, there are a lot of things, Manoj. If they can do what they want. State is not entitled to protect its own interest and do it. They can do lie, false affidavit, do whatever they want. But when state points out it's devious.
But
Very
Supreme Court says only about your affidavit.
Correct, because nobody points out nobody points out their affidavit. That's the again a problem.
I have only 2 minutes. But of course, lordships are not exercising this petition in the form of a public interest litigation, though. But it's the fact of the matter is not large number of persons who cannot approach your lordships are affected, and this is a far-reaching effect. Every person who can, I'm just only bringing it to ultimately lordships may have to decide this question. As to the switch over from a regular meter to smart meter, the decision of the state government is arbitrary and it is transparent in nature. These are the two questions. And post electricity reforms, it is the KERC which has to control the entire structures. And the KERC says that insofar as these connections are concerned, it is not required. Notwithstanding that contract is called, it is awarded to someone else, etc. Therefore,
that's all right. That will. How are you challenging all
what
this?
is very interesting is
no. Ultimately, we are bringing to lordships notice the method and manner it has gone about. Large number of states ultimately.
What happened to the PIL?
PIL, Manoj, is adjourned, Manoj. Court wanted to dismiss it. Then PIL. Then they sought time. They took an adjournment.
Court wanted to dismiss it.
Please, Manoj.
I'm surprised. Then why did the court not dismiss? I asked myself.
Because you
but
sought
anyway,
time.
it was. No, I didn't seek time.
No,
I didn't seek time.
Here
It was connected with the other matters. That's all. And your lordship, very
So
smart.
you can't say that everything is live streamed, sir, now.
Absolutely,
Correct. Absolutely. And your lordship, very smartly, even there,
Smart
PILs
meter.
are filed even before we file our PILs, wherein they don't even have a prayer for an interim prayer is not there. They don't even seek challenge to the tender. And those kind of PILs, for some strange reason, are filed even before the
But
regular
the
persons
pleadings
do.
in this writ petition is identical to pleadings in the PIL. I don't know how is that. Identical
No.
pleadings.
And the
Page
learned
wise,
AG
paragraph wise, prayer wise.
Writ petition
Except the petitioner name, counsel, and everybody is the same.
So,
And the pleadings, and the prayer, and the annexures.
and what is also same is the arguments of the learned AG. Because
Absolutely.
this is the very
Same
same
petition,
thing he
same
mentions
arguments.
over there. He says, this is the same lawyer. So what if it is the same advocate who has appeared? Is he not entitled to sign for two different people when he's dealing with the same matter?
Same
Obviously, parties will go to the person who is dealing with a smart meter. And this is the argument a learned AG has to put forth both in Court Hall 1 and over here. Till now, he's not progressed with what is the defect in the matter. That they will not
Objections
go into.
nodilva?
Objections ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ.
Anyway, lordships
Just
may
given
examine the matter on
Thursday.
merits.
Please.
Yes, but don't go all over, all of you.
No, Manoj.
Smart meter, smart submissions, short ends, yes, bullet points.
But it certainly has far-reaching on every
It does
household.
have, my interim order is so,
Yes,
I have not granted interim order in yours, madam.
There is.
ಎರಡರಲ್ಲೂ ಇದೆಯಲ್ಲ.
Please. And it's also as against even since we've challenged the virus.
The guidelines itself have stayed, I guess.
Please, Your Lordship.
Yes.
ಇದೆ.
ಹೌದಾ?
But
ಅವ್ರ
your
ಕೇಸಲ್ಲಿ
lordship has
ಕೊಟ್ಟೆ.
just mentioned as against petitioner, so that your lordship would have time to even deal with the matter and see the
What's the
records.
interim order?
Query the petitioner.
Query.
Yeah, but it also deals with the challenge.
Guidelines.
Please.
Manoj, when I say that they need not put smart meters, still they want to challenge the guidelines.
No. All petitions need not be examined in that context.
All right.
It's brought to lordships notice, lordships may examine it. On the ground of locus standi, this country, there are thousands of people who cannot approach
That
a
will be
lordship.
considered in PIL.
No, no.
Very
Matter is-
shortly, your lordship, there is a government scheme, central government scheme. Most of the states are adopted. Only 900 rupees is given by the central government itself for that smart meter to be installed. So the only amount that in other states that people would have to pay is on a monthly tariff of about 70 rupees. So that's the only burden to the end
Then what is
consumer.
this 20,000 rupees?
Yes, exactly. So they
It's
don't
not
want to take the central.
ಅಲ್ಲ ಎಷ್ಟು ಚಾರ್ಜ್ ಮಾಡ್ತಾ ಇದೀರ ಒಂದು ಸ್ಮಾರ್ಟ್ ಮೀಟರ್?
5,000 rupees for a single
Manoj,
phase.
I'll be able to show.
8,500 rupees for a 3-phase meter and almost 10,000
Manoj, the
rupees
tenderer
for a
who has lost, my
80
lord,
meter.
this is the argument of the tenderer who is lost, saying that.
That's all right.
No, the.
Now,
question-
in a big house perhaps or whatever, 3-phase meter ಬೇಕಾಗುತ್ತೆ ಈಗ
Yes.
ಎಲ್ಲದಕ್ಕೂ ಬೇಕು.
It's like this.
Whoever is using
It's like
geyser
this.
will necessary a 3-phase
Submission, my
meter.
lord. Existing meter that is 99% of people have built, they need not take it. It's a misconception.
Why do you bring it at all?
We're not bringing it, they're bringing it up by argument. They're not-
ಸ್ಮಾರ್ಟ್ ಮೀಟರ್ ಇಂಪೋಸ್ ಮಾಡ್ತಿರೋದು ಯಾರು?
It is for new connections as per the KRC regulation and.
First we'll show the
No, please, let
regulations
me-
and prove.
That is already produced. Kindly read one KRC regulation, strictly in terms of KRC regulations. And the concession which is been given is given here also. It is not 20,000 or 10, it is 4,500 plus maintenance and what has been given. And we are far cheaper than other states.
No, there.
I'll place it before, it's there before your lordship. So
I have
it's
passed
not-
an interim order with variance with other states and this
I'll place it, my lord. What they have produced on affidavit, I'll place all that. So therefore,
Thursday. Any rejoinder ಇದ್ರೆ ಹಾಕ್ಬಿಡಿ
I'll
ಅಷ್ಟೇ.
check, I'll
We'll
check
finish
that.
it off on
I'll
that day.
check that.
That is 12th, sir. 12th, finish all your work and come at 4 o'clock.
please.
Great.
ಧಾರವಾಡದ ಮೆಟ್ರೋ ತಗೊಳ್ಳಿ. ಎಷ್ಟಿದೆ? ಕೊಡಿ.
230 more matters. Preliminary hearing. Number 1 is Swaroop, yes.
For the petitioner.
ಏನ್ urgency?
I'm a member of the association and illegally they've removed my membership. I'm not able to vote. The election is on Sunday. I had filed a suit before the trial court. Well, trial court, I received an update as of now. Trial court has heard the matter. Vacation court did not grant interim order. Then the notice
one
was
minute.
issued.
Heard the learned counsel appearing for the petitioner. Who is the secretary or president of the association?
My lord, sir, respondent number 2. Respondent number 2 is the president.
Srimati Mansa.
Respondent number 4 is the secretary.
ನೀವು ಯಾರಿಗೆ?
I am for the association, my lord. I just come to know about 10 minutes back of this case, my lord. This matter has been heard in the regular bench. Regular
Division
court,
bench?
Regular court, my lord.
Regular court.
Orders today
Under
it was
636
posted
Which regular court?
before the civil court. Now,
All right.
it was, may I complete? It was filed before the vacation court. Ad interim order was not granted.
You are a
It was
member.
issued. Objections, now the matter has been argued. My lords,
You are
today
a member, right?
I am the member.
You vote.
And I may be permitted to participate in the elections also, my lords.
Voting ಅಷ್ಟೇ.
My lord, now
No
it's
contesting.
now it's posted for order, my lord.
No problem. sir.
ಅಲ್ಲ, ಇವತ್ತು
Sunday
orders
is the election.
What?
Sunday is the election.
Sunday is the election, my lord.
The petitioner is before this court on a frequent situation where the election to the members of the association of the first respondent is slated to be conducted on Sunday, date haki.
8th.
The petitioner is not permitted to participate in the election is the allegation, on which the petitioner has preferred OS 116 of 2025. The matter is set to be heard and reserved for its order.
Is it for orders today?
Today.
Today the judge is on leave, it is
1
posted
minute.
on Monday.
Reserved for orders today. Tomorrow being a government holiday, what remains is the date of election. In that light, I deem it appropriate to permit the petitioner to cast his vote in the ensuing elections to be held on.
My lord.
Wait, sir. To be held, Ashton prestige question. Wait, to be held on Sunday. The vote cast by the petitioner shall be placed in a sealed cover, and the sealed cover shall not be opened without the leave of the court. List the matter on Wednesday in preliminary hearing.
I request, let them participate also
No,
in the
no.
elections, my lords, because they were previous committee
Oh,
members.
no.
They were elected persons this time.
Samale will see. Yes. Next.
Hearing on item number 2, PP Vivekanand.
In terms of
We seek permission to withdraw, my lords.
no provision to withdraw.
No, permission to withdraw.
Permission to withdraw.
Both the matters.
Connected, both the petitions.
Both, yes, sir. Extension of parole.
Number 3.
An offense.
302,
ಎಷ್ಟು ದಿನ
eligible
ಕೊಟ್ಟಿದ್ದು?
for life convict.
Recommend ಆಗಿದೆಯಾ?
My lords, I have passed a detailed order on, recommendation. My lords, I have passed an order.
Page.
It's at page number 12 of IA, my lord. No, page number 7, my lord, sorry. Uploading portion at page number 10.
Same petitioner.
My lord, only because.
Same petitioner.
Same petitioner, my lord. Because one thing we have to appreciate, my lord, the petitioner's daughter topped the PUC in Madikeri district, my lord. She is eligible. She got a seat for medicine.
The extension, no? On the same terms, another 60 days.
My lord, 90 days, my lord.
Because
the thing is,
60 ಆದ್ಮೇಲೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಕ್ಕೆ ಕಷ್ಟ.
Obliged, grateful.
ಧಾರವಾಡದ ಮ್ಯಾಟರ್ ತಗೊಳ್ಳಿ. ಸೆಕೆಂಡ್ ಅಲ್ಲ ಫಸ್ಟ್ ಧಾರವಾಡದ ಮ್ಯಾಟರ್ ತಗೊಂಡ್ಬಿಡಿ.
My lord, tomorrow is that last date to surrender, my lord.
ಇದು will try to get it upload.
Great, so great.
Extension of parole. ಅಲ್ಲ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಇದೆಯಲ್ಲ, ಇಲ್ಲ ಅದು ತಗೊಂಡ್ಬಿಡಿ, ಅದು ಕರೆದು ಬಿಡಿ.
Matters pertaining to Dharwad bench.
ಅದೊಂದು ಮಾತಾಡ್ತಾರೆ, ಮಿಕ್ಕಿದೆಲ್ಲ ಅಡ್ಜರ್ನ್ ಮಾಡಿ 27th Interim order extend ಮಾಡಿ.
My lord, we wanted to withdraw one matter, my lords, in list 2.
Which one, madam?
List 2, my lords, serial number 17, my lords.
Serial number?
17.
In terms of the learned counsel memo ಹಾಕಿದಿರಲ್ಲ, in terms of memo.
Yes, my lords.
Lord, non-compliance first time.
Lord, list number 2.
No, I am not taking any single out of the illa.
Lord, serial number 18.
1 minute, sir. VC, please wait. 2 weeks time is granted to comply with the office objections. In the event they stand complied, the matter shall be listed on the ensuing Monday without any memo being moved at the before this court. Amale second time same 10 days time same order. Third time 1 week same order. Fourth and fifth time 1 week same order. Anybody wanting to withdraw their petitions?
Your lordship on submission. Lordship on submission, your lordship.
Yavadu?
Number 2, list number 2, serial number 26, BWS, same similar order.
Togoli.
Disposal.
Togoli. Same 26. First. You want to withdraw? Ensuing Monday ನೀವು ಕಂಪ್ಲೈ ಮಾಡಿದ್ಮೇಲೆ ತೊಂದರೆ ಇಲ್ಲ, ಬಂದಾಗ ಡೋಂಟ್ ವರಿ, ವಿಲ್ ನಾಟ್ ಹಾರ್ಮ್ ಎನಿ ಮ್ಯಾಟರ್ ಸರ್.
26 serial number.
ಆಯ್ತು ಸರ್, ಅದೇ ಸೇಮ್ ಡಿಸ್ಪೋಸ್.
That election matter interim order may be released at least because election is on Sunday.
Will upload it as a certified copy. I don't know.
Your lordship on submission. Serial number 15, your lordship, list number 2.
Serial number
15, list number 2, your lordship.
ಏನದು?
ಇದರಲ್ಲಿ ನಾನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲ ಕಂಪ್ಲೈ
ಮಂಡೇ
ಕಂಪ್ಲೈ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅದ್ರಲ್ಲಿ ಏನಂದ್ರೆ ಒನ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅಂತ, ಅಲ್ಲಿ ಇನ್ನ ಎಲ್ಲಾರ್ಸ್ ಅಪ್ಲಿಕೇಶನ್ ಅಷ್ಟೇ ಹಾಕಿದಾರೆ ಸ್ವಾಮಿ.
ತೊಂದರೆ ಇಲ್ಲ, ಈಗ ಯಾವತ್ ಮಂಡೇಗೆ ಬರುತ್ತೆ.
ಮಂಡೇಗಿದೆ ಸ್ವಾಮಿ ಅಲ್ಲಿ ಕೇಸ್.
ಈಗ ತಗೊಳಕಾಗುತ್ತೆ?
ಇಲ್ಲ
ಮಂಡೇಗೆ ಬರುತ್ತೆ. ಅದೊಂದು 15 ಮಂಡೇಗೆ ಹಾಕಿ.
List 2, serial number 16, my lordship, I kindly have it on Tuesday, my lord. I'll comply with the objections.
You comply, it will come. Yes.
List number 2, serial number 28, my lord. 1 week time may be granted.
Granted. Yes.
Serial number 13, my lord.
VC, please wait. Yes. List number? Comply ಮಾಡಿ ಬರುತ್ತೆ. Very urgent ಅಂದ್ರೆ ಕಂಪ್ಲೈ ಮಾಡಿ, it will come. Yes. ಯಾವತ್ತಿದೆ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್? We'll see, it will come. You comply, it will come. ಕಂಪ್ಲೈ ತಗೊಳ್ಳಿ, ಫೈಲ್ ಕೊಡಿ. ಎಸ್, ಕಂಪ್ಲೈ ಆದ್ರೆ ಬರುತ್ತೆ ಮಂಡೇ. ಎಸ್, ಈಗ ನಾಳೆ ರಜಾ ಮೇಡಮ್, ಹೆಂಗಾಗುತ್ತೆ? ವಾಟ್ ಇಸ್ ಆಲ್ ದಿಸ್? ಅಲ್ಲಿ ಟೈಮ್ ತಗೊಳ್ಳಿ. ಎಸ್, the trial court is listing something, I can't adjust my time.
Sorry, 15 preliminary hearing ಅಲ್ಲಿ lordship
ಇರದೇ preliminary hearing.
ಇಲ್ಲ ಅದು objection
15 ಅಲ್ವಾ? ಅದು ಹೇಳಿದ್ನಲ್ಲ ಮಂಡೇ ಅಂತ.
ಅದೇ preliminary hearing ಅಲ್ಲಿ
ಕಂಪ್ಲೈ ಮಾಡಿ ಬರುತ್ತೆ, ಅವ್ರದ್ದು ಅಷ್ಟೇ.
ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇನ್ನ ಅಮೆಂಡ್ಮೆಂಟ್
ಆಗಿದ್ರೆ ಬರುತ್ತೆ ಮಂಡೇ.
ಇಲ್ಲ ಅದರಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್
ಆಗಿದ್ರೆ ಮಂಡೇ ಬರುತ್ತೆ ಅಷ್ಟೇ.
ಆದ್ಮೇಲೆ ಮತ್ತೆ 3 ಅಬ್ಜೆಕ್ಷನ್ ತೆಗೆದಿದ್ದಾರೆ. ಟ್ರಯಲ್
ಅದಕ್ಕೆ
ಕೋರ್ಟ್
ಹೋಗಿ ಕಂಪ್ಲೈ ಮಾಡಿ.
ಇಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಪಿಟಿಷನ್ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ, ಬರೀ ಎಲ್ಲಾರ್ಸ್ ಅಪ್ಲಿಕೇಶನ್
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾವ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಅಲ್ಲಿ ಮಂಡ್ಯಾಗಿದೆ ಸ್ವಾಮಿ.
ಟೈಮ್ ತಗೊಳ್ಳಿ.
My lords, list to serial number 22. If it could be listed on Wednesday, my lords, I'll comply with all the office objections.
Comply, sir, it will
My
come.
lords, a
Yes.
warrant was issued against me without sufficient summons being issued to me,
No
without
problem,
appropriate
sir.
summons being issued.
ಏನ್ warrant? Delivery warrant.
How this one?
No problem.
My lords, the issue is appropriate summons was not issued to me, my lords.
We'll see.
The date that was issued to me was a court holiday.
It will come, sir.
Please, my lords, I'll comply with it in the next 2
Comply
days.
with it, sir, it will come. Yes.
Much obliged.
Matters
Taking,
pertaining to that one,
yes. ಅದು ಕೊಡಿ, ಅದು ಕಂಪ್ಲೈ ಆದ್ರೆ ಬರುತ್ತೆ. ಎಸ್, ಈಗ ಮಂಡ್ಯಗೆ ಹಾಕಕ್ಕೂ ಆಗಲ್ಲ ಮೇಡಮ್, ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಮಂಡ್ಯ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ ವಿಲ್ ಟೇಕ್ ಇಟ್. ಎಸ್.
Lords, with permission, may I mention with respect to two advocates matter, my lords, pertaining to Dharwad.
ಅದು ಬಂದಿಲ್ವಾ ಇಲ್ಲಿ?
ಅದು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೆ my lords, ಅದು ಬಂದಿಲ್ಲ. My friend Abhishek Patil is there.
ಅಲ್ಲಿ ಧಾರವಾಡದಲ್ಲಿ ಬಂದಿಲ್ವಾ ಅದು?
ಧಾರವಾಡದಲ್ಲಿ ಇದೆ my lords. It should come before you lordship in Bangalore.
Let's
And
see.
move the memo. My friend Abhishek Patil is there, my lords. He will move the memo with the liberty.
Aye. Yes, take that matter. 27. All other matters on 27th, interim orders which are existing will continue except this further hearing, serial number 20.
Please.
My lord, serial number 18.
ಎಲ್ಲ interim order extend ಮಾಡಿದೀನಿ, separate ಆಗಿ ಮೆನ್ಷನ್ ಮಾಡಬೇಡಿ ಈಗ. Yes.
My lord, urgency due to minor children's admissions, school admissions. Hence the
Which matter, sir?
18th, my lord. Serial number 18 video.
Review petition.
Review petition, my lord.
Sir, yes. 27th, next.
Serial number 20.
My lord, in these all matters, in the petitions by
Where
the
senior counsel ali?
senior is there, my lord.
Indeed, my lord, I am present.
In the petitions by the directors, Mr. Naidu would be submitting, and in the petitions filed by the company, Mr. Nikhil Goyal would be submitting.
All right, whoever starts, let them start.
Great. At least.
Yes, sir.
My lords, I start because I am older.
I don't think Nikhil will dispute and have a problem. Yes.
Absolutely no problem.
Yes.
May I please, my lords? My lords, on 3rd of this month, your lordships reserved a judgment.
Yes, this is because the Supreme Court has directed expeditious disposal. Yes.
Indeed, my lord. Yes, my lord.
Yes.
And on 3rd, your lordships reserved a matter that concerns similar iron ore export, similar
Which is
set of
kinetic.
Yes, my lords. Kenita Global, my lord.
Global or something. What is that?
Yes, my lord. That
Yes,
they purchased on board in the port, and then they have said that when they have committed an offense, and it's been completed. Well, that's why I said and reminded your lordships is for this reason, Mills. When I was waiting for the matter to be heard, I have couple of matters before me was the matter that's with regard to a cat named Daisy. And today, as I was waiting, again that popped out. And Millets, it seems there's been resolved too. Why I said Millets?
So the name of the cat was Daisy in that.
Yes, Millets. A cat named Daisy. Millets, why I said that, the saying goes, a cat has 9 lives. And this case so far has seen 2 lives. And I hope it will be paid to that extent, Millets, because earlier your lordships quashed it. And that was taken in appeal to the, in SLP to the Supreme Court. And there, on a technical ground, it has come back to your lordships.
Yes.
So that your lordships need not write right now anything down. I just will give a thumbnail sketch of the case, Millets. Then I'll take your lordships into the nitty-gritty of the matter.
Yes.
The matter concerns the transport of iron ore.
Yes.
And Millets, the allegation is the iron ore was transported without valid DMG permits. Department of Mine and Geology permits.
Yes.
The offense is said to have attracted, Millets, these sections, Millets. They are section 120B, read with 420, 379, 411, 427.
That's the convenience compilation. Give it, please.
Indeed, Millets. There is one convenience compilation. My lords need not refer to anything else. Everything has been put in that one.
Yes.
That's why, my lords, if your lordships look into that, I'll just give a bird's eye view of the case. Then my lords could go into the aspects such as the charge sheet and witness statements, whether any offense has been made out against the directors, all these things. The offense is said to be, my lords, under sections 120B, read with 420, 379, 411, 427, 447 of IPC. Then, my lords, though not concerned with me, but section 13(2) and 13(1)D of PC Act.
It is against the of public servants.
Indeed, Millets. Besides, Millets, section 21, section 41, 41A and 23 of MMDR Act.
Yes.
And finally, Millets, section 24 of Karnataka Forest Act.
Yes.
Millets, the accused before your lordships are, the first accused is the company, Millets.
Yes.
Accused A2 to A6 are the directors.
Yes.
Millets, of these 5 directors, one is no more. The remaining 4 are there before your lordships for vindication. Millets, in the FIR, my lords could see the gravamen of the allegation at page 36. Straight away, not necessary, Millets. I'm just submitting. It begins at 33, and the allegation contains 36. What it says is this, Millets. And precisely on this reason, it has come back to your lordships. Millets, the allegation is this, Millets, that the company has exported about 3 lakh metric tons, to be precise, 3,135,000 metric tons, Millets. And out of that, Millets, about 1,05,000 metric tons, it mined in its own mine and exported. The remaining, it procured from other suppliers, that is 1,95,000 and odd, and exported. This is what the allegation is, that, Millets. And totally, they began the investigation concerning 3 lakh plus metric tons. Then, Millets, they filed after 9 years the charge sheet, rather 3 charge sheets, Millets, splitting same thing into 3. What they have said is that, Millets, out of these 3 lakh metric tons, whatever I have mined in my own mine and exported, that is, Millets, about 94,000 metric tons, is perfectly legal. Then, Millets, to that extent, it's gone. Then the remaining part, Millets, that is, Millets, of that they have said 1,07,000 metric tons was legally procured and exported. Again, that's gone. There remained, Millets, a balance of 98,000 metric tons. In that one, Millets, vis-a-vis 58,000 metric tons, we are not accused. Charge sheets have been filed, so that also goes. What remains is that, Millets, 39,000 metric tons, and the charge sheet has been filed concerning this in 3 tranches. And my lords initially felt that since it's below 50,000 metric tons, given the direction of the Honorable Supreme Court in the pill way back 2013, Millets, it should have been investigated by the state authorities rather than CBI. Now, Millets, my lords were required to decide the whole issue concerning the offense that's been there. This is how, Millets, the matter has come before your lordships. Now, Millets, I'll take your lordships to the salient.
What did the apex court do?
Yes, Millets. Kindly come to page 1 of the convenient compilation, Millets.
Yes.
My lords could see, Millets. It begins in page 2.
Yes.
In our opinion, the record of proceedings dated so-and-so, postulated few conditions for the Central Bureau of Investigation to register criminal cases. The first condition was that the exporters in question should have been inquired into or the preliminary inquiry. Secondly, they should have exported iron ore of more than 50,000 metric tons without a permit. And thirdly, their name should have been mentioned by the Central Empowered Committee in its report so-and-so. It's pertinent to note that Clause A in the ROP dated so-and-so only related to the initiation of the investigation and inquiry by the CBI. The first information report, which is placed on record, would show that the total quantum that was sought to be investigated in the case, that's so-and-so, is 1,95,000 so-and-so. This exercise would show...
How it was not 1,95,000 because it was split into several transactions and it was less than 50,000.
Precisely 39,000 minutes.
Yes.
Nevertheless, Millets, the lordships have
ಯಾರು
felt that
CBI ಹಾಕಿರೋದ ಇದು ಅಲ್ಲೋಗಿ ಏನೋ ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀರಾ
ಅಲ್ಲಿ ASG ಇದೆ ಹೇಳ್ತಾರೆ ನಾನು.
What ASG? They've gone and told before the Supreme Court something that is not here. Yes.
Millets, may I just continue, Millets?
Yes, sir. Yes.
During the course of the hearing, our attention was drawn to the charge sheet and the language used therein. Our specific attention was drawn to paragraph 15.19 of the charge sheet. The said paragraph in the beginning stated that the investigation had revealed that MSPL Limited and had exported 98,000 metric tons iron ore without valid permits. Out of the said quantity, transactions relating to so-and-so iron ore were found to have been investigated and were covered by other cases registered by law enforcing agencies against others, details of which were mentioned. According to the final charge sheet submitted by CBI was in respect of 39,480 metric tons only. The details of the said exports are mentioned in the charge sheet. In view of the aforesaid discussion, we are of the view that the impugned judgment of the High Court quashing the charge sheet and the investigation by the CBI on account of violation of clause A in the ROP dated so-and-so is unsustainable and contrary to the facts on record. The impugned judgment orders are set aside and the appeals are allowed in the aforesaid terms. We
When
are
the next
informed.
hearing date will be fixed. All right. Yes.
Millets.
Yes,
We
sir.
are informed on. This is how, Millets, it's come back to your lordships. The factual inaccuracies apart.
No.
Now,
But do you accept that it is factually incorrect that all the transactions are put together and what is projected is 1,95,000 metric tons, while every transaction was less than 50,000 metric tons?
Not only that, Millets, the entire allegation is confined to 39.
Yes,
I am
39,000 metric tons.
I am an accused only in that one, nothing else.
Yes.
May I continue, Millets?
Yes, sir.
My lords could see, Millets, FIR at 33.
Yes.
Millets, at this stage, with humility, let me say, Millets, when it comes to Justice Jackson's statement, infallibility, I'll just proceed.
Yes, sir.
May I proceed, Millets? Kindly
sir.
come to page 33.
30?
3.
Yes, sir.
Millets, that's the FIR.
Yes.
Dated 24/10/2013. That was
Yes.
based on the Supreme Court judgment, which could be found at page 7. That need not be referred to.
Yes.
Now, my lords may kindly come to page 33.
Yes.
Here, the offense, the details, and all these things, Millets. And the next page at 34, my lords could see the company and the directors arrayed as accused.
Yes.
Then, Millets, kindly come to 35, the narrative part.
Yes.
Eventually, kindly see Millets, page 36.
Hmm.
The third paragraph, Millets, only 2 paragraphs
Yes.
that contain the whole gravamen of the allegation. Measures
Yes.
MSPL Limited, represented by its director A22A6, illegally excavated iron ore in excess from the mine leased to them and illegally procured from various suppliers and exported so-and-so, so-and-so. Represented by its directors, obtained the excess ore by stealing the natural resources in the form of iron ore by excavation without valid authority, by trespassing on the forest area, government land, procuring such illegality, excavated iron ore and receiving so-and-so, so-and-so. Millets, it may not be required to be read because everything they say in the charge sheet is incorrect. And
Yes.
finally, Millet, they have said in the last paragraph, the above acts on the part of so-and-so and its director so-and-so and unknown public servants and unknown others disclose commission of offense on the following offenses. This is how,
Yes.
Millets, the whole thing has begun. Now, my lords may kindly after 9 years, on 1st February 2022, they filed the charge sheet. My lords may kindly straight away come to page 38.
Yes.
This is where, Millets, the charge sheet begins. And I'll just take your lordships to the salient part of that aspect, Millets, in the charge sheet. One moment, Millets. Kindly come to page 39. This is where the accused all would be mentioned. And 57 is the brief facts of the case.
15.22 is where your name is found.
Exactly, Millets. I'm coming to that.
Yes.
Straight away, kindly come to Millets. 58.
Page 66.
Actually, Millets, it 57. I may.
Yes. Oh, all right.
57 minutes, para 15.2.
15.2. Yes, yes.
As requested, the Honorable Supreme Court of India, with its order dated so-and-so, permitted the CBI to register criminal cases against the exporters who were inquired into during the said preliminary inquiry and who had exported iron ore of more than 50,000 metric tons without valid permits. Now, Millets, it begins. In the inquiry report, so-and-so has also figured as one of the exporters which exported 3,135 metric tons of iron ore without valid permits, and accordingly a case has been registered against A1 represented by its directors A2 so-and-so directors A6 so-and-so and unknown public servants. The next page, Millets. Kindly come to 15.3, Millets.
Yes.
The brief allegation of the case in the FIR is that they repeat the FIR allegations, Millets.
Yes.
Kindly see Miller's fourth line. It's further alleged in the FIR that during the period from so-and-so, A2 to A6 directors of A1 company had illegally excavated iron ore in excess from the mine, so-and-so, 3 lakh so-and-so. This is all, Millets, the allegations that contain. They may not detain your lordships longer because, Millets, they've come later. Kindly come, Millets, page 61. Page 61, the last line.
Yes.
Further, Measures MSPL also procured iron ore from Amalgiris and Priyanka agencies, who in turn procured from various suppliers from outside and inside the port and thereafter supplied to so. This is the one that I've been accused of, only part of it though. That means these two suppliers, they have procured from various other sources, they have brought it into the port and they have sold it to me. Now, Millets, how it unfolds, my lords may kindly come. Page 64. This is the heart of my old submission, Millets. Kindly come to page 64.
Yes.
There is a table.
So this is the calculation, 39,480 metric tons.
Yes, Millets. Kindly come to the bottom, Millets.
Yes.
Total quantity procured, my lords could see.
Yes.
Then below that, item 10.
Export of iron ore legal. Own mines. Legal,
Indeed, Millets,
107. Balance illegal. No,
yes.
Balance illegal 98,080. Cases already charge sheeted for illegal 58,600. Balance remaining 39,400.
Precisely, Millets. When it comes to these 58,600 metric tons, I'm not an accused.
Yes.
And Millets, the other one, that is 39,480, I am an accused.
So you are accused only of 39,480 metric tons.
Indeed, Millets.
Yes.
May I take your lordships further, Millets? Kindly come to the next page, Millets. Page 65.
Yes.
These are the exports I've made and the vessel details have been given. Kindly see Millets 3 and 4.
Yes.
These are the vessels that concern this 39,000. Then, my lords may kindly come down 2 Millets. Page 68.
Yes.
Now, Millets.
68.
Beg your lordship, 68. 68.
Yes.
Kindly come to Millets 15.23.
Yes.
Investigation revealed that so-and-so has procured so-and-so iron ore from various parties suppliers during 1/1/2009 to 31/5/2010 without valid DMG permits, trip sheets, and exported the same through Bellekeri port along with the iron ore legally procured from various suppliers as discussed above. The details of iron ore illegally procured so-and-so, Millets. Now, my lords may kindly come, Millets. Then they have stated the whole figure. Now, finally, come to 70, Millets.
Yes.
70. Yes, Millets, 70. Here, my lords could see the vessels' names.
Yes.
The table is there. Vessel name. There, Millets. Illegal quantity pertains to so-and-so.
39,481.
Yes, Millets. 27,186. Regarding this, Millets, they have filed 2 charge sheets, splitting that. And the next vessel, my lords could see 12,295, 1 charge sheet. Again, totally it comes to 39,481. My lords, I may just bring your lordship's attention to para 15.25.
Yes, I'm there.
Investigation revealed that under shipment so-and-so, represented by its director, exported iron ore to China to the tune of so-and-so, out of which so-and-so was found to be illegal. That is 27,186. That my lords could see in the table, Millets.
Yes.
There are 6 transactions where the illegal quantity of 27,186 metric tons was supplied by Messrs. Amalgiris, that's A8, a partnership firm
Yes.
represented by its managing partner, so-and-so,
Yes.
that's A7, on port. My lords may kindly take judicial note of this, Millets, on port through 6 different suppliers.
Yes.
Millets, very eighth respondent itself purchased that on the port.
Yes.
And from 6 suppliers. It's a cascading effect of domino, Millets. 6 suppliers.
Yes.
And then they sold it to us, is the one, Millets. Then, Millets, they have given the details of the suppliers. We need not bother ourselves with that one, Millets. Kindly come, Millets. They have given the details
Yes.
at 15.33, the permits, etc., which we have, my lords, make just kindly see, Millets. Investigation revealed that after supply of iron ore as required under purchase order to submit MDPs for the supplied quantity, so-and-so, submitted the details of along with invoice number so-and-so, so-and-so. These are the details that have been there. Ostensibly, they have supplied everything to me and they have done it. Millets, now 76.
Yes.
15.40 minutes.
Yes.
Investigation revealed that A7, managing partner of A8, procured iron ore from various suppliers. That's A9, A12, A13, A14, A15, through brokers A10, A11, 11, and Millets A16, 17, 18, without valid DMG permit receipts and supplied to MSPL. Millets may kindly mark this one, Millets. He procured
Yes.
that on port from all these people without valid permits according to the prosecution, and he has supplied that to me. It will have the echo
Yes.
of Kineto Global Millets. Now, my lords may kindly come to 77. Para 15.41. Investigation revealed that Amalgari is represented by so-and-so, all names apart, Millets, have not obtained any mining lease from iron ore or stockyard permission for transportation of iron ore to Bellekeri port from DMG Hospet, and no royalty was collected from them by DMG Hospet as intimated within their letter so-and-so. Hence, the iron ore supplied by the said suppliers to MSPL through Amalgiris are illegal. Millets, what's been
Yes.
happening here is they supply to Amalgiris. It's a completed transaction. And then, Millets, they've supplied to me. Whatever the documents he has had, Millets, I will take your lordships to invoices and other things where I've said squarely all the documents you should produce, and it's your responsibility. You should satisfy the authorities. You should bring that into the port. Once it is there, after passing every muster, then I will take it. That's how, Millets, I've done. Kindly come, Millets. 15.42. This is the gravamen where they talk about
15.46 and 47.
May I go to that one, Millets?
No, that is where it is found against you
Yes,
again.
Millets.
Yes.
I'm coming to that one, Millets. 15.46 at page number
And
78.
47.
Yes, Millets.
Yes. Page
Investigation
78 and 79.
Yes, Millets. May I read, Millets?
Yes, sir.
Since my lords have already
Yes.
given a reading, I just will
Yes,
have to
sir.
go through the questions. Investigation revealed that it's the responsibility of so-and-so who purchased so-and-so 7,945 metric tons of iron ore without DMG permits from various suppliers. That's A8 and others on board at Bellekeri's port to verify the
Yes.
records and ascertain the genuineness whether the supplier so-and-so,
Yes.
traders so-and-so. Millets, before this, may I read a wonderful sentence just above that? 15.45. 15.45.
Yes.
Because that will have a
During
punchline. During
Yes.
investigation, the role of public servant was not surfaced in this criminal act. The lapses on the part of public servants are of common in nature and used to be looked into ground realities. An offense can be condoned if they are officials.
So they are all let off?
Yes, my lords. Though I am unsuspecting and I'm a bona fide purchaser, I've had every document that's been supplied to the extent, my lords, we have had all the statements of witnesses who have said what are the documents that are required, who are the authorities that check.
Ground reality is that those public servants should be first prosecuted.
They have been made accused in the extraction case, not in the transportation.
Without public servants connivance, you can't do anything. Yes.
Yeah, I'm not defending the public servants. Let's.
Yes, sir.
But they defend it on record, my lords, though.
So this is you're representing the company.
I'm representing the directors, my lords. My friend.
Directors.
I represent the company.
Who's representing the company?
I represent the company.
Then we will, sir, can we hear
Yes,
Nikhil?
Indeed,
Yes.
my lords.
Yes. Nikhil, right? What's his name?
Yes, my lords.
Nikhil, Mr.
Yes.
Nikhil Goyal, Senior Counsel, my
Yes.
lords, from Supreme Court.
Senior counsel. Okay.
Yes, my lords.
I was hoping that Mr. Naidu will finish, Lord, but I can take you through, Lord, to 4 or 5 issues, Lord, which I have flagged.
Yes.
Lord, my learned colleague has shown you, Lord, substantial part of the charge sheet. Since we are in quashing jurisdiction, Lords, all we can show
Yes.
today is the charge sheet to your Lordships.
Yes.
Lord, some parts of charge sheet, Lord, I would like to show in addition to what has been shown to my Lords, my Lords.
Yes.
Would your Lordship, Lords, permit me to show, Lord, I'll refer from paragraph numbers.
It's not stable, I guess. Your network is not stable. Voice breaking.
Oh, I see. Is it better now, my Lords?
No. You continue. We'll see. Yes.
That's where in different parts of the world, thanks to vacation in Supreme Court.
Oh, see. That's the reason. Okay.
Yes, my lords. Both of us guilty of that one.
Both
But
of you are outside.
Yes, my lords.
Both of you are outside.
Yes.
Yeah, in
Yes,
different
yes,
parts,
my Lord.
not at one place.
All right. But if you can appear here, it will be great.
My lords, we are always willing, my lords. It's a pleasure.
Physically, if you are appearing here on any
Yes,
day,
my lords,
it would
may
be
I pray,
fine.
my lords? May I pray, my lords? 13th?
13th is half day here. That's the a little problem.
Then, my lords, the immediate to our next working day, my lords, that could be 16th.
16th or 17th, whenever you want.
My lords, I'm your lordship's
Even-
hand. 16th, I am
even,
willing because we are all free. So that we'll have the
Nikhil
pleasure.
Nikhil sir is also free on that day?
Lord, whatever date
Seven-
suits Mr. Naidu, Lord, I'll follow course.
No, sir, we'll fix it on 17th, Tuesday.
So be it, my lords. We'll be there very much.
Yes. Tuesday, you'll be coming here.
Indeed, my
I'll
lords.
take
We are
it at
coming.
two, I'll take it at 2:30.
2:30, my lords, on 17th.
Yes. On 17th, 2:30.
My lords.
I would also be personally delighted to have Naidu sir. We both come from the same place.
Happy to hear that one, my lords. And in my lords,
That
in
would
fact,
that would not absolve him of getting ready on the next date.
yes, my lords. My lords, we'll continue
both
where
come
we
from
are.
Chittoor. I've been seeing him from my childhood.
Yes, yes, yes.
Grateful,
Yes,
my
sir.
lords.
So
We'll
we'll
continue.
fix it on. No, because Nikhil sir's network is a little shaky.
Yes.
So we'll take it on 17th.
17th.
17th Tuesday at 2:30 p.m.
Grateful, my lords,
17th
for the
Tuesday at 2:30 p.m. Heard
Yes.
the learned senior counsel Sri Dama Sheshadri Naidu appearing for few of the petitioners and the learned senior counsel Sri Nikhil Goyal representing the company, the accused number 1, to hear them further list the matter on at 2:30 p.m. on 17th for further hearing.
May I make a
Great.
request? Our presence may also be marked since this is
Sorry,
a batch matter.
1 minute. The learned counsel, ನಿಮ್ಮ ಹೆಸರು ಹಾಕ್ಲಾ ಅವರ? Learned counsel Rahul S. Reddy appearing for the CBI ಅಂತ ಒಟ್ಟಿಗೆ ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ 17th. 60. ಹಾ, ಏನ್ ಬೇಕು?
We have already filed the wakalat for respondent number 5 and we have also already filed a statement of objections.
ಏನ್ ಅರ್ಜೆನ್ಸಿ? Urgency idea. Review petition. ಯಾವ್ದು cooperative society da?
The matter pertains to the handicapped persons, allocation of shops to handicapped persons.
What is review in that? Who has filed review? Darigonda. We'll see. We'll repeat them on the next date. What's your name? Who has filed wakalat?
Srinande Pachapuri.
Srinath Pachapuri. I will notice it. Yes.
Let's say a date may be fixed.
All on a particular day, 27th. Yes.
Let's kindly have it on next Friday.
Next Friday is half day. I'm telling you, it's difficult. Yes.
20th.
20th is already full. Gautam, where were you?
My legs in.
When it is surrogacy, you should be here.
Could I only request for item 18, for 18th instead of 19th? 18th could I?
18th hakiradu.
18th could I request for it? Only one.
You tell, I think Sadhna madam. Yes. Yes.
Girish, serial number 21.
Objection hakalva?
Mallards, please, Mallards, it's under the process, Mallards. And the department is intending to avail the services of ASJ, Mallards. So it's under process, Mallards. Kindly place out 3 weeks time, Mallards. It may be conducted on first.
6 months.
Requesting for a short date in the.
Please, Mallards, I understand, Mallards. Since the notification is being challenged, Mallards.
This one, no 3 weeks, sir. I will take it on 17th hakiradala. We'll take it on 18th, finally. Whatever you want to do, can do by then. Yes.
Seal number 20.
Mallards,
21.
Mallards,
Harvard list 21.
another 1 week accommodation, Mallards.
Madam,